May please, madam.
Wait. Fresh matters ಎಲ್ಲ ಕೊಡಿ. Only on Tuesday. Monday is a holiday. Sorry, Republic Day. Yes.
Lord,
Give it. If you want to give it, give it.
One matter.
Wait, mentioning wait. Fresh matters ಎಲ್ಲ ಕೊಟ್ಬಿಡಿ. Tuesday, according to seniority and the limit.
madam.
Why? All of you still standing? Pending matters also you give. According to seniority, it will come on the designated days. Give it.
With my,
Give it, sir. Vacating entry moderate, adu kodi. Give all the pending memos.
my,
Give all the pending memos, sir.
Settlement ಗೆ ಸ್ವಾಮಿ 230.
Settlement ಗೆ ಯಾವತ್ತು ಬೇಕು ಕೊಟ್ಬಿಡಿ, ಬರೆದು ಕೊಡಿ.
230.
Whenever you want, settlement will take it.
my lords, there is a
Settlement ಎಲ್ಲ ಕೊಟ್ಬಿಡಿ. Give it, sir. No problem, sir. Give it.
lords, one humble submission.
No, sir. It will come according to seniority. Give it.
Lords, one
No,
submission.
sir. Give it.
Madam,
Pending matters will come according to seniority on the designated days. Please give it. ಇದೊಂದು ಇಂಟರ್ವ್ಯೂ ಮುಗಿದು ಬಿಟ್ರೆ ಐ ವಿಲ್ ಟೇಕ್ ಎವ್ರಿಥಿಂಗ್ ಆಮೇಲೆ 1st February ಇಂದ ವಿಲ್ ಟೇಕ್ ಎವ್ರಿಥಿಂಗ್. ಮೇ ಬಿ ಸರ್, ಏನಾದ್ರೂ ಇರಲಿ ಕೊಡಿ ಸರ್, ಪರವಾಗಿಲ್ಲ ಸರ್, ಏನ್ ಮಾಡಕ್ಕಾಗಲ್ಲ ಕೊಡಿ. ನೋ ಸರ್, ಯು ಶುಡ್ ಹ್ಯಾವ್ ಟೇಕನ್ ಸ್ಟೇ 1 year ಇಂದ ಯಾಕೆ ತಗೊಂಡಿಲ್ಲ? ಅದು ಅವಾಗ ಬೆಂಚ್ ಇತ್ತಲ್ಲ, ಯಾಕೆ ತಗೊಳ್ಳಿಲ್ಲ? ಹಾ ಕೊಡಿ. ನಥಿಂಗ್ according to seniority, pending matters, give it.
Reporting settlement.
Settlement whenever you want, please give, sir. Fresh matter ತಾನೆ ಬರುತ್ತೆ ಕೊಡಿ. ಏನು ಯಾಕೆ 1 ವರ್ಷದಿಂದ ಮಾಡಿಲ್ಲ ಸರ್? 1 ವರ್ಷದಿಂದ ಯಾಕೆ ಮೂವ್ ಮಾಡಿಲ್ಲ? ಪರವಾಗಿಲ್ಲ ಕೊಡಿ. ಎಲ್ಲ ಅಂತಪ್ಪಲ್ಲ ಕೊಡಿ. ನಾನು ಅಕಾರ್ಡಿಂಗ್ ಟು ಮೈ ಡೇ ಐ ವಿಲ್ ಡೂ ಇಟ್. ಗಿವ್ ಇಟ್ ಸರ್. ಮೇ ಬಿ ಕೊ ಸರ್, ಗಿವ್ ಇಟ್. ಪೆಂಡಿಂಗ್ ಮ್ಯಾಟರ್ ಎಲ್ಲ ಕೊಡಿ, ಪರವಾಗಿಲ್ಲ ಕೊಡಿ ಸರ್. ವಾಟ್ ಎವರ್ ಇಟ್ ಇಸ್, ವಿಲ್ ಟೇಕ್ ಇಟ್ ಸರ್, ಪರವಾಗಿಲ್ಲ. ಎಸ್, ಗಿವ್ ಇಟ್. ಕೊಡಿ ಸರ್. ಎಸ್. ವೈ for what? Which 138? Kodi 230. Kodi.
my lords at 2:30.
1 minute. Sorry. Yes. Bail ತಗೊಂಡಿಲ್ವಾ? ತಗೊಂಡು ಕೊಡಿ. Tuesday. No sir. Give it. All fresh matters Tuesday. Yes.
This is actually a family matter.
Maybe fresh or pending, sir.
Pending.
Give it.
The child is not going to school since last.
Give it, sir. No problem, sir. Give it. Can't help, sir. Give it, sir. We'll see. Who has stayed it? Give it.
Yes. One more, sorry to make another memo submission. This is a dated matter.
Who has given the date? Give it. Give it. Yes. Give it, sir. Sorry? Who had assigned the date? Who has assigned the date? Give it, sir. Yes. It will come according to the designated days of this court. Yes. Give it.
Lords, one submission, my lords. At 2:30.
Give, sir.
2:30, my lords.
230 ಯಾಕೆ ಸರ್? ಪೆಂಡಿಂಗ್ ಮ್ಯಾಟರ್ಸ್ ಎಲ್ಲ ಕೊಟ್ಬಿಡಿ.
My lords, there is a civil dispute between the parties.
Date is given yesterday, your lordship. The stay is extraordinary.
ನೆನ್ನೆ ಡೇಟ್ ಕೊಟ್ಟಿದೀವ. ಯಾರು ಕೊಟ್ಟಿದ್ದು ಡೇಟ್? ಕೊಡಿ. ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಆಫ್ ಹಿಯರಿಂಗ್ ಅಂದ್ರೆ ಅದು ಬಂದಾಗ ಮಾತ್ರ, ಡೋಂಟ್ ವರಿ. ಏನ್ ತೊಂದರೆ ಇಲ್ಲ ಸರ್, ಕೊಡಿ. ಎಷ್ಟು ವಾರ ಕೊಟ್ಟಿದ್ರು ಅಷ್ಟೇ?
4 weeks.
ವೀಕ್ಸ್ ಕೊಟ್ಟಿದ್ರೆ ಕೊಡಿ, ಅದು ನಾಳೆಗೆ ಹಾಕಿ ಮೇಡಮ್, ಎಕ್ಸ್ಟೆನ್ಷನ್ ಆಫ್ ಎಂಟ್ರಿ ಮಾಡಿ. ಬೇಲ್ ತಗೊಳ್ಳಿ. ನಾನು ಬೇಲ್ ಕೊಡಲ್ಲ.
Lords,
Give it,
lords
give
at
it.
2:30, my lords.
Don't convert 480 to bail court, sir.
Lords,
Tuesday. ತೊಂದ್ರೆ ಇಲ್ಲ, ಅಲ್ಲಿಂದ ಇಲ್ಲಿವರೆಗೆ ಏನ್ ಮಾಡ್ತಾರೆ? ಟ್ಯೂಸ್ಡೇ ಕೊಡಿ. ನೆಕ್ಸ್ಟ್ ಕೊಡಿ.
lords at,
ಕೊಡಿ ಸರ್. ಪೆಂಡಿಂಗ್ ಮ್ಯಾಟ್ರಾ? ಪರವಾಗಿಲ್ಲ.
lords at 2:30, my lords.
ಎಲ್ಲ ಕೊಡಿ. I am not going to budge according to your convenience. Designated days ಅಲ್ಲಿ it will come. ಅಷ್ಟೇ ಕೊಡಿ.
Lords at 2:30, my lords.
Will you wait, please? ನಾನೇನ್ ಮಾಡಕ್ಕ 26 ನವೆಂಬರ್ ಹಾಕಿರೋದು ಈಗೇನ್ ಪ್ರಾಬ್ಲಮ್ ಇದೆ ಕೊಡಿ. ನೋ ಪ್ರಾಬ್ಲಮ್, ನೋ ಪ್ರಾಬ್ಲಮ್, ಗಿವ್ ಇಟ್. ಇಟ್ ವಿಲ್ ಕಮ್ ಆನ್ ಡೆಸಿಗ್ನೇಟೆಡ್ ಡೇಸ್ ಸರ್. ಕೊಡಿ, ಎಲ್ಲರದ್ದು ಕೊಟ್ಬಿಡಿ ಮೆಮೊ. ಗಿವ್ ದ ಮೆಮೋಸ್ ಸರ್. Give the memos, please. I have to start proceedings. Give the memos.
My lords, at 2:30, my
Give,
lords.
2:30 is wait ಮಾಡಿ ಒಂದು ನಿಮಿಷ. Give the memos. Give all the memos.
Your Lordship, for
Pending
tomorrow-
matters ಎಲ್ಲ ಮೆಮೊ ಕೊಡಿ.
Your Lordship, fresh matter for tomorrow,
Wait.
the parties.
Give all the memos.
Your Lordship,
You are not giving the memo? Leave it. Yes, give the memos. Yes.
this is the
Jaga
fresh
ಇಲ್ಲ.
matter, my Lordship.
Fresh matters ಎಲ್ಲ on Tuesday again. Give it.
Your Lordship, it is posted for charges tomorrow, my Lordship. Sanction.
For framing of charges.
Yes, my Lordship.
Why, what are you doing till now?
Your Lordship, file ಮಾಡಿದ್ದೆ.
ಅಲ್ಲ ಇಲ್ಲಿವರೆಗೆ ಏನ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ ಚಾರ್ಜ್ ಫ್ರೇಮ್ ಆಗೋವರೆಗೂ?
Sanction without sanction.
ಪರವಾಗಿಲ್ಲ. Yes.
Cognizance
We'll
has
see.
been taken.
Oh, you a long time back. Leave it. Yes. Give it.
My lord, 7 AM at 20.
ಪರವಾಗಿಲ್ಲ ಕೊಡಿ, ಎಲ್ಲ ಕೊಡಿ.
ಮಲಟ್ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ ಇದು.
7 ಮ್ಯಾಟರ್ಸ್ ಎಲ್ಲ 31ಕ್ಕೆ ಬರುತ್ತೆ ಕೊಡಿ.
ಮಲಟ್
Sorry?
Submission.
4 times. What 4 times? Even if you move 100 times, I am not bothered. Give it. It will come according to designated days. Give it. Give it, sir. Give it, sir. Yes. ಕೊಡಿ ಸರ್. ಫ್ರೆಶ್ ಎಲ್ಲ ಮೆಮೊಗಳು ಕೊಟ್ಬಿಡಿ. ಫ್ರೆಶ್ ಪೆಂಡಿಂಗ್ ಎಲ್ಲ. What delivered? What has happened? All right, 2:30 ಕೊಡಿ. Yes. Very good, sir. Tuesday. ಏನ್ ಪರವಾಗಿಲ್ಲ. Give it. No, sir.
Your Lordship,
All fresh matters on Tuesday ಕೊಡಿ. Pending matters on the designated days. Please give it. ಯಾರು ಕೊಟ್ಟಿದ್ದು ಡೇಟ್ಸ್? ಕೊಡಿ ಸರ್, ತೊಂದರೆ ಇಲ್ಲ, ಬರುತ್ತೆ ಕೊಡಿ ಸರ್. No, sir. No, sir. 420, 840, nothing. Give it. Yes. It will come, sir. Fresh matter ಅವತ್ತಿನ ದಿನ ಬರುತ್ತೆ.
2:30, my lords.
Why?
My lords, there is a civil dispute pending between.
ಬೇಲ್
parties.
ತಗೊಂಡಿದ್ದೀರಾ?
My lords, section
ಬೇಲ್
1
ತಗೊಂಡಿದ್ದೀರಾ ಇಲ್ವಾ?
My lords, bail, I have
Bail
applied for-
ತಗೊಂಡಿದ್ದೀರಾ
I
ಇಲ್ಲ?
have applied for bail. My lords, one humble submission, my lords. My lords, the first informant's mother died out of heart attack, my lords, but the police have invoked section 108, my lords. 2:30, my lords. Kindly,
No,
my lords.
2:30, sir. Give it. Yes.
There is civil
Take
dispute
bail,
between-
take
but-
bail.
And also Atrocities Act, my
Take
lords.
bail, sir.
My lords, I have applied, my lords. Kindly, my lords, there is,
Give it.
my lords, there is urgency, my lords. Kindly, my lords, at 2:30.
ಆದ್ರೆ ರಾಜೇಂದ್ರ ರೆಡ್ಡಿ ಅವರು ತಗೋಬೇಕು ಅವಾಗ.
My lords, they have invoked section 108 for suicide, my lords. Please, my lords.
All right, give it.
ಅಲ್ಲ, ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲೇ ಹೇಳ್ತಾರೆ ಸ್ವಾಮಿ.
FR ನಂಬರ್
Yes, my lords.
ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ ಕಂಪ್ಲೈ ಮಾಡಿ ಹೋಗಿ.
I comply ಆಗಿದೆ.
ಕೊಡಿ. Day after tomorrow.
2:30.
No, 2:30. Give it. No, sir. Nothing. Take bail. Yes. Take bail, sir.
2:30.
Why?
There is a order of the magistrate to release amounts that are alleged to be part of cybercrime without issuance of notice to the account holder.
You are the account holder?
Yes, your lord.
All right, give it. 2:30.
ಫಾರ್ ಸಬ್ಮಿಷನ್ ಮಲಟ್. ಮ್ಯಾಟರ್ ಇಸ್ ಪೋಸ್ಟೆಡ್ ಫಾರ್ 313 ಸ್ಟೇಟ್ಮೆಂಟ್. ಇಲ್ಲಿ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್.
ಇಲ್ಲಿವರೆಗೆ ಏನ್ ಮಾಡ್ತಾ ಇದ್ದೀರಿ ಸರ್? 313 ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಂದ್ರೆ ಎವಿಡೆನ್ಸ್ ಸ್ಟಾರ್ಟ್ ಆಗಿದೆ. No, nothing doing. Yes.
ರಿಜೆಕ್ಟೆಡ್ ಮೈ ಲಾರ್ಡ್.
Fresh matter?
Yes, my lord.
No, sir. Not taking. Yes.
125 counter matter.
It's pending, right? Pending.
Counter case.
ಕೊಡಿ ಸರ್. ಪೆಂಡಿಂಗ್ ಫ್ರೆಶ್
Fresh matter.
ಕೊಡಿ.
My lord, because
My lord, 120.
ಸೆಟಲ್ಮೆಂಟ್ ತಗೊಳ್ಳಿ ಯಾವತ್ ಬೇಕಾದ್ರೆ.
125 ಇವಾಗ ಇನ್ನೊಂದು counter case ಗೊತ್ತಾಗಿದೆ.
my lord, because of ego clash between the jurisdiction.
Whatever it,
and,
fresh or pending,
Fresh, my lord.
give it.
3 different FIR false.
No problem, sir. Give it, sir. Yes. All next. All
No,
fresh
one
matters
matter,
on Tuesday only. Please give it.
Tomorrow, my lord.
No tomorrow, no day after tomorrow. Give it.
If it is citizen, senior citizen, my lord.
Whatever it is on Tuesday. Give it.
138 act, my lord.
138.
Yes, madam.
Can arrest ಆಗ್ತೀರಾ?
I call, we issue NBW, I arrest the petition.
Very
my lord.
good, sir.
The petition number 2, my lord, they issue the personal check, not the firm, not check to
it.
company, my lord.
No problem, sir. Give it.
Kindly, tomorrow.
No,
my
no,
lord.
sir.
But senior
ಎಲ್ಲ
citizen,
Tuesday, nothing.
he was admitted in the hospital, madam.
ಅಲ್ಲೇ ಇರಕ್ಕೆ. Yes, Tuesday.
Same tomorrow, my lord.
No.
For framing of charges 17th, sir.
No problem, sir. ಕೊಡಿ. ಇಲ್ಲಿವರೆಗೆ ಏನ್ ಮಾಡ್ತಾ ಇದ್ರಿ? Tuesday ಕೊಡಿ.
Breach of promise to marriage, my lord.
Tomorrow.
No, sir.
Passport is not
No,
renewed.
sir. What was your client
Monday
doing
is for-
till the matter went to framing of charges?
For posted for charging of the frame.
What was your client doing till
Filed,
now,
your
sir?
lordship. Filed and complied.
Sir,
Date
what-
has been given, not listed.
answer the question. What was your client doing till now, till the matter went to framing of charges? He was sleeping? ಇಲ್ಲ ತಾನೆ? Give it. Monday, yes.
My lord, breach of promise to marriage, my lord.
Give it,
Passport
sir.
is not renewed, my lord.
ಕೊಡಿ, sir.
That's right. Day after tomorrow, or
It is 10:15. Please give all the memos. I am not taking any other matter for 2:30. Give it. Yes.
Sorry, my lord, may
Give it, sir. Give everything.
Humble submission, my lord.
Give every settlement you want, please give it.
may please.
Madam, settlements ಎಲ್ಲ ಮುಂಚೆನೆ ತಗೊಂಬಿಡಿ. Please give the memos for settlements earlier before I come.
My lords, one humble submission, my lords.
ಯಾವ್ದು ಇಲ್ಲ. Day after tomorrow ಕೊಡಿ.
My lord, mental illness.
My lord.
Of mental illness. my lord.
No problem, give it.
At the time of incident.
No problem, give it.
Judicial custody.
Pending.
My lord.
Bail ತಗೊಳ್ಳಿ.
My lords.
Please, my lord,
Give it, sir.
matter pertaining to,
Give it.
Jail time will, my lord.
Call the cases, madam.
please,
My
madam,
lord.
one submission, please.
Want to give the memos, please give the memos.
madam. Matter pertaining to misuse of a minor girl to plant a POCSO case against some innocent persons, please, my lord.
Oh, yes.
That, my lord, this Chikkaballapur mat, where there is a CCTV footage which depict that, my lord, on the date of occurrence, the victim girl was in the school premises, please, my lord. The matter requires,
Pending or fresh?
no, fresh matter, please, my lord. It requires immediate intervention at the hands of this honorable court.
Not-
CCTV footage shows that, please, my lord, the victim was in the school, not in the scene of occurrence, please, my
No
lord.
problem.
This is not being
ಎಲ್ಲ
conducted.
Tuesday, give it, yes.
May please,
My lord,
kindly
vacating
have
stay,
it
my lord.
tomorrow at least, please,
Vacating
my
stay
lord.
ಕೊಡಿ.
Vacating stay.
ಯಾವ್ದಿದೆ vacating stay?
My lord.
Bank
the
employees
prosec-
on the rated
Vacating
beneficiaries.
stay ಇದೆಯಾ?
Yes, sir.
ಕೊಡಿ. Madam, ಅದು vacating stay ಹಾಕಿ ಯಾವ ವರ್ಷದ ಅದು?
2024, my lord.
Madam, vacating
Sorry,
stay
my lord,
ನಾಳೆ
by
ಹಾಕಿ.
suppressing this fact, my lord, he has obtained an order, please, my lord. Therefore,
Give
it
it.
requires,
You're for the complainant.
no, I am for the accused, please, my lord. Case and counter case, please, my lord.
Please give it, sir.
Oblige, my lord, oblige.
My lord, the prosecution has filed
Obliged.
an application. I have
Yes,
challenged that
call the
application,
cases,
my lord.
If you want to give the memos, please give them.
My lord,
One request
matter is
for tomorrow.
posted for evidence, my lord.
Yes, Nirupan Gowda,
That's one request for tomorrow, my lord.
please give. No tomorrow, sir. Give it, yes.
That's visa interview, my lord, says
Who is
scheduled
appearing
day
with the
after
petitioner?
tomorrow.
Ah, yes,
Can
sir.
this
Come,
be
come.
taken day after tomorrow?
Come, give the memos, sir.
My lord, 2:30, my lord.
Give the memos, please. No 2:30, give it.
Lord, accused is day after tomorrow, my lord. Conditions of the appellate court, my lord. My lord,
No problem, sir. Give it.
mental,
Fresh matter. Give it.
my lord, mental
Yes,
illness,
it's a
my lord.
fresh matter.
Give it, sir.
Lord,
No problem.
2:30,
Give it.
my lord.
No,
It's a
2:30,
fresh
give it.
matter.
Nothing doing.
My lord,
Yes.
at least tomorrow, my lord, she's
No, sir.
mentally ill,
Give
my
it.
lord. Jail time, my lord, will worsen the.
ಇಲ್ಲಿವರೆಗೆ ಏನ್ ಮಾಡ್ತಾ ಇದ್ದೀರಿ ಸರ್?
Lord, I've
ಏನ್
been
ಮಾಡ್ತಾ ಇದ್ದೀರಿ?
move ಮಾಡಿದೀನಿ, bail move ಮಾಡಿದೀನಿ.
ಅಲ್ವಾ? ಬೇಲ್ ಮೂವ್ ಮಾಡ್ಕೊಡಿ.
Please.
ಮೆಂಟಲ್ ಇಲ್ನೆಸ್ ಅಲ್ಲಿ ಫಸ್ಟ್ ಕೊಡ್ತಾರೆ ಬೇಲ್.
My lord, this fresh matter, my lord.
Tuesday, sir,
Protection
give
order,
it.
my lord, was in my
If you want to give it for Tuesday. Otherwise, I'll take it next
Memo,
Tuesday.
my
Please
lord,
give it.
couple
My
of
lord,
times.
one sub,
ನೀವು ಕೊಡಿ ಪ್ರವೀಣ್.
24th is the date given for.
ಪರವಾಗಿಲ್ಲ ಸರ್. No problem.
my lord, one submission.
I can't adjust the date for the dates in trial court. Yes.
My lord, the prosecution has filed an application. I have challenged that in writ petition, my lord.
Very
The
good,
matter is posted for on 22
No
for
problem.
evidence, my lord.
Tuesday.
My writ petition will become
No,
infructuous, my
sir,
lord.
no writ petition will become infructuous. Give it.
Fresh
My lord,
matters.
it is for the posted for
No,
evidence,
sir.
my lord.
Give it. It's a pending matter.
Fresh matter, my
It
lord.
will come on
The
Tuesday.
matter is posted for evidence, my
For
lord.
what, sir? ಮಾಡಿ evidence. sir.
Prosecution has filed an
Madi
application under
evidence,
173 clause 5, my lord. I have challenged that
No
application in the
problem, sir.
review.
Give it, sir. Yes, Tuesdays.
My lord,
I'll take it. You get it posted on Tuesday. Yes. No, sir, I'm not taking tomorrow and day after. Please give it.
2:30, my
Yes.
lord.
No, yes, give it, yes.
Fresh matters till number 1.
As this petition was just challenging the order of the magistrate court wherein my complaint was dismissed to non-prosecution methods. It was initially at
No, at what stage was it dismissed?
summons stage, my lords.
Notice was not issued. Where are you standing? Are you the respondent here? Yes.
Notice was issued. I did not take out, I did not make process to dismiss for non-prosecution, my lords.
Process stage alena?
My lords, process.
Process stage alena. The petitioner is before this court calling in question an order of the concerned court which rejects the complaint or they rejects the case for its non-prosecution on the score that the petitioner has failed to take steps in the matter. If the petitioner, the learned counsel for the petitioner submits that if one opportunity is granted, steps would be taken and appropriate action, steps would be taken and would be diligent in prosecuting the petition before the concerned court. The learned counsel, the perusal at the order would indicate that it is not an order of acquittal as is passed under section 251 of the CRPC for the petitioner to file an appeal. In the light of the petition being dismissed at the stage of dismissal for non, at the stage of summons and dismissed for non-prosecution, I deem it appropriate to grant one opportunity to the petitioner to avail of, petitioner to diligently prosecute the matter. Therefore, the order dated so and so stands quashed. The matter, the case is restored to file on the file of the so and so court. The petitioner shall appear before the concerned court on 10th February. The concerned court shall regulate its procedure thereafter. In the event the petitioner fails to appear on the 10th of February 2026, the concerned court shall pass necessary orders in accordance with law, against which no indulgence again would be shown to the complainant, ordered accordingly.
Number 2.
Next. ಪವನ್ ಚಂದ್ರ ಶೆಟ್ರೆ, page 40 ಗೆ ಬಂದ್ಬಿಡಿ ಒಂದೇ ನಿಮಿಷ. ಇದು ಅಲಿಗೇಷನ್ ಅಲ್ಲ ಅಂದ್ರೆ ಈಗಲೇ ಅಲೋ ಮಾಡ್ತೀನಿ. Come to page 40.
40, my lord.
40.
Please, my lord.
40 ನಂತರ A9 ಅಂತ ಸ್ಟಾರ್ಟ್ ಆಗುತ್ತೆ.
Please,
ನಾಶಪಡಿಸಿರುತ್ತಾರೆ ಅಂತಿದೆ. ಇದು
Paragraph-
ಇದು ಟ್ರಯಲ್ ಬೇಡ ಅಂತಂದ್ರೆ ನೀವೇ ಹೇಳ್ಬಿಡಿ.
17 of the charge sheet, my lord.
ಬಿಟ್ಬಿಡಿ ಸರ್, ಅದೇ ನೋಡ್ತಾ ಇರೋದು ನಾನು.
Please, my lord.
ಕಮ್ ಟು
Yes,
ಪೇಜ್
ma'am.
40.
Wherein, my lord.
ವೇರಿನ್ ಇಲ್ಲ, ನಂತರ A9 ಏನ್ ಮಾಡಿದ್ದಾರೆ ಅಂತ ಇದೆ.
Yes, my lord.
Yes,
I will
A9
come.
ತಾನೆ?
A9.
ಕರೆಕ್ಟ್,
Yes,
ಅಲ್ಲಿದೆ.
my lord. A1 ಆರೋಪಿಯ ಕ್ರಯ ಮಾಡಿ.
A1 ಬಿಡಿ ಸರ್,
ಅಲ್ಲ,
A9 ಏನ್ ಮಾಡಿದ್ದಾರೆ
I
ಹೇಳಿ.
must read the, my lord, entire sentence.
You go to A9.
Yes, my lord. A9. A9, my lord.
ಓದ್ಬಿಡಿ ಜೋರಾಗಿ ಸ್ವಲ್ಪ.
Please, my lord.
ಹಾ.
A1 ಆರೋಪಿಯ ಕ್ರಯ
A1 ಅಲ್ಲ ಸರ್, A9 ಓದಿ ಸರ್.
A9. Yes, my lord.
A9 ಆರೋಪಿ.
ನಂತರ A9 ಆರೋಪಿಯು ಸಾಕ್ಷಿ 54ರ ಮೊಬೈಲ್ ನಂಬರ್ ಸೋ ಅಂಡ್ ಸೋ ನಂಬರಿನ ಆಧಾರ್ ಕಾರ್ಡ್ ನಂಬರ್ ನಕಲಿ ನಂಬರಿನ ಪಾನ್ ಕಾರ್ಡ್ ಅನ್ನು ಒಪ್ಕೋ ಮೊಬೈಲ್ ನಲ್ಲಿ ನಕಲಿ ಮಾಡಿ ಒಪ್ಕೋ ಮೊಬೈಲಿನಲ್ಲಿ ನಕಲಿ ಮಾಡಿ ಅದರಲ್ಲಿ ಮೃತ ಸಾಲಮರ ಹೆಸರಿನ ವಿಳಾಸವನ್ನು ಎಡಿಟ್ ಮಾಡಿ ಅದರಲ್ಲಿ A2 ಆರೋಪಿ ಭಾವಚಿತ್ರವನ್ನು ಹಾಕಿ ದಾಖಲಾತಿಯನ್ನು ಸಾಲಮ್ಮ ದಾಖಲಾತಿ ಎಂಬುವಂತೆ ನಕಲಿಯಾಗಿ ಸೃಷ್ಟಿ ಮಾಡಿ ಈ ದಾಖಲಾತಿಗಳನ್ನು ಪ್ರಿಂಟ್ ತೆಗೆದುಕೊಂಡು ನಂತರ ಆ ಮೊಬೈಲ್ ಅನ್ನು ಹಿರಿಯೂರು ನಗರದ ವೇದವತಿ ಸೇತುವೆಯ ಕೆಳಗೆ ಹರಿಯುತ್ತಿದ್ದ ನದಿಗೆ ಬಿಸಾಕಿ ಸಾಕ್ಷಿಯನ್ನು ನಾಶಪಡಿಸುತ್ತಾರೆ. Who has stated to the whom?
Who has stated to the whom is a matter of trial.
Yes, my lord. Now I will come back, my lord.
Yes,
the
sir.
entire affair is registered against the 8%. Your lordship may kindly.
No problem, sir. Charge sheet ಅಲ್ಲಿ ನಿಮ್ಮನ್ನ ಡ್ರಾ ಮಾಡಿದ್ದಾರೆ ಅಷ್ಟೇ.
No, I will come back, my lord. I will narrate the story. Your lordship
not here to listen to the story. This ಅನಂತರ A9 ನಾಶಪಡಿಸಿರುತ್ತಾರೆ.
That is the allegation. That is the allegation.
ಇದು ಎವಿಡೆನ್ಸ್ ಆಗಬೇಕೋ ಬೇಡವಾ?
That is the allegation which has been made by the prosecution. I will come back. I will come back, my lord. Your lordship may kindly come back to my lord, running page number 73, document number 5. Wherein, my lord, FIR has been registered against the 8%.
1 minute. ಆ 8% ಅಲ್ಲಿ ಮೊಬೈಲ್ ಬಗ್ಗೆ ಹೇಳಿದಾರ?
ಆ 8% ನಲ್ಲಿ
ಮೊಬೈಲ್ ಬಗ್ಗೆ ಆ ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ FIR ಅಲ್ಲಿ ಈ ಮೊಬೈಲ್ ಬಗ್ಗೆ ಹೇಳಿದಾರ?
FIR ಅಲ್ಲಿ nothing, my lord. Nothing has been stated.
This evidence.
No complaint against me.
This evidence has come for the first time.
Yes, my lord.
If this evidence has come for the first time.
Yes, my lord.
That you have destroyed this by creating all this.
Yes, my lord.
Is it not a matter of trial?
Of course.
Yes.
When there is a credible evidence is, my lord, with respect to that some mobile is belong from me. Somebody throw the mobile to the some lake, my lord. Somebody has.
Some ಎಲ್ಲ ನಾವು
ಅಂತ ಯಾರು ಹೇಳ್ಬೇಕು?
ಒಂದು ನಿಮಿಷ, ಈ ಮೊಬೈಲ್ ನಂಬರ್ ಯಾರ್ದು?
That is, my lord, because it is not belong from me.
That prosecution should say.
That they has to say. They have not stated throughout the charge sheet.
So look into it and tell me. Yes.
Then, my lord, one more humble submission, my lord.
Yes, sir.
Sub-registrar left out. RI left out.
That I am going to.
Please, my lord.
Wait.
Major accused, my lord.
1 minute, sir. The petitioner is accused number 9. Against him is the allegation of forgery. The allegation of forgery has sprung only on account of the following observation in the summary of the charge sheet as obtaining in column number 17. The petitioner is not an officer or is a third person to the transaction, is an admitted fact. While crime registered named 8 people, they are as follows. While filing the charge sheet, it transpires that yaran bittidare illi
Accused number.
list ಹಾಕಿದಿರಲ್ಲ?
Yes, my lord. Running page number 8, my lord.
8 ಅಲ್ಲಿ.
Accused number.
The police after investigation have dropped the proceedings against the sub-registrar, village accountant, revenue inspector, stamp vendor. If forgery has been committed in registering a document, it is ununderstandable as to how the prosecution could drop the accused 3, 4, 5, 6 who all were involved in the said transaction. The additional SPP shall secure instructions and show cause as to how the charge sheet drops all these accused despite direct allegations being made against them in the complaint, and has drawn a very vague charge sheet. The allegation against the petitioner is that he has thrown a particular mobile phone after editing the photograph of the complainant. It is not the case of the prosecution that the petitioner has circulated the said photograph, which has led to registration. The registering authorities, the authorities who have given documents, are all left off, and the petitioner is now brought into the web of crime while filing the charge sheet. While it is no law that no person should not be brought into the web of the crime while filing the charge sheet, the allegation must point at the forgery. While allegation points at the connivance of the sub-registrar, village accountant, revenue inspector, stamp vendor, they are dropped.
The allegation is that he created Aadhaar card, he created all these
How the
documents.
phone will create ಮಾಡಿ ಬಿಸಾಕಿದ್ರು.
Alla, he produced before the sub-registrar based on,
Then why have you let them off?
no, no, alla. They do not know whether these documents are genuine
Why?
or false.
You should
That's the
verify.
forgery document of
You
place.
should verify, yes. Therefore, the learned additional SPP to secure instructions and make submissions with regard to the role of the petitioner in the entire transaction by producing all the charge sheet material available. Till then, no precipitative action shall be taken against the petitioner. This is the matter on charge sheet ಆಗಿದೆಯಲ್ಲ? Charge sheet ಆದ್ಮೇಲೆ ಏನು ತೊಂದ್ರೆ ಇಲ್ಲ? Yes. Till then, charges charges shall not be framed against the petitioner. List the matter on 12th February.
Yes.
Number 3.
Split,
Split, my lord. Already accused number 8 in the same
page,
case.
page.
My lord, 86, my lord. 141, my lord.
Famous
This lordship, my lord, already quashed the
famous Chamanuru jewelry shop.
same case. Accused number 8 was already quashed.
ಯಾವ್ದಿದು?
Chamanuru jewelry shop there.
Dacoit.
Accused number 8 and the accused number 13, same case, my lord.
Page, ನಾವು ಕ್ವಾಶ್ ಮಾಡೋದು ಯಾವ್ದು?
Page 141, my lord.
1?
141, my lord. Allegation against the petitioner is conspiracy, my lord. Accused number 8 is also conspiracy, my lord.
ನಾನು ವಾಶ್ ಮಾಡೋದು ಯಾವ್ದು? Page.
I have, my lord.
ಇದಾಯ್ತು, ಇನ್ನೊಂದು ಯಾವ್ದು ಸರ್?
Accused number 8 is my lord.
ಇನ್ನೊಂದು ಯಾವ ಅಕ್ಯೂಸ್ ಇದೆ?
ಇಲ್ಲ, ಒಬ್ರು accused number 8 was quashed.
ನೀವು
This
ಯಾವ
is accused number 13, my lord.
Yes, Jagdish sir. The petitioner, accused number 13, is at the doors of this court calling in question proceedings in 50807 of 2015, which continues the case against the petitioner, but drawing up a split charge. The allegation is one of commission 499, 399, 402, na?
395.
395, which is commission of dacoity. The learned counsel for the petitioner submits that the co-accused, the learned counsel for the petitioner submits that for the persons who underwent trial, the concerned court by a detailed order has acquitted those accused for want of evidence. The same would become applicable to the case of the petitioner as well, is the submission of the learned counsel appearing for the petitioner. The learned additional SPP though would submit that the petitioner who has escaped trial must come out clean in a full-blown trial. The full-blown trial is would leave the decision to the court. Though persons who escape trial should not be shown any indulgence, the only indulgence is shown only for the reason that the petitioner would get eventually acquitted and would be wastage of precious judicial time. In that light, the view of mine in this regard. Disposed. Next.
4.
Pass over.
A comedy series, my lords, called Comedy Kiladigalu, and the skit that was being played was a rehearsal of
Imran
a-
Prajapati kodi.
Alla. Lordship may see the content.
ಏನ್ ಮಾಡಿದ್ದೀರಾ?
See that you can't make anything and everything.
Where is the content kodi?
The Mahabharata scene was enacted.
ಯಾಕೆ ಸುಮ್ಮನಿರಕ್ಕಾಗಲ್ವಾ?
My lords,
You're Khiladi or Khiladi?
my lords, this whole series was
Whatever it
a
is.
rehearsal.
What is all this?
My lords, a rehearsal for a show. That was what was being portrayed as a comedy episode of the rehearsal. That is how it starts.
So, under the garb of free speech, you can do anything you want. Then,
In fact, my lords, we
in
have.
fact, judgment, even I am aware.
Yes.
Yes.
And my lords, the mandate of a preliminary inquiry as held now by the Supreme Court, my lords.
It is,
Supreme Court now, my lords, would hold 299.
ಗೊತ್ತು.
it is not
All right.
mandatory. It is after being circulated in wide.
You don't deserve any indulgence. Such people don't deserve any indulgence who display gods, mythological figures as useless.
My lords, this was not even that, my lords, this was a rehearsal for the play.
Whatever.
How this happens is, my lords, we have the, could I just pass on, my lords?
In
My lords,
judgment,
notice
then-
what exactly it was, whether it amounts to a case under 299. Kindly notice this, my lords, how the whole episode is. The episode is, my lords, these characters are rehearsing for the play. And that is shown in the comedy series, my lords. And this comedy series has been going on for 5 seasons, my lords. Please notice this, how it is done. It is not meant, my lords, to hurt the religious sentiments of anyone.
What else it is, sir?
The characters, my lords.
What else it is, sir?
ಸಾರಾಯಿ ಸಿಂಪಡಿಸಿ.
And my lords, one aspect, my lord's judgment itself.
I know.
Public-
Law I know, sir. Law I know. But why should I show indulgence? I will not show. It is discretion.
My lords,
I will not show.
if my lord,
Why should such people be spared?
if my lords would kindly see the episode, my lord, just that portion of it which they say hurting religious sentiments, if it amounts to that, could I just point that out, my lords? We have the clipping, my lords, which they say is,
No, it's.
and
there-
all this happens, my lords. The episode is on 15/11. 25/11, a person gives a complaint in Hubli, my lords, a 0 FIR. That is now sent to Bangalore, my lords. And the mandate, my lords, in my respectful submission is when it is sent like that, the preliminary inquiry which needs to be done to see under what circumstances this has taken place. That has not been done.
This is how
And
ನೀವು ಕರೆಕ್ಟ್ ಆಗಿ ಮಾಡಲ್ಲ.
and my lords,
ಸುಮ್ನೆ ಒಂದು ರಿಜಿಸ್ಟರ್ ಮಾಡಬೇಕು ಮಾಡ್ತೀರಾ?
No, that's.
ಪ್ರೊಸೀಜರ್ ಫಾಲೋ ಮಾಡಲ್ಲ.
and Kirtan Kumar, my lords.
All cases are closed because of procedure not being followed by the prosecution. Every case you leave a loophole.
No, preliminary
Whether it
inquiry,
is
my lord,
deliberate or not, who knows?
not mandatory, my lord. This is
My lords,
there in the
first
public.
decision.
ಮಾಡ್ಬಿಟ್ರೇನು?
ಮಾಡಬಹುದು, but
ಅಲ್ಲ ಮಾಡ್ಬಿಟ್ರೆ ಏನಾಗುತ್ತೆ? ಗ್ರೌಂಡ್ ಇರಲ್ವಾ?
ಮಾಡಬಹುದು, but
Then we'll have to interfere on that ground.
ಇಲ್ಲ, but ಮಾಡ್ಲೇಬೇಕು ಅಂತ ಏನಿದೆ. This is, it is not that something is done secretly. It is being circulated widely. When it is being circulated widely, my lord, it is not about existence.
Could
Let
I
them
just
deny that
point
they
at
have
the
not even
first
done it.
ruling, my lords? His Lordship Justice Oak's first ruling, Imran, my lords,
That is
in
on the
which the
issue of
guidelines that is
literary
laid
art.
down. 299, my lords, what the court holds. Could I
I
just?
am aware of that, sir.
And then my lord's judgment in Kirtan Kumar.
Lordship may see the complaint, my lord. This is what needs to be shown any indulgence, my lord. Nothing can be there. Complaint itself, my lord. ರಾತ್ರಿ 9 ರಿಂದ 10 ಗಂಟೆವರೆಗೆ
ಗಂಟೆಯವರೆಗೆ ಕಾಮಿಡಿ ಕಲೆಗಳ ಶೋನಲ್ಲಿ ನಟನೆ ಮಾಡುತ್ತಿರುವ ಮಾಹಿತಿ ಇದಕ್ಕೆ ಮನಸ್ಸು. ನೀವು ಈ ಕೆಳಕಂಡ ನಿರ್ದೇಶ ಕಡ್ಡಾಯವಾಗಿ ಪಾಲಿಸುವಂತೆ. ಆಮೇಲೆ ಏನಾಗಿದೆ?
ಪಾಂಡವರಿಗೆ ಪಂಚೆ ಇಲ್ಲ. ಧೃತರಾಷ್ಟ್ರ ಸೋನ್ಸೋ, ಕೃಷ್ಣ ಸೋನ್ಸೋ.
My lords, those are the
ದ್ರೌಪದಿಗೆ
yes, my lord. Those are the actors who are
This is-
doing the rehearsal. In fact, my lords, this whole thing was a rehearsal for a play which is showed in a comical sense, my lords. That is what happened. It is not, my lords, on the characters, my lords. The rehearsal
Then
that
what,
was
sir?
on the
Characters,
village folks, my lords.
Characters sir, village folks.
My lord, this-
Characters sir ಇದು.
My lords,
Yes.
if my lords, can I show the consent video?
No.
Clipping?
But 299 ಸ್ಟೇ ಮಾಡಬೇಕಾಗುತ್ತೆ.
ಅಲ್ಲ, my respect to submission, my lord, it is not mandatory, my lord. And that Supreme Court judgment, my lord, it's on a poem. This is not a poem, my lord. This is the people are, it's been shown to the people are watching it. And if this is not going to be an offense, my lord,
My lords, if that poem in that particular judgment is also seen, my lords, in that context, how the court would interpret it. If it's 299, what ought to be done is how it's interpreted. My lords, in that paragraph 9 is the poem which is extracted, Supreme Court, my lords. They extract it and then they say if it's 299, this is how you should go about it, how a preliminary inquiry ought to be done, and then you proceed with it. And they lay down, my lords, in paragraph 42. The guidelines is laid down there.
You seen the complaint?
Yes, my
What
lords.
have
we
you
have.
depicted Lord Krishna as?
My lords, the-
What have you depicted? Can you read that? Is it readable?
Probably
Is it readable?
it's only for the characters.
Whatever,
my lords.
sir, is it readable? What have you depicted Draupadi as? Is it readable?
ಧೃತರಾಷ್ಟ್ರ.
In the name of comedy, anything is happening in this country. A free speech. This is the way. This is unreadable. So we should show indulge. Bail kotilva?
ಇಲ್ಲ, my lords, police notices are issued now, my lords.
Notice
Police
appear, participate in the
We have
investigation.
participated, my lords, we have participated, not that we are not participating. But my lords, the mandates which are not followed, my lords, may be
That we'll
considered.
see.
And more,
Participate in the
my lords,
investigations.
more in the context, kindly notice, my lords, more in the context of saying a preliminary inquiry whether it's necessary or not. And that is what has been laid on. If the first
So like I'll
judgment,
hold it not mandatory, only directory.
my lords, if the first judgment is seen, my lords, what was there as a poem and how the Supreme Court interpreted it, and also my lords has interpreted. My lords, in Kirtan Kumar,
No
my
sir,
lords,
being over liberal, these things are happening. Salpa, it becomes stringent, things will be all right.
probably, my lords, whether the comedy was extended too much. That's all the is the aspect, my lords, whether the element of comedy was extended too much, my lords. But please notice, my lords, after 10 days,
Participate in the investigation.
my lords, after 10,
Participate in the investigation. Why investigation ಭಯನಾ?
like procedure,
Comedy ಮಾಡ್ಬೇಕಾದ್ರೆ ಏನು ಭಯ ಇರಲಿಲ್ಲ, ಇದ್ಯಾಕೆ?
if the procedure is not followed
See
correctly,
sir, take bail. Take bail.
lot of harassment to
Take bail, sir.
for the entire
Arre,
network,
take
my
bail,
lords.
sir. Take bail.
And one other aspect, my lords, if every comedy series turns out to be FIRs, my lords,
No,
it
ಈ
becomes-
ತರ ಕಾಮಿಡಿ ಸೀರೀಸ್ ಮತ್ತೆ ಏನ್ ಮಾಡಕ್? Oh, don't paint everything with the same brush.
But
If
so
everything
many-
is
my
like
lords
this,
would have
be
seen-
it so.
My lords would have seen so many instances
No, so
of
be
comedy
it, sir.
series, my
So be it. If everything is going to be like this, so be it. Comedy, yes. Not at the cost of somebody else.
It's a theory, my lord, likely audience theory. In the literary audience and the audience which sees these kind of things are
Anyway,
different.
procedurally, they should have done it, my lords. At least after a zero FIR, if it's sent here, you don't even have a preliminary inquiry, my lords, to find out the starting point of that entire episode.
That's a clear case for bail.
My lords, starting for,
No, that's a clear case for bail. Take bail.
Alla, my lords, the starting point of that entire episode, it starts by saying this was a rehearsal.
I am
that-
only on 3. Dhritarashtra, whatever characters
Oh,
they
my
are.
lords,
Krishna and Draupadi.
Draupadi, I understand that, my lords. The starting point of it itself, my lords, the play starts, my lords, by saying this is a rehearsal that is being done.
ಆಯ್ತು rehearsal, whatever.
My lords, the characters
Then why
who
did you
are,
circulate the rehearsal?
my lords, the characters who
Why
are
did you
there.
circulate the rehearsal? Rehearsal should have been rehearsal. Why did you circulate the
The
rehearsal?
acting out of a rehearsal.
Do.
This is what was the comedy part of it, my lords. The acting out of that rehearsal which they had is what they put as a skit. And the skit, my lords, it's not to demean any characters. The 3 persons who are there, they're commenting on each other, my lords, not as saying that it is the mythological
Yes.
figures that are being done. That is not the intention at all, my lords.
Participate in the investigation. Don't arrest them in the garb of investigation. The petitioners shall participate in the investigation as the matter is still at the stage of crime. The complaint is stage of the investigation. The prosecution in the garb of investigation shall not take any coercive steps against these petitioners till the next date of hearing. Yes.
Well, it's just a small amendment to the cause title. The name has to be changed. We'll just,
yes.
Seal number 6.
It's a case of false promise to marry against accused number 1. Lord, he is a practicing advocate. The petitioners 1 and 2 are the clients, and petition number 3 is a student. He was visit for internship to his office, your lordship.
Internship?
The petition number 3 is a student, your lordship. You went to the office of the accused number 1. He is a practicing advocate, my lord, against him. False promise to marry.
Where is accused number 1 here?
My lord?
Accused number 1 illa illi.
Illa. 2 to 4, your lordship. 2 and 3 are the clients, your lordship. 4 is a student, your lordship. We went to the internship, his office, your lordship.
Your mail 74.
Yar mele?
Your mail.
A1.
A1 mele?
A1 mail 69, your mail 74.
Accused number 2,
2 and 3. They are trying to pacify the Galata.
Pacify, yeah.
Pacify the Galata, and they are called 112, your lordship, and I have produced this
Correct.
document.
Charge sheet
Number
ಆಗಿದ್ಯಾ?
27, your lordship.
Almost ready, my lord. We'll waiting for a FSL report.
Get the charge sheet material. Will stay against the student. The petitioner petitioners accused 2, 3 and 4. The second respondent is the complainant who had a relationship with the accused number 1, physical as well. The allegation is the physical relationship has happened with accused number 1 on the promise of marriage, and its breach has led to the registration of the crime. The learned additional SPP submits against the second accused what is alleged is offense under section 74, which is 354A of the earlier regime, the IPC. Insofar as the third accused number 4 is concerned, he is said to be an interning in the office of the advocate accused number 1. Therefore, there shall be an interim order of stay of investigation. Who is accused number 3?
3 is also one of the client, your lordship. There is no
The-
motive against.
And the third accused number 3 is the client of accused number 1. Therefore, they're finding no allegations even prima facie against accused number 3 and 4. The further investigation shall remain stayed qua accused number 3 and 4.
Accused number 2 also. madam.
No, yes. Insofar as accused number 2 is concerned, it shall be considered only after looking into the charge sheet material, which this court has now directed the additional SPP to place on record. Next. List the matter on 19th February.
Lordship may say the investigation with respect to others can.
The pendency of this petition will not come in the way of investigation qua other accused.
7.
Husband Kodala, in-laws.
Lordship,
No.
kindly come to.
No.
Lordship, kindly come to.
Husband, I will not grant.
Husband, my lord, kindly come to page number 84. Lord, the against husband also, my lord, the coordinate bench of this honorable court has granted this stay. My lord, on 19/11/25. Lord, thereafter, my lord, after 1 month, on 19/12/25, my lord, again she lodged the complaint, that too in Vasadurga. After 1 month.
One complaint already agidya.
ಆಗಿದೆ ಅದನ್ನ ಸ್ಟೇ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಇದು DV Act.
ಅಲ್ಲ ಇದು ಡಿವಿ ಆಕ್ಟ್ ಅಲ್ಲ ಆಫ್ಟರ್ 1 month.
DV Act ಗೂ ಅದಕ್ಕೂ ಸಂಬಂಧ ಇಲ್ಲ.
ಅಲ್ಲ 1 month ಆದ್ಮೇಲೆ
ಪರವಾಗಿಲ್ಲ.
ಅಲ್ಲ she engaged the service of
DV Act ಗೂ ಅದಕ್ಕೂ ಸಂಬಂಧ ಇಲ್ಲ.
Lordship, kindly appreciate.
ಕೇಳಿರೋದೇನು?
14/8/25, my lord.
Act ಅಲ್ಲಿ ಕೇಳಿರೋದೇನು?
Lord, she has sought the domestic relief, means the domestic relief regarding the monetary, and she's a earning woman. And moreover, my lord, on 14/8/25, petitioner number 1, he has lodged the complaint against her. My lord, and 18/8, my lord, he has given the legal notice.
Maybe,
My lord,
sir.
31/8/25, she lodged the complaint.
You DV Act ಆದ್ರೂ you should face.
ಅಲ್ಲ 39/25, my lord, she has given the reply.
Let
My
her
lord,
come.
after 6 months, my lord, she has lodged the complaint, that too stay of this honorable court, and she engaged the service of an advocate on 9/12/25 to that petition. After 20 days, my lord, she has lodged this complaint.
No problem.
Last
Yes.
working day of the vacation, my lord.
The petitioners are respondents 1 to 4 in a proceeding instituted by the respondent wife in criminal miscellaneous 935 of 2025. The learned counsel for the petitioner submits that the crimes were sought to be registered twice over against the husband and other members of the family, which have been stayed by the coordinate benches of this court. Those are proceedings under proceedings instituted invoking the provisions of the BNS. The present one is a proceeding instituted under the DV Act. It can both would stand on different footing qua the applications are concerned. Therefore, there shall be an interim order of stay only insofar as respondents 2, 3 and 4. It is made clear that the proceedings will continue against the husband. The consideration of interim prayer qua the husband can happen only after the appearance of the wife. The respondent emergent notice returnable by 19th February.
Please,
Next.
grateful.
8.
For the petitioner.
Heard the learned senior counsel Devakar appearing for the petitioner. The petition appends to it a communication to the jurisdictional police or the officer in charge of the police station that the complainant would want to withdraw the complaint. The communication reads as follows. In the light of the said communication, page 26, there shall be an interim order of stay of further investigation qua the petitioner. Next.
9.
Petitioners are accused number 6 and 7, my lords. They're aged about 56 years.
118.
No, not.
Not 7, my lords. After lapse of 8 days,
107.
307, my lords. 109 of
ಅದೇ
BNS.
118 307.
307 ಆಮೇಲೆ ಹಾಕಿದ್ದಾರೆ.
307 of IPC, my
ತಲೆಗೆ
lords. 109 of BNS.
ತಲೆಗೆ ಹೊಡೆದಿರೋದು ಮಟೀರಿಯಲ್
ಅಲ್ಲಿ ಸೆಕ್ಯೂರಿಟಿ.
ಕೊಡಿ.
I am placing, my lords, the wound certificate.
ಕೊಡಿ.
All injuries are simple in nature, but in complaint, my lords, there is no allegation against these petitioners.
Who are these?
These petitioners are mother of accused number 1 and aunt of accused number 1, my lords.
ಅಲ್ಲ ಅವ್ರ ಮೇಲೆ ಇದೆ ಟೈಪ್ ಮಾಡ್ಬೇಕಾದ್ರೆ ಅವ್ರ ಹೆಸರು ಬಿಟ್ಟಿದ್ದಾರೆ ಅಷ್ಟೇ.
Galate,
ನಮ್ಮ
there is a
ಮತ್ತೆ
dispute, my
A6 and
lords,
A7.
boundary and also land dispute.
That is not a license to assault, sir.
My lords, but that entire incident is false, my lord. There is a videograph
that we'll
also.
see.
Videograph also, my lords. We have placed it before the investigating officer.
ಇನ್ಮೇಲೆ we will have to see all videographs, sir. Because ಎಲ್ಲ ಪೊಲೀಸ್ನವ್ರು ಏನೇನ್ ಬೇಕಾದ್ರೆ ಹಾಕ್ತಾರೆ, ಇವರು ಏನೇನೋ ಹೇಳ್ತಾರೆ.
That is a fact.
Even in that skit, I want to see the video, whatever they have done. We'll start that, otherwise we can't entertain. ಬರೀ ಸುಳ್ಳು ಹೇಳಿರ್ತೀರ ಅಲ್ಲಿ, ಯಾರು ಬೇಕು ಅವ್ರ ಮೇಲೆ ಬಿಟ್ಬಿಡ್ತೀರಾ. ಈಗ what is the weapon involved?
ಮಚ್ಚಲ್ಲಿ ಹೊಡೆದಿದೆ.
Machu by accused number 1, my lords, in
ದೊಣ್ಣೆ.
complaint. As against these petitions, my lord, they have used some stick ಅಂತ ಅಲ್ಲೇ ಬಿದ್ದಿರುತ್ತೆ, ಆಮೇಲೆ ಮರದ್ದು ತೆಂಗಿನ ಮರದ್ದು
Spelling ಎಲ್ಲ
ಮೊಟ್ಟೆ.
ಇದೆಯಲ್ಲ, assault ಮಾಡಿದ್ದೀರಾ.
As against this petition, my lord, there is a vague and general allegation.
Get the charge sheet material.
Charge sheet is
Sorry,
not yet.
charge sheet ಆಗಿಲ್ಲ ಇನ್ನು.
No, my lords.
Investigation material.
There is 60 years and 56 years of.
ಅದೇ ಹೊಡಿಬಾರ್ದು ಅಂತಿದ್ಯಾ ಅವರು.
No, they have not assaulted, my lords.
We'll
Even
see.
as against the other accused person, there is an allegation.
Get the material. The learned additional SPP shall secure the investigation material with particular reference to the role of accused number 6 and 7, who are said to have assaulted the complainant. Therefore, the offense under section 118 and 109 of BNS, which is 307 and 324 of the IPC, has sprung. Yes, list the matter on next week.
Till then, my lords, 109, as against 109, my bail application came to be rejected by the sessions court. I have approached this honorable court, my lords. I have
Togoli,
taken,
bail togoli.
my lords, I have taken the station bail for the bailable offences, my lords. On very
307
same
ಯಾರು
day,
ಸ್ಟೇಷನ್ ಬೇಲ್ ಕೊಟ್ಟರು?
prior to, after lapse of 8 days, my lords, they have invoked section 307. It was very much, that's why, my lords, I have placed the own certificates.
Bail.
My lords, till then, at least, my lords, for 109, my lords, there shall not be any, because my lords, 60 years, ladies, my lords. There is
Lady
no-
na ಇದು?
Ladies, my lords, both the petitioners are ladies.
ಇಲ್ಲಿ
Yes, my lords.
ಕುಡಿಯಲ್ಲಿ
But the accused number 1 are gents are not before, men are not before this honorable court, my lord. Both the petitioners.
ಜಯಮ್ಮ and ಗೀತಮ್ಮ.
ಅಲ್ಲಿ ಕೆಲಸ ಮಾಡ್ತಿರ್ತಾರೆ, ಸಡನ್ ಆಗಿ ಗಲಾಟೆ ಆಗುತ್ತೆ, that is the allegation, my lord.
Yes.
ಆಯ್ತು, ಅಲ್ಲಿ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ ಮೇಲೆ not to arrest.
No, sir. Not, if it's women, then 307 ಅವ್ರಿಗೆ.
307 ತಲೆ ಕೊಡ್ತಿದ್ದಾರೆ.
ಯಾರು ಬೇರೆ
ಬೇಲ್ ತಗೊಂಡ್ ಮೇಲೆ, ಸ್ಟೇಷನ್ ಬೇಲ್ ತಗೊಂಡ್ ಮೇಲೆ
ಬೇರೆ
same
road.
day.
ಅಲ್ಲ anyway, I will instruct them not.
Yes. The petitioner shall cooperate with the investigation. No coercive steps will be taken against these petitioners, particularly on the score that they are women and aged 60 years. It is highly improbable they would assault the complainant so that it becomes a case for attempt to murder. The learned counsel for the petitioner submits station bail was granted on the offences under section 323. Another 115 of the IPC. But
118.
after 8 days, allegation under section 307 is added, all of which revolves around a property dispute is the counsel, submission of the counsel will state only. Therefore, the investigation against these petitioners shall remain stayed. It is made clear that the investigation qua the others shall continue.
Stay ಬೇಡ. He'll tell them not to
Steps
go.
on. ಸುಮ್ನೆ ತೊಂದ್ರೆ ಕೊಡ್ತಾರೆ.
6 years harassment, that's it.
Yes, next. 10 and 12 same ಅಲ್ಲ?
10 and 12 same.
Yes, sir.
But in 10,
Material ಇದೆಯಾ ಏನಾದ್ರು?
what has happened, 132 they have invoked, not, which is criminal force,
Criminal force ಏನ್ criminal
assault or criminal force.
ಹಾ.
That's the only cognizable section they have invoked. ಅದು ಅಪ್ಲೈನೇ ಆಗಲ್ಲ. Because it was a
Bail ತಗೊಂಡಿದ್ದೀರಾ?
discussion over
Bail
the phone.
ತಗೊಂಡ್ರಾ?
Bail ಇಲ್ಲ ಬ್ಲಡ್.
ತಗೊಂಬಿಡಿ.
Bail ತಗೊಳೋದಕ್ಕೆ ಇದು
ಯಾಕೆ ಬೇಲ್ ತಗೊಳ್ಳೋದೇನ್ ಕಷ್ಟ?
ಸೆಕ್ಷನ್ ಅಟ್ರಾಕ್ಟ್ ಆಗಲ್ಲ.
ಯಾವ್ದು?
ಇನ್ನೆಲ್ಲ ಬೇಲಬಲ್ 132. Because it was a telephonic conversation. My banners had been removed, though it was permitted by her.
What? Who are you?
But I'm the person who contested from Congress party there and lost.
ನಿಮ್ ಬ್ಯಾನರ್ ಇತ್ತ ಅಲ್ಲಿ?
Nan banner ಹಾಕಿದ್ದೆ because in promotion of a film. That
You are
banner.
a hero, is it?
ಇಲ್ಲ.
Then
ಯಾರ್ದೋ film I had promoted.
film ನಿಮ್ ಬ್ಯಾನರ್.
I had said promote it anta. Then what happened? She had permitted it over WhatsApp, the municipal commissioner. In the meantime, then she suddenly got it removed and she had left the banner of the other political party as it is.
WhatsApp permission ಎಲ್ಲಿದೆ?
WhatsApp permission ಹಾಕಿದೀನಿ ಅಲ್ಲೇ. Annexure E page 29. ಅಲ್ಲ annexure page 28. ಇದು ಹಾಕಿದಾಗ ಇದು ಲೆಟರ್ ಸಂಡೇ ಇತ್ತು, 2 ದಿನ ರಜಾ ಇತ್ತು.
ಏನಿದು?
She admits that. ಇಲ್ಲೇ ಇದೆ.
ಯಾವ ಲ್ಯಾಂಗ್ವೇಜ್ ಅಲ್ಲಿ ಇದೆ? ಇದು
ಇಲ್ಲೇ ಇದೆ.
ದೇವನಾಗರಿ.
ದೇವನಾಗರಿ ಲಿಪಿಲಿದೆ. ದೇವನಾಗರಿ ಲಿಪಿಲಿದೆ.
She admits that in the press statement, she admits that ಹೌದು ಈ ತರ ಕೇಳಿದ್ರು ವಾಟ್ಸ್ಆಪ್ ನಲ್ಲಿ I permitted ಅಂತ. Her case is that it was put at a place where it was a little accident prone. So therefore she had got it removed. In the meantime, other political party, she had left it as it is, rival political party. So I asked her a question as to why this was done.
Question ಮಾತ್ರ ಇಷ್ಟು ಸಭ್ಯವಾಗಿ question ಮಾತ್ರ ಕೇಳಿದ್ರೆ
heat of the moment ನಲ್ಲಿ I have said certain words which blood I am out of contrition I want to take back and I want to apologize.
How?
I will do it openly in the public blood.
ನಾನೇ ಕೊಡ್ತೀನಿ
ಅದಕ್ಕೆ 132 not 132 could not have been involved.
132 ಏನು?
132 ಏನಂದ್ರೆ criminal force, offering criminal force, whoever assaults or uses criminal force to any person being a public servant.
353 sir. Yes.
132 whoever
353 IPC.
353 yes. Assaults or uses criminal force to any person being a public servant in the execution of his duty as such public servant, or with intent to prevent or deter that person from discharging his duty as such public servant, or in consequence of
ಕೊಡಿ ಇವರು ಹೇಳಿರೋದೆಲ್ಲ ಏನಿಲ್ಲ.
I'll get it man. ತುಂಬಾ ಹೇಳಿದ್ದಾರೆ, ಸಭ್ಯವಾಗಿ ಹೇಳಿದ್ದಾರೆ.
ಅಲ್ಲ ಇದೆ, that I agree lord, but it has gone a little beyond the.
What has gone little beyond?
The speech. But today I am willing to say that I am sorry for this.
Why did you want to promote a film? You are a producer.
The local constituency.
New producer.
ಇಲ್ಲ local constituency.
New producer, hero na.
ಅಲ್ಲ local constituency person was part of that film. ಅದಕ್ಕಾಗಿ ಅಷ್ಟೇ ಬಿಟ್ರೆ ಏನಿಲ್ಲ. Local councillor ಅಷ್ಟಕ್ಕಾಗಿ I promoted it. And out of a genuine belief. But what they did, they allowed.
Genuine belief of what?
Genuine belief that not that they will permit, this was being permitted. I had taken permission from the municipal corporation, WhatsApp, and the permission to promote this on the field by paying the fees. What had happened? Not rival political party banners were left as it is. The municipal corporation.
Rival political party also.
Janata Dal. This municipal commissioner was little partial towards retaining their banners and removing my banner selectively. For this, a heated conversation took place. And second complaint though, because this went, she only had recorded this and sent it.
Both are by the same complainant.
Alla, adralli the Janata Dal vice president of the constituency. ನೀವು ಅವ್ರಿಗೆ ಯಾಕೆ ಬಿಟ್ರಿ ಅಂತ ನಾನು ಕೇಳಿದ್ದಕ್ಕೆ ಅದನ್ನ ಹಾಕಿದ್ದಾರೆ. ಅದು ಅಟ್ರಾಕ್ಟ್ ಆಗಲ್ಲ. That will also
film promote ಮಾಡ್ತಾ ಇದ್ದಾರೆ.
ಇಲ್ಲ ಇದೇ ಇನ್ಸಿಡೆಂಟ್ ನಲ್ಲಿ in the same phone conversation I say that Janata Dal ಅವ್ರದ್ದು ನೀವು ಬಿಟ್ಟಿದ್ದೀರಾ?
ಅಲ್ಲ ಬಿಟ್ಟಿದ್ದೀರಾ ಅಂದ್ರೆ ಅವರು ಫಿಲ್ಮ್ ಪ್ರಮೋಟ್ ಮಾಡ್ತಾ ಇದ್ರಾ?
ಇಲ್ಲ ಅವ್ರದ್ದು ಓನ್ ಬ್ಯಾನರ್ಸ್ ಇತ್ತು, ಪಾರ್ಟಿ ಬ್ಯಾನರ್ಸ್, ಅದನ್ನ ಹಾಗೆ ಬಿಟ್ಟಿದ್ರು. So we suspected that the JDS people have removed this banner and she has permitted it.
BJP ಇನ್ವಾಲ್ವ್ ಆಗಿಲ್ವಾ ಇದರಲ್ಲಿ?
ಅವರಿದಾರಲ್ಲ ಅದಕ್ಕೆ.
And there appears to be an attempt to target me here. That is how this has happened, Lord. Very unfortunate.
Very unfortunate.
And Lord, 132, I have not offered any criminal force or used criminal force to deter a public servant. 132 is not attracted.
Number 75, 79 ಎರಡು ಹಾಕ್ಬೇಕಾಗಿತ್ತು ಜೊತೆಗೆ.
ಇನ್ನು FIR ಇದೆ ಇನ್ನು.
And other sections, if other sections are seen, they are also not applicable. And they are all non-cognizable and bailable. Kindly see 150.
74, 79 ಯಾಕೆ ಹಾಕಿಲ್ಲ?
ಹಾಕಿಲ್ಲ.
Kindly see lot 224. Threat of injury. Which is
224, yes sir.
224, which is bailable. And
the only non-bailable offense is 132, 353.
132. 132 and 353 in the other.
ಅದೇ IPC.
In the other. Yeah,
ಅಲ್ಲ,
353.
IPC
correct.
350.
Yes, yes. ಇಷ್ಟೇ. And I'm willing to submit myself to the interrogation. I will go-
ಬೇಲ್ ಕೊಟ್ಟೆ ಬಿಡ್ತಾರೆ ಹಿಂಗ ಅಂದ ತಕ್ಷಣ.
ಅಲ್ಲ, ಸ್ವಲ್ಪ there is a- ಮನೆ ಸುತ್ತ ಪೊಲೀಸ್ ಅವ್ರ ಮನೆ ಮುಂದೆ ಮಲಗ್ತಾ ಇದ್ದಾರೆ.
ಒಳಗಡೆನೆ ಬಿಟ್ಬಿಡಿ, ಮನೆ ಮುಂದೆ.
That is why ಒಂದು ದಿಬ್ಬೂರಳ್ಳಿ ಪೊಲೀಸ್ ನನ್ನ ಮನೆ ಮುಂದೆ ಬೆಂಗಳೂರಿನಲ್ಲಿ ಹಾಕ್ಬಿಟ್ಟಿದ್ದಾರೆ. One police unit has been placed there.
ಈಗ ಎಲ್ಲಿದ್ದೀರಾ ನೀವು?
ನಾನು ಹಿಂಗೆ
ಅಪ್ಸ್ಕೊಂಡಿಂಗ್.
ಜಯನಗರದಲ್ಲಿ.
ನಾನು ಎಲ್ಲಿದ್ದೀನಿ ನನಗೆ ಗೊತ್ತು.
ಪೇಟ್ರಿ ಬೇಲ್ ರಿಜೆಕ್ಟ್ ಆಗಿದೆಯಾ?
ಇಲ್ಲ ಪೆಂಡಿಂಗ್ ಇದೆ.
ಪೆಂಡಿಂಗ್ ಇದೆಯಾ? ಮತ್ತೆ ಎಲ್ಲಿದ್ದೀರಾ ಈಗ?
ಪೆಂಡಿಂಗ್ ಇದೆ. ನಾನು
ನೀವು ಎಲ್ಲಿದ್ದೀರಾ ಅಂತ ಹೇಳಿದ್ರೆ ಏನಾರ ಒಂದು ಆರ್ಡರ್ ಮಾಡ್ಬೋದು.
ಎಲ್ಲಿದ್ದೀರಾ ಅಂತ ಹೇಳಿದ್ರೆ ಅವ್ರು ಹೋಗಿ
ಅರೆಸ್ಟ್ ಮಾಡ್ತಾರೆ.
ಈಗ ಎಲ್ಲಿದ್ದೀರಾ ಅಂತ ಹೇಳೋದಕ್ಕೇನೆ ಪೊಲೀಸ್ ಜೀಪ್ ಹಾಕಿರೋದು. That's the situation I am facing, Lord. And I will cooperate with the investigation.
You may cooperate with anything.
Submit myself to the investigation.
How can you speak like this?
That Lord, there is no pardon to it, and I will withdraw. As soon as I come, I will withdraw.
Come where?
Come out. I will withdraw this allegation. Your Lordship may note it.
ಹೆಂಗ್ ವುಮನ್ ಅಂದ್ರೆ ಏನ್ ರೆಸ್ಪೆಕ್ಟ್ ಇಲ್ಲ.
ಸುವರ್ಣ ನ್ಯೂಸ್ ನಲ್ಲಿ ಸಾರಿನೂ ಕೇಳಿದ್ದೀನಿ ನಾನು. ಅವರು ಒಪ್ಕೊಂಡಿದ್ದಾರೆ. Already I have taken, but I will reiterate that apology. Subject to that, Lord, and I'll face the inquiry. Let them not take coercive steps against me. That's all. ಆಗಿದೆ, ಅಚಾತುರ್ಯವಾಗಿ ಆಗಿದೆ. I will not say no, Lord. But I've already pleaded
ಅದು ಕೊಡಿ ಜಗದೀಶ್. ಏನಿಲ್ಲ.
I'll secure my right.
ಮಧ್ಯಾಹ್ನ ಬೇಕು ನನಗೆ. Get it. ಆಯ್ತು. ಎರಡು ಸೇಮ್ ಅಲ್ಲ?
ಎರಡು ಸೇಮ್. ಅದರಲ್ಲೂ ಅಟ್ರಾಕ್ಟ್ ಆಗಲ್ಲ.
ಆಯ್ತು. Heard reserved.
ಅದು 352 and 351.
What can be done?
BNS.
ಹಂಗೆ ನೀವು ಮೆಟೀರಿಯಲ್ ಕೊಡಿ, ನೀವು ಅಡ್ರೆಸ್ ಕೊಡಿ.
ಆಯ್ತು.
ಎಲ್ಲಿದ್ದೀರಾ?
ಆಯ್ತು.
230 ಅಲ್ಲ, 230 ಅಲ್ಲ, ರಿಸರ್ವ್ಡ್.
Please.
I'll pass orders tomorrow.
Please.
ಅದು ನಂಗೆ ಮೆಟೀರಿಯಲ್ ಬೇಕು.
And this is the police photographs.
ಅದೇನ್ ಬೇಡ ಬಿಡಿ.
Somehow or the other, Lord, on a cognizable offense, they want to.
ಗವರ್ಮೆಂಟ್ ನಿಮ್ದೆ ಆದ್ರೂ ಪೊಲೀಸ್ನವ್ರು ಇದ್ದಾರೆ ಹಿಂದೆ.
ಏನ್ ಮಾಡೋದದು? MLA ಸೋತ್ ಬಿಟ್ಟೆ, ಅದಕ್ಕೆ ಇಲ್ಲಾಂದ್ರೆ ಇರೋರು. Presently, there is a JDS MLA.
Reserved, yes.
Please, Lord, please. Oblige. Some relief, Lord, so that I can attend the inquiry, Lord. Some relief. I'll attend and cooperate with the inquiry, and
But
subject to the condition that a public apology I will give. I'll ready to give a public apology also.
We'll see.
And say that.
The whole problem is, I'll tell you, what cannot be taken back is words spoken. Your tongue should be very important.
Yes.
Tongues have destroyed everything, sir, always. So.
Yes. But Lord.
Words spoken can never be taken back.
Yes. But Lord, out of contrition, I will withdraw, and out of genuine bona fide belief.
You may seek apology, but the crack remains. Let's see. Yes.
At least some opportunity to recompense and take back. But at least public will accept it.
We'll see.
Please. Oblige.
11.
498 MLS in-laws.
85, yes.
Admission 13.
Not a whisper, my lord, against me. Under the SC/ST Act, if you also look at the complaint.
My detailed interim orders. That's the final order.
Absolutely. Not only that, he is, my lord, there is a injunction against him.
Served unrepresented, idara Arjun.
ಬರ್ತಾ ಇಲ್ಲ.
Last time ಬಂದಿಲ್ಲ. I have already indicated. Yes. Heard the learned, the petitioners are before this court calling in question proceedings in crime, registration of a crime in crime number 8 of 2023, registered for offense punishable under section so and so. Prayerly. Heard the learned senior counsel Uday Holla appearing for the petitioner. The counsel for the respondent has remained throughout absent. This court on 6/1/2026 had passed the following order. The counsel for the respondent complainant remained absent both in the forenoon and in the afternoon, and the matter was posted today as a last chance. Even today, there is no representation on behalf of the complainant. Therefore, the learned senior counsel for the petitioner and the learned HCGP for the state are heard. Facts enumerated are as follows. The petitioners, ITC na ನೀವು?
ಹೌದು ಸ್ವಾಮಿ. We are employees of ITC. Page 10 ನಲ್ಲಿ ಬರುತ್ತೆ.
The petitioners are the office, what are you?
I was, my lord, working as the vice president HR.
The petitioners are the office bearers of the ITC Limited, Agri Business Division, hereinafter referred to as the company for short. The petitioners had engaged the services of the complainant, one Tejasvi Enterprise, or
Tejasvi Enterprise, my lord, was not the complaint. Tejasvi Enterprise is the
engaged,
contractor.
the company had engaged Tejasvi Enterprises, an independent contractor who was engaged for the purpose of deployment of its employees at the company's Greenleaf Tobacco threshing unit at Nanjangud Taluk. An agreement to that effect is entered into between the company and Tejasvi Enterprises. The agreement stood expired on 23/7/2016, and Tejasvi Enterprises withdrew its employees, including the complainant, from the Nanjangud unit. A fresh agreement was then entered into for the next term with the same company, between the same parties. After the agreement was entered into, a crime comes to be registered by the second respondent complainant. The complaint comes to be registered. The complaint then becomes a crime in crime number 234 of 2016 against new Madidavai.
He, my lord, files a complaint against us. In fact, we filed a suit and got an injunction also.
Why?
Because he started, my lord, dharna there, and he gave a good conduct certificate. Your lordship turned to, my lord, 111.
The second respondent then, after the closure of the agreement between the parties, is said to have staged a dharna in front of the unit of the company on the score that he was removed from service.
Page 43 ನಲ್ಲಿ ಬರುತ್ತೆ.
This led the company to register a crime against the second respondent for an assault, which had become a crime in crime number 234 of 2016, and another crime in crime number 241 of 2016, again against the second respondent complainant for assaulting the employees of the company. Not stopping at that, the company had to knock at the doors of the competent civil court in OS 588 of 2016, or 588 of 2016, by seeking an injunction against the second respondent not to enter the premises of the company. Interim injunction was granted, and the second respondent called that injunction was granted. First kodlilva?
Injunction was refused.
Injunction was refused by the civil court, which was granted by the first appellate court in MA 18 of 2016. The second respondent then initiates proceedings before the deputy labor commissioner, and an undertaking was given by the company but to render a good conduct bond to his good conduct certificate to the second respondent, which was eventually granted. When things stood thus, the second respondent then goes to the jurisdictional police and goes to the Directorate of Civil Rights Enforcement and registers a complaint on 29/3/2019. Notice is then issued by the Directorate of Civil Rights Enforcement, and there again a settlement is arrived at between the parties. Between the parties, it transpires the second respondent was allegedly abused. When was the complaint, sir?
It was, my lord, lodged on.
Manu, you should file a synopsis.
1/1/2023, my lord.
ಇವಾಗ ಹಾಕತ್ತೇನು?
11/1/2023.
11/1/2023. 23.
Please. In respect of an incident which took place, my lord, on 27/8/2020, page 34 ಗೆ ಬನ್ನಿ ಸ್ವಾಮಿ.
1 minute. 27/8.
27/8/2022 ಅಂತ ಹೇಳಿ 21 ಅಂತ ಹೇಳಿ ನಮಗೆ 1 2 3 4 5 6 8ನೇ ಲೈನ್ ಅಲ್ಲಿ ಬರುತ್ತೆ ನೋಡಿ.
27/8/2021 ಇದೆ.
ಹೌದು. ಆಮೇಲೆ ಕಂಪ್ಲೇಂಟ್ is lodged in 23 11/1/2020.
It transpires that the second respondent then seeks to register a complaint before the jurisdictional police for offences punishable under section 506, 504, 506, 143, 149 of the IPC and the provisions of the Atrocities Act. The registration of the complaint has driven the petitioners to this court in the subject petition. The learned senior counsel Shri Uday Holla would take this court through the complaint to demonstrate that the complaint alleges an incident that has happened on 27/8/2021 and the complaint comes to be registered on 11/1/2023, 2 years after the registration of the complaint. He would submit that if factually abuses had been hurled or assault or the second respondent was assaulted, it would not take 2 years for him to approach the jurisdictional police to register a complaint. More so in the light of the fact that he had already agitated his rights before the Directorate of Civil Rights Enforcement. The learned senior counsel submits that if this would be permitted, it would become an abuse of the process of the law. The learned HCGP would submit that the matter is still at the stage of investigation. The offences alleged are the ones punishable under the Atrocities Act, which are clearly made out in the case at hand. If the offences are made out, it is for the petitioners to face trial and come out clean in the trial. He would submit that this court should not interfere at this stage and permit investigation in the least to be continued. As observed here and above, there is no representation on behalf of the complainant throughout. I have given my source. Therefore, narrated facts, dates, link in the chain of events are all a matter of record. It would not require reiteration, except the relation between the present petitioners and the second respondent complainant, which the second respondent complainant was an employee of Tejasvi Enterprises. He was also offered employment in the company. The contractual agreement changed and the second respondent was not permitted to work. The second respondent was creating ruckus in the company. Therefore, the company had to take three proceedings against the second respondent. One in crime number 234 of 2016, the other in crime number 241 of 2016, and another civil suit seeking injunction against the second respondent from entering the premises. All these are a matter of record. The interim injunction was granted by the first appellate court. Then the second respondent would approach the Deputy Labour Commissioner. See, the matter gets settled there by rendering a good conduct certificate to the complainant. After about 2 years,
The complainant. By the complainant.
a good conduct certificate by the complainant of all the employees in the company. After about 2 years, it is the allegation that on 27/8/2021, the second respondent was abused and abused by accused 7/8/11, taking the name of his caste, threatened him with death while he was protesting at Rishi Fabrications near the Nanjangud unit. The complainant does not immediately register the crime. 2 years later, registers the impugned complaint. Since the entire issue is now triggered from the complaint, I deem it appropriate to notice the complaint. It reads as follows. Where is the complaint?
Page 33.
30 typed copy, yeah?
34 ಸ್ವಲ್ಪ ಮಿಸ್ಟೇಕ್ ಇದು 34 is
ಇದೆಲ್ಲಿದೆ 33 34
33 34 ಅಲ್ಲಿ ಇದೆ ನೋಡಿ. ತಾವು
ಟೈಪ್ಡ್ ಕಾಪಿ ಒಂದೇ ಇದೆ.
ಟೈಪ್ ಕಾಪಿ
33 34
35 36 ಟೈಪ್ಡ್ ಕಾಪಿನಾ ಅಷ್ಟೇನಾ ಅದು?
ಇಲ್ಲ ಸ್ವಾಮಿ, ತಾವು ಇನ್ನೊಂದು ನೋಡಿ
ಕೊಡಿ.
ಮಾಡಬೇಕಾದ್ರೆ ನೋಡ್ಕೊಂಡು ಎಲ್ಲ ಯಂಗ್ಸ್ಟರ್ಸ್ ಇವರು ಈ ಟೈಮಲ್ಲಿ ಮಾಡಬೇಕು, ನಾನ್ ಮಾಡೋದಲ್ಲ.
ಅದಕ್ಕೆ ಮನುಗೆ ಹೇಳಿದ್ದು.
ಇವರು
ಅರ್ಧಂಬರ್ಧ ಕಂಪ್ಲೇಂಟ್ ಹಾಕಿದ್ದೀರಾ. ಸೆಕೆಂಡ್ ಒನ್ ಏನು? ಡಿಫರೆಂಟ್ ಅಕ್ಯೂಸ್ಡ್
ಬಟ್ ಸೇಮ್ ಆಫೀಸರ್ಸ್ ಆಫ್ ದಿ ಸೇಮ್ ಇದು.
The complaint reads as follows. As observed here and above, the complaint narrates the entire history of the litigations between them and an incident that happens on 27/8/2021. If the incident of hurling of abuses has happened on 27/8/2021, nothing stopped the complainant to immediately approach the jurisdictional police. The effect of hurling of abuses cannot be said has taken 2 years for the complainant to have its effect on him. The complaint also does not narrate as to where and which place the hurling of abuses has taken. The hurling of abuses is neither in a public place nor a place with public view. It becomes very clear from the very complaint itself. Therefore, the offence under section 31 R and S as is laid down against the petitioners is not even prima facie found in the case at hand. Permitting further investigation in the case at hand, the said offences would run foul of the judgment of the apex court in the case of Hitesh Verma versus State of Uttarakhand, 2020, 10 SCC page 710, the court para 14 to 19. The Apex Court observes that the Atrocities Act is invoked in the said case before the Apex Court on the score of pending disputes between the parties only to wreak vengeance. The wreaking of vengeance is writ large in the case at hand, as several proceedings are taken up against the complainant by the company, and therefore it is not improbable that wreaking of vengeance has led the complainant to register the said crime. Above all, the complaint is hit by gross delay. The Apex Court has time and again cautioned complaints to be entertained by the police, but the petitions to be entertained by this court while answering it under 482 of the CRPC if the complaints are hit by delay. As the Apex Court holds, delay would cause embellishments to come into the complaint, which in fact in the case at hand has come into the complaint. The Apex Court in Chanchalapati Das versus State of West Bengal, 2023 SEC Online SC page 650 has held as follows. In the light of the aforesaid judgments, the Apex Court in the case of Hitesh Verma, I do not find any warrant to permit investigation into the offences under the Atrocities Act. As also the judgment in the case of Chanchalapati Das, I do not find any warrant to permit the investigation of any offence as it is hit by complete delay. In that light, the petition deserves to succeed, and the crime obliterated for it to stop from becoming an abuse of the process of the law and result in miscarriage of justice. Lord Quast, next.
Both the cases.
Both, yes.
Great.
14.
And accused Esther.
He's accused number 3, man.
Huh?
He's accused number 3.
Yaudರಲ್ಲಿ?
Second case. 14.
First petition ಯಾವ accused?
1 to 6 except 3.
1 to 6. So, ಎರಡು ಸೇರಿ 1 to 6 ಎಲ್ಲರೂ ಇದ್ದಾರೆ.
Yes.
Yes.
14.
Well, serial number 14, I am appearing for the petitions council minutes. So can I argue this? There is an interim order minutes. Can I argue this matter in the next week?
When do you want? It's not well.
Any date in the next week minutes.
List the matter on, we'll take it on 3rd February.
Very well, minutes.
Interim order subsisting will continue to the next date of hearing.
15.
They remained absent minutes continuously. All other 5 cases are quashed, my lords. ಕೊಟ್ಟಿದ್ದೀನಿ ನಾನು.
Sorry, yes. The petitioners are before this court calling in question registration of a crime in crime number 99 of 2023 registered for offences punishable under section 120, 406, 409, 420 and 34 of the IPC. The heard sounds. ಇದು ಕೌನ್ಸಿಲ್ ಬರ್ತಾ ಇಲ್ವಾ petitioner?
ಇಲ್ಲ ಬರ್ತಾ ಇಲ್ಲ. Respondent counsel.
The heard the learned counsel appearing for the petitioner. Counsel for the second respondent has remained absent throughout. This court on 13/1/2026 had passed the following order. It was indicated that in the event the complainant nor his counsel would be present, appropriate orders would be passed on hearing the counsel for the petitioners. Even today, there is no representation on behalf of the counsel on behalf of the complainant. Neither the complainant nor the counsel for the complainant is present. The petitioners are accused 1 to 18, 1 to 21 are alleged of offense punishable as aforesaid.
Elru ಇಲ್ಲ. 1 to 11, 18, 21 and 22.
ಆಯ್ತು, ಅದು ನೋಡ್ಕೊಳ್ಳಿ. Yes. Are alleged of the aforesaid offences. The learned counsel as Rajshekhar would submit that the second respondent complainant is habitual.
Let's.
Second respondent
And
gets the complaint registered from each one of its employees at every point in time. All those have been quashed by the coordinate benches of this court. Coordinate benches.
Bench.
Coordinate bench of this court. They are all in criminal petition. illide. Each case ಹಾಕ್ಬಿಡಿ. ಇದ್ಯಾಕ್ ಇದು ಆಮೇಲೆ ಹಾಕಿರೋದಾ?
ಇದು ಫಸ್ಟ್ ಫಸ್ಟ್
ಇದ್ಯಾಕ್ ಮೂವ್ ಮಾಡಲಿಲ್ಲ ಮತ್ತೆ?
ಮೂವ್ ಮಾಡದೆ ಲಿಸ್ಟ್ ಆಗಿ.
Yes. The subject crime is the one that is registered initially long before the crimes that are registered by the employees of the complainant, which becomes the subject matter of the aforesaid criminal petitions. The criminal petitions are allowed, each of the criminal petitions are allowed on the score that the issue was purely civil in nature and was dressed with the color of crime. In the light of the present complainant also being an employee of the company which sought to register several crimes against the present petitioner through its employees, I deem it appropriate to follow suit as to what the coordinate bench has held in the aforesaid orders. The coordinate bench, while quashing every one of the proceedings, has held as follows. In the light of the issue being similar, the contentions being similar, the petition deserves to succeed in the manner in which the coordinate bench has rendered the judgments qua the present petitioners. For the aforesaid reasons, allowed post.
Great.
16.
Respondent.
Swaroop,
Please, Molu.
ಇವರು ದುಡ್ಡು ಕೊಟ್ಬಿಟ್ಟಿದ್ದಾರೆ. ಇವ್ರನ್ನ ಬಿಟ್ಬಿಡೋಣ. But law we will not lay down that settlement ಕಳಿಸ್ಬೇಕು, ಇಲ್ಲದ್ರೆ farmers ಗೆ ದುಡ್ಡೇ ಬರಲ್ಲ.
ಅಲ್ಲ, ಅದಕ್ಕೆ couple of points. They're relying on section 84 where it has to go before the dispute committee.
That also I will not.
Please, adali only seller and buyer, the petitioner is a commission agent. So commission agent is 84 ಕೆಳಗೆ ಬರೋದಿಲ್ಲ. One point. Second, my lord, a couple of decisions of the Honorable Supreme Court and this court I want to rely on.
Today.
Here, where criminal prosecution and civil prosecution would lie.
That is a settled law, sir.
And my
Can
lord,
go on. I am not on that at all.
that one decision of our own High Court. What-
ಈ provisions interpret ಆಗಿದೆಯಾ?
ಇದೆ.
ಕೊಡಿ, ಅದಿಟ್ಬಿಟ್ಟು ಕೊಡಿ ಸಾಕು.
That judgment is
ಇದರಲ್ಲೂ
not applicable to
Wait,
me.
madam.
ಇದರಲ್ಲೂ ಈ ಕೇಸಲ್ಲೂ ಫಾರ್ಮರ್ ಗೆ ದುಡ್ಡು ಕೊಟ್ಟಿರ್ಲಿಲ್ಲ. They would file, APMC would file 420 cheating case against the commission agents. ಅದಲ್ಲೂ they would take a decision, contention that 84 ಕೆಳಗಡೆ ಕಳಿಸ್ಬೇಕಾಗಿತ್ತು and things like that. But para 26 ಅಲ್ಲಿ this court held as follows. It is not in dispute that no dispute committee has been constituted by the APMC Gangavati. Therefore, submission of the learned counsel of the petitioner that the complainant or secretary to whom the said agriculturist made their representation should have got the dispute resolved by invoking provisions of 84, 84A of the Act cannot be accepted. Even where there is a clause referring to the dispute to arbitration, the Honorable Supreme Court has held such a clause would not prevent the aggrieved party to approach a criminal
No,
court.
that law we will lay down, no problem. But he has paid it now.
That is observation is there in para 17. In the same judgment ಅಲ್ಲಿ para 17, last 3
ದುಡ್ಡು
lines.
ಕೊಟ್ಟಿದ್ದಾರೆ ಅಂತನಾ?
ನಾನು ಓದ್ದೆ.
ಅಲ್ಲ, ದುಡ್ಡು ಕೊಟ್ಟಿದ್ದಾರೆ ಅಂತನಾ?
3 lines ಅಲ್ಲಿ ಇದೆ. Even at this stage, observation ಇದೆ. Even at this stage,
want
the
of some
petitioner are
allegation?
not Even in the last 3 lines, para 17 ali.
Yes.
Even at this stage, the petitioner are not in the position to come up with a specific case as to whether they are liable to pay the said balance amount to the, ಅಂದ್ರೆ ಅವ್ರು ready ಇರ್ಲಿಲ್ಲ balance pay ಮಾಡಕ್ಕೆ.
ಕೊಟ್ಟಿದ್ದಾರೆ, ದುಡ್ಡು ಕೊಟ್ಟಿದ್ದಾರೆ.
Please.
ಕೊಟ್ಟಿರೋದ್ರಿಂದ will close this, but we will not lay down the law that farmer ಅಲ್ಲಿಗೆ ಹೋಗ್ಬೇಕು ಇಲ್ಲಿಗೆ ಹೋಗ್ಬೇಕು ಅವೆಲ್ಲ ಬರೆಯಲ್ಲ. 84 is not applicable at
Dr.
all.
Muller, what the commission agent would do, he would default, wait for the APMC to file a complaint and pay the farmer delayedly and
That's
then
the
come
problem.
before this.
See,
That is the problem.
ಏನಾರು ಇರ್ಲಿ, farmer ಗೆ ತೊಂದ್ರೆ ಆದ್ರೆ I will not interfere, madam.
Let there are about
Please,
7
in this
farmers
case,
who have
commission
been.
there are
agents
4 commission
ರೈತರನ್ನ
agents.
ಆಟ ಆಡ್ಸ್ಬಿಡ್ತೀರಾ.
Like our
there are-
proceedings and resolution ಅಲ್ಲಿ there are 4 commission agents defaulted, but only 2 persons ಗೆ ಮಾತ್ರ criminal case file ಮಾಡಿದ್ರೆ, in 2 persons ಗೆ
ಅವ್ರ
not
ಹೆಸರು
even they
ಕೊಡ್ಲಿ,
have
ಅವ್ರ
not
ಮೇಲೂ
even
ಹಾಕ್ತೀವಿ.
filed a civil suit also.
ಅವ್ರ ಹೆಸರು ಕೊಡ್ಲಿ, ಅವ್ರ ಮೇಲೂ ಹಾಕ್ತೀವಿ.
ಯಾಕೆ?
ಅಲ್ಲ ಅವ್ರ ಮೇಲೂ ಹಾಕ್ತಿವಿ, ಏನ್ ತೊಂದ್ರೆ ಇಲ್ಲ. There are 6 farmers who they
ಅಲ್ಲ
have
ಅವರಿಗೆ
defaulted.
ಅವ್ರ ಕೇಸ್
ಹಾಕ್ತಾರೆ ಬಿಡಿ, ಈಗ ಹಾಕ್ತಾರೆ, ಹಾಕ್ಕೊಡ್ತಾರೆ.
ಅವರಿಗೆ ಫಾರ್ಫಿಟ್ ಮಾಡಿಲ್ಲ,
Criminal
license
case
cancel
ಹಾಕ್ತು,
ಮಾಡಿಲ್ಲ,
you will
ನಮ್ಮ
produce
ಇಬ್ರು
it
ಮಾತ್ರ
before the court. How do you treat
But I have
everybody?
no
Our
instruction.
proceedings
It is not
ಅಲ್ಲಿ, my lord,
pleaded in the
kindly take
petition.
this.
First time it has come before the court. I'll take instructions on that.
that
Give-
was in the writ
ಕೊಡಿ, ಅವ್ರ
process
copy
also
ಕೊಡಿ.
ಹೇಳಿದ್ದೀನಿ, ನಾನು ಅವ್ರಿಗೆ copy.
ಕಾಪಿ ಕೊಡಿ ಮೇಡಮ್.
First
ಇದು
time
ಒಂದ್
it has
ನಿಮ್-
been pleaded, I will take instructions about what has
How
happened.
do you leave, see, if somebody, some commission agent
But
has
it has not,
played with the life of a farmer,
True.
no, you will not entertain anything.
he should not be let go.
Yes.
It should not be let
No
go.
farmer should be troubled. Commission agents ಮುಗಿಸ್ಬಿಡ್ತಾರೆ farmer ಅಷ್ಟೇ.
Please.
ದುಡ್ಡೇ ಕೊಡಲ್ಲ.
ಈ ಕೇಸಲ್ಲಿ if 6 farmers have filed the complaint, Malad. So 2018, Malad, they have filed a complaint. 19, we have filed the PCR. CC has been registered. Thereafter, he receives the summons. In 20, he pays the farmers. Then he cannot
ಯಾವಾಗ
be.
ಸೇಲ್ ಆಗಿದ್ದು ಯಾವಾಗ?
Malad, in between November 2018 to February 2019, we received the complaints.
ಇಲ್ಲ ಇಲ್ಲ, ಇದು ಸೇಲ್ ಆಗಿದ್ದು ಯಾವಾಗ?
Let's sale.
Produce ಸೇಲ್ ಆಗಿದ್ದು ಯಾವಾಗ?
ಅದೇ between November
ನಾವು ತಗೊಂಡು late
2018
ಆಗಿ sale
ಇಂದ
ಮಾಡ್ತೀವಿ.
ನವೆಂಬರ್ 2018 ಇಂದ
ಎಲ್ಲ 2018 Malad, between September to November 2018 Malad. Immediately Malad, he is supposed to pay. They give us a complaint in 2018 ಅಲ್ಲೇ between November to February ವರೆಗೂ ಕಂಪ್ಲೇಂಟ್ ಕೊಡ್ತಾರೆ ನಮಗೆ. February 2019 ಅಂತ.
2019.
19th
ನೀವು
ಅಂದ್ರು.
ಕ್ರಿಮಿನಲ್ ಕೇಸ್ ರಿಜಿಸ್ಟರ್ ಮಾಡಿದ್ದು ಯಾವಾಗ?
ಆಮೇಲೆ 4/10/2000 we issued notices, couple of notices.
ಆದ್ರೂ ಕೊಡ್ಲಿಲ್ಲ.
ಆದ್ರೂ ಕೊಡ್ಲಿಲ್ಲ.
ನಾವು ರಿಪ್ಲೈ ಮಾಡಿ.
Then 4/10/2019 Malad, we would file the complaint.
4/10/2019 complaint.
Yes.
Summons issue ಆದ್ಮೇಲೆ ನೀವು ಕೊಟ್ಟಿದ್ದ ದುಡ್ಡು?
Please.
ಇಲ್ಲ, ನಮಗೆ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಆಗುತ್ತೆ. ಪ್ರೊಸೀಡಿಂಗ್ಸ್
ಅಲ್ಲ ಅಲ್ಲ, ಯಾವತ್ತು ಕೊಟ್ರಿ
in
ನೀವು?
front of secretary.
When did you
Page
make
number
the payment to
52.
the farmers?
In front of the secretary, we have paid the payment on 13/5/2020. Page number
13/5?
2020.
2 ವರ್ಷ ಯಾಕೆ ವೇಟ್ ಮಾಡಿದ್ರಿ?
ನನ್ನದು ರೀಸನ್
ಅಲ್ಲ,
ಹೇಳಿ.
ರೈತರಿಗೆ ದುಡ್ಡು ಹೋಗದೆ ಹೋದ್ರೆ
ಅಲ್ಲ, ರೈತರ ಹತ್ರ ನಾವು ತಗೊಂಡಿದ್ವಿ, ನಾವು ಬೇರೆಯವ್ರು ಸೇಲ್ ಮಾಡಿ ಅವ್ರ ಕಡೆಯಿಂದ ನಮ್ಗೆ ಅಮೌಂಟ್ ಬಂದ್ಮೇಲೆನೆ ಆ ಚೆಕ್ ಬೌನ್ಸ್ ಕೂಡ ಆಗಿದೆ.
ಅದೇನಾರ ಆಗ್ಲಿ,
ಅದು ಲಾಸ್
ದಟ್ ಇಸ್ ರೈತರಿಗೆ ಅದಲ್ಲ ಲೆಕ್ಕ.
ನಾವು ಅವ್ರ ಹತ್ರ ತಗೊಂಡು ಫಸ್ಟ್ ಪೇಮೆಂಟ್ ಮಾಡ್ಬೇಕು,
If you
ಆಮೇಲೆ ನಾವು
have,
ಸೇಲ್
if you have
ಮಾಡೋದು.
taken agricultural produce from the farmer, you better pay the farmer first. ನೀವೇನಾರು ಮಾಡ್ಕೊಳ್ಳಿ.
ಅಲ್ಲ, ನನಗೆ ಅಮೌಂಟ್ ಸ್ಟಕ್
ಅದೇ
ಆಗಿತ್ತು, ಬಿಸ್ನೆಸ್ ಲಾಸ್. ನಾನು ಅದನ್ನ
stuck
reason
business
ಕೊಟ್ಟಿದ್ದೀನಿ.
loss ಅಲ್ಲ, criminal case straight away. We can't stop the law coming into effect.
Act
In the same
clearly says
proceedings ಅವರೇ ಹೇಳಿದ್ದಾರೆ, ನಾನು
whether
ಕೊಟ್ಟಿರೋ
they have-
ಕಂಪ್ಲೇಂಟ್ ವಾಪಸ್ ಕೂಡ
One commission
ತಗೊಂಡಿದ್ದಾರೆ.
agent ಗೆ ನಾನು ಇಂಟೆಲಿಜೆನ್ಸ್ ತೋರಿಸಿದ್ರೆ
ಅಲ್ಲ, page
ಒಂದು
number
farmer ಗೂ
54
ದುಡ್ಡು
ಅಲ್ಲಿ
ಹೋಗಲ್ಲ.
ಅವರೇ ಕಂಪ್ಲೇಂಟ್ ನ ವಾಪಸ್ ತಗೊಂಡಿದ್ದಾರೆ. ಬಿಕಾಸ್ ನನ್ಗೆ ಹಣ ಬಂದಿದೆ, ನಾನು ಕಂಪ್ಲೇಂಟ್ ನ ವಾಪಸ್ ತಗೋತಿದ್ದೀನಿ ಅಂತ ಅವರೇ ಕೊಟ್ಟಿದ್ದಾರೆ. ಪೇಜ್ ನಂಬರ್ 54 ಅವರೇ ಲೆಟರ್ ಕೊಟ್ಟಿದ್ದಾರೆ
Right.
ಸೆಕ್ರೆಟರಿಗೆ.
No, we can't interpret the law in favor of commission agents.
Even this proceedings also 6/5/2020 proceedings ಅಲ್ಲಿ 4 ಜನ ಡಿಫಾಲ್ಟರ್ಸ್ ಇದ್ದಾರೆ traders. In
That
that
they will
only
do.
two.
That I'll take.
How have you done that?
I'll take instructions. This is the first time.
ಅವರಿಗೆ
Malad,
ಲೈಸೆನ್ಸ್ ಕೂಡ
it
ಕ್ಯಾನ್ಸಲ್
has been
ಮಾಡಿಲ್ಲ,
pleaded.
forfeit
I'll take
ಮಾಡಿಲ್ಲ, ಶಾಪ್
instructions as to
ಇಬ್ಬರಿಗೂ
what
ಮಾತ್ರ
has
ಮಾಡಿದ್ದು.
happened,
The
whether they have filed or
learned
not.
counsel appearing for the petitioner submits that the APMC, ಯಾವ APMC ಇದು?
Bangalore one.
Bangalore APMC is practicing discrimination insofar as default in payment. Default in payment was alleged to the farmers, was alleged against 4 commission agents, but 5
4 Ayush and company, Ishwar
4
traders,
commission
Suresh traders and
agents,
Kenchamba traders.
commission agents, and proceedings are instituted only against 2. The learned counsel Swaroop T submits that if criminal proceedings are not instituted against the others, action will be taken immediately.
I've taken instructions.
It is for the first time coming to the notice of the respondent that such an action is, such discrimination is practiced.
Therefore,
Therefore, let him, therefore the respondent should now seek instructions as to why such a thing has come about. The issue in the list is with regard to payment of commission, payment to be made to the farmers by these commission agents who purchase the agricultural produce from the hands of the farmers. The farmers in the case at hand have given their agricultural produce in the year in November 2018, or the entire transaction happens between September and November 2018. In law, a farmer should be paid immediately. As the farmer would depend upon the agricultural produce for his living, and the commission agent's money that goes to the farmer would be his livelihood. The farmer does not get the amount of the agricultural produce for close to 1 year. He complains to the APMC. The APMC then registers a crime invoking the provisions of the Act, APMC Act on 4/10/2019. After the summons are served in the criminal case, the commission agent comes before the court, before the officer, and makes the payment to the farmer on 13/5/2020. Therefore, there has been delay of 2 years in the farmer receiving his amount for the agricultural produce. The commission agent projects that he had business problems. The business problems of the commission agent is no business of the farmer. He has to get his amount. The learned counsel submits that if this is entertained, it would open Pandora's box, or no commission agent will abide by the law, and as and when he gets money, he would pay the farmer. This cannot be. The submission of this respondent would merit acceptance, albeit prima facie now, till the instructions are sought with regard to the discriminatory treatment as projected. The interim order would continue. List the matter on 12th February.
Much obliged.
February, sorry. Yes.
17.
Appear for the petitioner, my lord.
Hearing for the respondent number 2, your lordship. On the last date of hearing, we had addressed the arguments, and the honorable court had asked for the production of the sale deed in favor of the respondent number 2.
Civil suit hakidira?
Civil suit not against them, my lord. Regarding the second portion of the property, I had subsequently entered into an agreement.
Now, who is in possession of the property?
I'm in possession of the property at the time of event.
Your lordship, that is an incorrect submission. As mentioned earlier, in the same survey number, there are different properties.
I heard this. Why was it not disposed that day?
For the production of sale deed in favor of the respondent, your lordship.
Your lordship, I have revenue extracts pertaining to show of my property.
1 moment, sir. Schedule in a sale deed.
Page number 9 to 13 is the sale deed which is in my favor of the respondent number 2, your lordship.
1 moment, madam. Schedule. Site number 36.
Yes,
That's
your
yours.
Yes, your lordship.
Nimde out, sir.
Yes.
The
LDD, yeah. Mine is, this was a grant certificate granted in 1964. Sale deed, my lord.
Where is the grant certificate?
I could not procure.
Produce the grant certificate with regard to site.
Lord, I have just one submission regarding the property that they're claiming that we have criminally trespassed, because there were 2 portions. One was sold to one Mr. Nagendra, who is my subsequent purchaser, and the respondent number 2 herein is the subsequent purchaser of my subsequent purchase.
So maybe I am
Because
only on this.
in the Maser it is shown.
Offense is 427, 447.
Please, my lord.
It's mischief and trespass.
Please.
If you are in possession of the property, and if you prima facie show possession, there cannot be a trespass against your own property. So you will have to give a document of site number 36 being yours.
Please, my lord.
Or grant certificate, whatever.
Lord, that is my contention, because the property that they've claimed we have trespassed is not even 36/1. That is recorded in the spot Maser.
Where is the complaint?
Please, my lord. If I may direct your lordship's attention to the spot Maser.
No, page 26 is the complaint.
Please.
Spot Maser ಎಲ್ಲಿದೆ ಕೊಡಿ.
Spot Maser is at page number 30. Lordship may see from page number 32, my lord. 32. Where it says Gramada survey number 25 the latter portion of the page.
ಸರ್ವೆ ನಂಬರ್ ಜಮೀನು ಆಗಿದ್ದು ಈ ಜಮೀನಲ್ಲಿ ಖಾಲಿ ಇರುತ್ತದೆ ಅಲ್ಲಲ್ಲಿ ಗೋಡೆ ಬೆಳೆದಿರುತ್ತದೆ ಜಮೀನಲ್ಲಿ ಸೋಲ್ಸ 25/3 ಜಮೀನು ಮುಂದಕ್ಕೆ ಮಾಡಿ ಸೋಲ್ಸ.
Your Lordship, this only mentions the survey number. It does not disclose which
Site number.
Site number it has
My lord,
taken
this is the
place on.
second part of my contention. They are claiming that we have broken into their layout. Because the first portion of the property, they claim it was a layout and a compound was constructed. And here they have clearly given that there was no compound constructed and the portion which they claim where the compound was constructed was in a layout. But there's a clear finding in the spot master that there is no identity of a layout.
All right, where is your grant certificate?
A grant certificate I've requested my party. I've placed the revenue record showing I'm in possession.
All right, contemporaneous documents of that survey number. Where ಏನಿದೆ?
These are the documents I have on.
Where, which document?
Page number 127.
One 127.
127. I've just given a compilation to your lordship.
Oh, no, just she gave. ಇವಾಗ ಕೊಟ್ರ?
I've just handed.
ಇವಾಗ ಏನ್ ಕೊಟ್ರಿ?
So extra copy.
You just now gave it, is it?
Yes,
You just now gave it?
Just.
Oh, madam, just now given.
I'll just hand it 1 second.
You thought of giving it?
Sorry, man.
You thought of giving it or gave it?
I'll peruse the
Yes.
extra. Your lordship may see the first page and the first 7 pages.
25/3.
Please, my lord. 25/3. Oblappa. Which was the propositors of the petitioners hearing.
Yes.
And then page number 3, which is the RTC extract.
Survey number, the survey number.
The second portion, my lord, where it says Mukund bin late Oblappa.
Madam, yours is a layout.
Your Lordship. it is
Layout
a
and
vacant
site number
land.
36.
Yes, Your Lordship. If Your Lordship kindly turns to page number 15 of the document that I have just produced, it shows a vacant land and the boundary also that was constructed by the respondent number 2. There are 2 photos. Now, on the next page, that is page number 16, we show this court may peruse that.
He has entered into this, is it?
Yes, and
He will
destroyed
not
this-
enter into this.
Your
He
Lordship.
will not enter into this. It is not his.
Your Lordship, but that has happened. We have complained to the police immediately after. There is a destruction of the boundary, the fence, and subsequently, this has,
But spot master says 25/3.
that is the survey number, Your Lordship. Site number 36 is in survey number.
Where do I get that?
Your Lord-
Property in 25/3.
25
The
bar,
survey number later.
Survey number, my lord.
that is the survey
My
number.
lord, this is my survey number, the second portion of that property that was sold. So they're saying I have trespassed on my
And
own property.
let the evidence go on.
My lord, I've produced the judgment as well in the compilation
That's
of your
okay,
lordship.
fine, no problem.
Lord, here, I'll just place one submission, my lordship. Here they are claiming that we have trespassed on our own property and the sport master clearly records that there is no layout. They claim their house and their specific
Site number
portion of-
36, where,
Site number
when did
36
you
in a
buy
layout.
site number 36?
As per the page number 13, sorry, 9, Your Lordship, it
Oh,
was
you
purchased.
purchased it from him, is it?
No, Your Lordship.
Then?
Obalappa had, that entire property was divided into 2. Obalappa had sold one portion to one Nagendra Reddy. That has been produced at page number 2, the sale deed from Obalappa. So from the said Nagendra Reddy, we have purchased it. That is at page number 9.
All
So
right.
currently that property is not in the possession of the petitioner at all. He may have another portion of
You
the
filed
property.
a civil
in his-
suit also?
There is no civil suit, Your Lordship. Subsequently, again, they have trespassed, they have attacked the petitioner and their son. And in respect of the same, the criminal proceedings are going on in CC number 8904 of 23. That is currently pending in the court.
That's trial is on in that.
Please, my lord.
ಇದು ಆಗ್ಲಿ ಬಿಡಿ.
My lord, because this portion, even the spot master clearly records there is no layout.
25/3. Spot master is 25/3.
25/3 is a survey number. I occupy the western and the southern portion
No
of the
problem.
survey number.
You
They have a
yourself
different
sold
survey number
it.
where the layout doesn't
You have
exist.
sold it long ago.
My lord, that is
You
exactly.
have
my-
sold it long ago, you want to claim that all over
We're
again?
not claiming that portion. That
Then,
is my
sir-
contention I seek to place before your lordship, that we
Yes,
are not
sir.
in possession of that property. My lord, in the judgment I have produced, paragraphs 13, 16 and 17 lays down, my lord, in terms of possession of your lordship, your lordship's judgment.
I know, if possession is proved,
Please, my lord.
yes, if grant
I produce-
certificate ಅಲ್ಲಿ.
I produced those documents to show my possession, my lord, and the very aspect that this property is not even the property they allege.
Now,
That is
which
theirs
is
that
the
have
second
trespassed.
trespass?
So, yes, your lordship.
Second trespass, which is that?
That is in the objections itself, we have just a minute, your lordship. On 18 March 2023, a complaint was filed, in furtherance of which crime number 108 of 2023 was registered. FIR was registered. Your lordship, the petitioners
Which
have.
page, which page?
Sorry. Page number 9, your lordship, of,
Objections.
sorry, 19, not 9, 19 to 23.
Objections ಹಾಕಿದ್ದೀರಾ madam?
Yes, your lordship.
Where is the objections?
How- It's a petition.
This is 18th March 2020 complaint, is it?
Yes, your lordship. That was the subsequent trespass. And in that, they have also gone and assaulted the
Where is
petitioner and
the
son.
same 25/336, same thing?
Yes, your lordship. Same property.
Yes, sir.
Your lordship, page number 30, in their own very statement, they claim that they purchased serial number 37.
No, this complaint trial is on.
The second complaint trial is ongoing, my lord, in this very case.
Same complaint, same allegation.
Lord, here
447,
in their very own
427, same
statement,
survey number.
in their very own statement, they're given conflicting claims as to their ownership of the property. Lordship will turn to page number 30 of the main petition. If I may read the relevant portion, my lord.
Yes, sir.
Survey number 25/3 ರಲ್ಲಿ site number 37,
ಎಲ್ಲಿದೆ ಅದು complaint ಅಲ್ಲಿ?
page number 30 of the main petition.
But come to the complaint at page 21 of the objections, in which now the trial is on.
Your lordship, just one submission before. Page number 30 is the statement of one Srimati K.C. Layamma, who is saying that she has purchased site number 37. She is not saying that.
Oh, my lord, I'll refer to that statement as well. Even in
No,
the
as simple as that, sir. Second trespass of the same property,
Please,
trial is on. How can the first you say that it is not his property, their property? You have
But
accepted
here the
that.
offense itself is not made out because they're not
You
in
have
possession of the
accepted
property.
it. 36, come to page 21 of the objections, same. ಬೈದು ಹೊಡೆದು so and so. If that is, in that case, trial is on and you have not projected this, that is not the property and other things.
Please, my lord.
This also will go the same way.
My lord, despite my not challenging the second proceedings, it should not adversely impact the proceedings before your lordship is my humble submission, my lord. In terms of the possession of the property, that very layout and the very formation of that land is not made of. They cannot file a complaint and subsequently say, let me figure out whether I'm in possession of the property or whether it's the same property as the trial
They
goes
are
on.
not saying that, that's not their case that they are
Because
not
the
in
spot
possession.
master
of the
clearly says the alleged.
property. 25/3.
Please, ma'am, that's the larger survey number.
Lordship,
ಇವರೇನೆ
this-
ಫೆನ್ಸ್ ಮಾಡಿದಾರಲ್ಲ ಸೈಟ್ ಅವ್ರ ಸೈಟ್ ಅವ್ರು ಫೆನ್ಸ್ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ.
Your lordship.
They haven't anywhere stated in any of the statement that it is their particular property, because spot master says their claims from the
Sale
layout.
deed says 36, sir.
Please, my lord.
36 and 25/3.
But the spot master said there is no layout. Even in their other suit in 2011 that they had filed,
Let
seeking for a
the- let
permanent
the evidence
injunction that
go
was
on.
not recorded.
Let the evidence go on, or you want to file discharge, you can file, or I'll answer it. Yes. The petitioners are before this court calling in question proceedings in CC 11012 of 2022 registered for offence punishable under section 427, 447, 34 of the IPC. The petitioners are accused 1 to 4. The second respondent, the complainant. The complainant and the petitioners are in a squabble with regard to one particular property, i.e. number 36 in survey number 25/3 of so and so. Owing to certain allegations of assault, the second respondent complainant seeks to register a crime in crime number 108 of 2023. for offences punishable under section 341, 504, 323 and 506 of the IPC. The police conduct investigation in the said proceeding and register and file a charge sheet against these petitioners for having trespassed into the property and assaulted the petitioners, assaulted the complainants. The said charge sheet, the charge sheet is not challenged and the trial is on in the said proceeding. Later, the subject complaint forms an earlier complaint to the one that is registered and the trial is on. The allegations are that the petitioners have trespassed into the property of the petition, have indulged in criminal trespass and mischief of the property or belonging to the second respondent on the score that the fence that the second respondent complainant had erected has been destroyed by the petitioners and have entered into the property. The police, idallu charge sheet agidya? The police, after investigation, file a charge sheet in the case at hand as well. The filing of the charge sheet has driven the petitioners to this court in the subject petition. The learned counsel appearing for the petitioner submits that the proceedings are purely civil in nature and cannot be given a color of crime, and it is an abuse of the process of the law for the complainant to invoke the to set the criminal law into motion for the purpose of criminal law into motion on criminal trespass and mischief. The learned counsel appearing for the learned counsel would seek to place reliance upon several judgments rendered on the issue, particularly of this court, where it is said that there cannot be a criminal trespass into one's own property, and had obliterated the proceedings thereon, and seek to place reliance upon several judgments of the apex court to contend that the issue, which is purely civil in nature, cannot now be given a color of crime by the respondents. The learned counsel appearing for the respondent complainant would refute the submission by taking this court through the sale deeds. The petitioner, she would contend that the learned counsel would contend that the petitioners had sold their portion of the property to one Nagendra Reddy. The complainant is a purchaser from the hands of Nagendra Reddy. They are not in possession of the property at all. Not being in possession of the property, they have trespassed into the property, destroyed the fence, and therefore the offense has sprung. After the registration of the impugned crime, the second time trespass was made, and the second crime has resulted in a charge sheet, and the trial is on in the said charge sheet. The learned counsel would contend that the petition be dismissed and trial be permitted to be continued. The learned HCGP would toe the lines of the learned counsel for the complainant for contending that the police, after investigation, have filed a charge sheet, and therefore it is for the petitioners to come out clean in a full-blown trial. The aforementioned narrated facts are not in dispute. The petitioner is said to be a grantee from the scheduled caste grant. When was the grant?
64.
The petitioner is said to be the children of a grantee who was granted land under the provisions of the provisions at the relevant point in time in the year 1964. They claim to be in possession of the said property since then. Owing to the fact that they were in possession of the property, all these petitioners sell the property, i.e. site number 36 in survey number 25/3 to one Nagendra Reddy on 15/5/2004. Therefore, the site number marilva sell the property in survey number 25/3 in and the sale deed has two schedules in it. Therefore, the petitioners prima facie were not in possession of the property. They said Nagendra Reddy sells the property to the complainant in terms of a sale deed on 19th August 2024, 2004, which happens for 3 months after the first sale. It is on this basis the Nagendra Reddy has sold site number 36 in 25/3 to the complainant. The complainants have put up a fence. The fence is said to have been broken now by the act of the petitioners. It is not in dispute that identical complaint had been registered against the petitioners by the very complainant alleging trespass, assault, intimidation. The said crime had sprung from, this said complaint had become a crime in crime number
108 of 2023.
108 of 2023, which is now said to be in which at the trial, the charge sheet is filed by the police and the trial is on. The offences are identical. The plea is identical. The contention that the complainant is in possession of the property is also identical. Now in the second round of trespass or the first round of trespass prior to the earlier trespass, the petitioner wants to contend that he is not, that they have not trespassed into the property of the petitioner. He would seek to place reliance upon a spot mahzar conducted, which depicts that there is no layout formed, there is only vacant land and fence. Vacant land or fence, whatever the case would be. If the petitioners have accepted the first trespass or the first wrongful restraint of the complainant in his own property, the petitioner cannot now blow hot and cold contending that the property does not belong to them or otherwise. The sale deeds prima facie indicate that the petitioners have indulged in such trespass, albeit prima facie, which would require evidence for the petitioners to prove their case before the concerned court. In the first blush, the case that is looked into may appear to be civil in nature. The issue is not with regard to the claim over the land. The issue is with regard to trespass into the property. The criminal trespass into the property is accepted by these petitioners in one proceeding and cannot now be said that they would not, cannot now be said they have not trespassed, and on a specious plea that the property does not belong to the complainant. The reliance placed by the learned counsel for the petitioner to the judgment rendered by this court is on a different circumstance, as it is settled law that there cannot be a trespass into one's own property. The sale deeds quoted supra would prima facie indicate that the petitioner is not in the property. Civil suit hakidira?
That is pertaining to the first portion. That is 1 acre and 4 guntas.
The learned counsel for the petitioner, who's the plaintiff?
The plaintiff is my subsequent, it's
Nagendra Reddy na?
not unrelated to that portion of the property.
Then leave it, yes. So and so. Concerning the subject properties, there is no civil suit pending between the parties. Therefore, the first blush would tumble down that the matter is civil in nature. It's an issue of trespass and 2 proceedings are pending. The police, after investigation, have filed a charge sheet in the case at hand as well. In that light, the petitioners shall now, there is no warrant of interference at this stage in the case at hand. Petition rejected. The observations made in the course of the order is only for the purpose of consideration of the case of these petitioners under 482 of the CRPC, which would not bind the proceedings before the concerned court. Ordered accordingly. Yes.
80.
18, I seek for passover.
I am for the petitioners in this matter, my lord.
I seek for passover.
Government passover kelange.
Jagdish sir, he's honest like my lord, sir. Jagdish sir is on.
Detailed order.
He has got the instructions, my lord, sir. That's it.
Order of cognizance is non-reasoned. We'll send it back.
No, yeah. The spot measure, which is basis for filing the PCR. The spot measure is in page number 40, my lord.
Just Vishwa Shetty or the order.
Alla, adilla.
Alla, new kotrada.
Now got it. Page number 40, the spot measure, which is basis for filing the PCR, my lord. Spot measure was conducted.
Yes. Passover.
Yes.
19.
498A 506, my lord, is against the in-laws, my lord. I request your lordships, my lord, you kindly turn to the complaint. There are no allegation against the in-laws, my lord.
That I am going to quash.
Lord?
Husband ilva?
Husband is our first
Our
petitioner. I will not press that. My lord.
The complainant yaru? Anjan Kumar.
Respond number 2, my lord.
Yes, sir. Anjan Kumar. Yes, Anjan Kumar. Unmute ಮಾಡಿ. Yes, sir.
Respondent already divorced also, my lord.
ಅದು ಗೊತ್ತಾಯ್ತು. ಹಸ್ಬೆಂಡ್ ಯಾವಾಗ ಡಿವೋರ್ಸ್ ಆಗಿದೆ?
Divorce 2017, my lord.
ಆದ್ಮೇಲೆ ಇದು ಬಂದಿರೋದ?
ಅಲ್ಲ, that is the reason for which she lodged a complaint.
2014.
She took up that as a contention before the family court.
Anyway, entry order husband ಕೊಟ್ಟಿಲ್ವಾ?
ಇಲ್ಲ, husband ಇಲ್ಲ. ಅಲ್ಲ, ಯಾರಿಗೂ ಕೊಟ್ಟಿಲ್ಲ ಸ್ವಾಮಿ ಅದಕ್ಕೆ.
ಯಾರಿಗೂ ಕೊಟ್ಟಿಲ್ವಾ?
I came in on record subsequently, my lord. Earlier council was not completed the office objection.
Fresh matters list. ಬರೀ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಅಲ್ಲೇ ಇದೆ.
He came on record subsequently, my lord.
ಡಿವೋರ್ಸ್ ಆಗಿದೆ ಈಗ?
ಆಗಿದೆ. I produced the copy of it. Page number 59, my lord.
Let them come, but cricket battle ಹೊಡೆದು ಬಿಟ್ಟಿದ್ದೀರಾ ಅಂತಿದೆ.
ಅಲ್ಲ, ಅದನ್ನ ಗಿವ್ ಅಪ್ ಮಾಡಿದ್ದಾರೆ ಸ್ವಾಮಿ. Kindly go to page 36, my lord. She says that battle ಹೊಡೆದ್ರು ಅಂತ ಹೇಳಿದ್ದು, ನಾನು vengeance ಇಟ್ಕೊಂಡು ಹೇಳಿದ್ದು ಅಂತ. Page 36, my lord. Second para, last 4 lines, page 36. ಬ್ಯಾಟ್ ಇಂದ ಹೊಡೆದು ಬರೀ ಕೈಗಳಿಂದ ಹೊಡೆದಿರುತ್ತಾರೆ, ಆದರೆ ನನ್ನ ಗಂಡ ಮತ್ತು ಅತ್ತೆನೇ ಕಿರುಕುಳ ನೀಡುತ್ತಿರಿಂದ ಈ ತರ ಕೊಟ್ಟಿದ್ದೀನಿ ಅಂತ ಹೇಳಿದ್ದಾರೆ.
ನೋಡಿ, let him come. ಈಗ ಯಾವ ಸ್ಟೇಜ್ ಅಲ್ಲಿ ಇದೆ?
It is summons is issued, my lord.
In-laws we will stay.
Please.
Not the
In-laws quotas. I'll press for that.
Heard the learned counsel appearing for the petitioners. The petitioners are accused number 1 to 4. The husband, mother-in-law, father-in-law, and inyaru?
ಅಷ್ಟೇ.
3 ಅಷ್ಟೇ. 1 to 3. Husband, father-in-law, and mother-in-law. The learned counsel for the petitioner submits that the family court has already granted divorce in the year 2017 and they are living separately. The present proceeding is of the year 2015 in CC 22590 of 2015. Though divorce is granted and the crime had sprung earlier, I deem it appropriate to grant further proceedings, stay of further proceedings only against the second petitioners 2 and 3, finding no allegations against them. While certain allegations are present against the accused number 1, the learned counsel submits that he would not press the petition qua accused number 1. Therefore, petition against accused number 1. ಎಲ್ಲ ಅವ್ರು ಬಂದ ಆಮೇಲೆ ಇರ್ಲಿ. Insofar as accused number 1 is concerned, the same would be considered after the appearance, after hearing the counsel appearing for the respondent. List the matter on 10th February. 10th February.
Yes.
20.
This is representative petitioner, my lord. Petitioner is the accused number 1, my lord. Alleged offences are 406, 420, and 34, my lord. My lord, facts of the case, the FIR is at page number 22, my lord. Complaint is at page number 22, my lord. The case of the prosecution is the respondent number 2 was looking for financial assistance. In that case, accused number 2 had contacted the complainant and conducted.
I'll file a detailed objection, my lords.
3 ವರ್ಷ ಆಗಿದೆ.
And my lord, it is covered with lordship judgment
the last week.
And also, my lord, Once,
served
ನಾನು
only the
submission
last
ಮಾಡ್ಬಿಡ್ತೀನಿ
week.
ಸ್ವಾಮಿ. I will complete my submission.
ಹೇಳಿ ಹೇಳಿ. ಸ್ಟೇ ಇದೆಯಲ್ಲ?
Covered by your lordship, but
ಸ್ಟೇ ಇಲ್ವಾ?
stay ಇಲ್ಲ ಸ್ವಾಮಿ.
ಏನ್ ಹೇಳಿ?
It is covered by your lordship, but
ಆಯ್ತು, ಏನು KPID ಇದೆಯಾ?
ಇಲ್ಲ ಸ್ವಾಮಿ.
No, no.
Bari 406,
420, my lords.
My lord, they have made these persons as accused. The amount is transferred to the company, not to the personal capacity of these directors. My lord, the recent judgment of the Honorable Supreme Court in Anil Khandelwal and Phoenix, my lord, that I have produced before the lordship, and also, my lord, they have also, while filing they have also filed a PCR for checkbones case, wherein they have made the company as a party. Whereas in this particular case, they have not made a company as party. Your lordship is aware that Anil Hada and the recent judgment, when the company is not made a party, the entire complaint.
ಅಲ್ಲ, ಯಾರು ಇವ್ರ ಅಕೌಂಟ್ಗೆ ಹೋಗಿದ್ಯಾ ದುಡ್ಡು?
ಇಲ್ಲ, company ನನ್ನ
ಒಂದ್ ನಿಮಿಷ
account
wait.
To the company account, my lords. What happened?
Company
They
account.
came and
Then
told
how
us
are
that
they
they are giving us loans, my lords, with the, I mean, with lesser interest. So, my lords, I sought for loan of about 25 crores. They said that, my lords, there is something called processing fees, and they went on to collect 38 lakhs from me, my lords. Subsequent to which, when I started following up, they closed the office, they went.
Who company?
My lords, the directors were the ones who were in touch with me. They have closed the
Office
office,
close
my
ಮಾಡಿದ್ರಾ?
lords. Oh, the office closed ಮಾಡ್ಕೊಂಡು ಹೋಗಿದ್ದಾರೆ. I went on to follow up with them. Then I got to know that they have shifted their office somewhere else. When I went to that place, my lords, they are saying that, no, if you want to go, you file a complaint. Nothing can be done.
That's all right.
Subsequent which, my lords, that office was also closed.
ಈಗ
Now, my lords,
38 ಲಕ್ಷ ತಗೊಂಡಿದ್ದೀರಾ?
25 lakhs ಸ್ವಾಮಿ.
ಕೊಟ್ಬಿಡಿ.
38 lakhs.
ವಾಪಸ್ ಕೊಟ್ಬಿಡಿ.
ನನ್ನ ಅಕೌಂಟಿಗೆ ಬಂದಿಲ್ಲ ಸ್ವಾಮಿ. If your lordship go to
ನಿಮ್ಮ
the
account
complaint,
directors
the
ಅಲ್ವಾ?
entire allegations made against
ಈ
the
ಕಂಪನಿ ಕ್ಲೋಸ್ ಆಗಿದೆಯಾ?
ಇಲ್ಲ ಸ್ವಾಮಿ, it is running ಸ್ವಾಮಿ.
ಎಲ್ಲಿದೆ? Where is the company function?
In MG Road in Bangalore only ಸ್ವಾಮಿ.
My lord,
And
this is a shell company
they
that
have
they have
initiated
created
checkbones case, my lord.
with the mensria,
They
my
have
lords.
Wait, sir.
They have initiated checkbones case where the accused people are regularly appearing before the court, my lord, and it is posted for the cross-examination. And if the court comes to the conclusion I have to pay, I will definitely make the payment. But this particular case, my lord, there is a lacuna in this, my lord. My lord, they have not made a company as a party.
ದುಡ್ಡು ತಗೊಂಡಿದ್ದೀರಲ್ಲ?
Swami, ಕೊಡ್ತೀನಿ ಸ್ವಾಮಿ, but that in this particular criminal case, my lord, your lordship judgment is covered, my lord.
No, we'll see. Yes.
Your lordship judgment is covered, my lord. I'm here giving the citations, my lord. And
My lords, I'll file a detailed objection.
ಫೈಲ್ ಮಾಡಿ.
And the private complaint which they have filed, that also have filed, my lord.
ಕೊಡಿ ಮೇಡಮ್.
Muniappa judgment and also Honorable Supreme Court judgments are also there. Recent judgment, my lord, 2025, my lord.
I'll also place judgments on record, my lords. Next day.
Wherein it has been clearly mentioned when the company is not made a party, the complaint is liable to
ಇಲ್ಲಿ ಕಂಪನಿ ಪಾರ್ಟಿ ಮಾಡ್ಬೇಕಾಗಿತ್ತು, ಯಾಕೆ ಮಾಡಿಲ್ಲ?
My lords, in the complaint, I have mentioned the company's name at least thrice,
So,
my lords.
they have not
Police
made a
have
party.
not- was registered.
charge sheet
The FIR
ಆಗಿದೆ.
was registered.
Charge sheet ಅಲ್ಲಿ ಹೇಳಿಲ್ಲ ಸ್ವಾಮಿ.
Charge sheet is also filed.
ಸ್ವಲ್ಪ ಸುಮ್ನೆ ಇರ್ತೀರಾ ಸರ್?
Yes,
ಅವ್ರನ್ನ ಕೇಳಿ. ಅಲ್ಲ, ಇದರಲ್ಲಿ ಕಂಪನಿ ಹೇಳಿದಿರಾ?
ಹೇಳಿದ್ದೇನೆ. Kind look into the complaint, my lords, in page 22. My lords, in the third, in the fourth line, my lords. 2019ನೇ ಸಾಲಿನಲ್ಲಿ ಕಾಸಿಯಾ ಭವನದಲ್ಲಿ ಪ್ರೊವಿನ್ಸಿಯೋ ಕ್ಯಾಪಿಟಲ್ ಅಡ್ವೈಸರ್ ಪ್ರೈವೇಟ್ ಲಿಮಿಟೆಡ್ ಕಂಪನಿಯ ಮಾಲೀಕರಾದ ಮೋನಿಶ್ ಆನಂದ್ ರವರು ಕಡಿಮೆ ಬಡ್ಡಿಯಲ್ಲಿ FDI ಮೂಲಕ ಸಾಲ ಕೊಡಿಸುವುದಾಗಿ ಸೆಮಿನಾರ್ ಅನ್ನು ಮಾಡಿರುತ್ತಾರೆ. After that, my lords, in lot of other places I have mentioned the company's name, saying that they are the directors of this of the said company.
And the allegation
However,
is
my
made
lords, when the
against
FIR
accused
came to
two,
be
my lord.
registered,
Manish
company
Anand
was
is the
not
accused
made
number
the
2.
accused.
Manish Anand is accused number 2. This petition is accused number 1. And it is accused number 2 has made a
ಈಗ
conference.
ಯಾವ್ದಕ್ಕೆ ತಗೊಂಡ್ರು ದುಡ್ಡು? ಕಮಿಷನ್ ಯಾವ್ದಕ್ಕೆ?
My lords, it is in so far as FDI loans, my lords, processing charge ಅಂತೇಳಿ ಹೇಳಿ. ಅದರಲ್ಲಿ GST ಕೂಡ ಬಂತು ಸ್ವಾಮಿ. There is TDS also, and there is certain service charges.
So 38 lakh service
38
charges.
lakhs is the service charges that they have taken.
ಆಮೇಲೆ
However,
ಏನ್
the loan was not availed.
ನಿಮಗೆ ಏನ್ ಬಂತು? ಲೋನೇ
ಏನು
ಬರಲಿಲ್ಲ.
ಬರ್ಲಿಲ್ಲ. When they went on to follow up, when we went on to follow up, my lords, that is when they closed the office and they went.
My lord,
Not
it is
only for
making
us, my
a-
lords, there are several other people who have been defrauded.
Where did they project that they would get you loan?
My lords, in one of the seminar in.
File your objection.
Please.
My lord, instance, because the company, they, my lord, the
For us.
judgment is very clear, my lord.
Maybe.
Your lordship judgment is there.
Maybe, yes. ಯಾರು ಅಮಾಯಕರಿಗೆಲ್ಲ ದುಡ್ಡು ತಗೊಂಡು ಲೋನ್ ಕೊಡಿಸ್ದೆ ಇದೆಲ್ಲ ಏನು?
My lord, they have initiated the process, other proceedings, my lord. Check bounce proceedings, wherein
ಅದ್ ಮಾಡಿ
in page number 151, it is clearly stated, my lord.
No, yes. But let him file his objection.
Yes, my lord. Okay, okay.
The learned counsel Akash P. Shetty seeks 2 more weeks' time to file statement of objections. As a last chance, lest this matter on 17th February. In the event objections would not be filed by then, the petition would be answered on hearing the counsel appearing for the petitioner and the respondent on the score that there are no objections to be filed to the petition. Yes.
Much obliged.
21.
These are proceedings, my lords.
ಗೊತ್ತಾಯ್ತು. Partnership. Difficult, Rajat.
Please, my lords, my only submission is this, my lords. The onus is on the complainant to first make an averment as to how I am involved into the day-to-day affairs of the company. And there are.
Company ಅಲ್ಲ ಇದು partnership firm.
Please, my lords, the partnership. firm.
Company ಆದ್ರೆ that argument is acceptable. Partnership firm ಗೆ I'm afraid it's.
But the judgment, my lords, I am relying upon is, my lords, Sunita Palita and others versus Panchami Stone Quarry. There they very specifically specify, my lords, how the liability is attracted. My lords, in a situation where, my lords, the criminal liability is attracted against a partner, the ramifications are quite vast, my lords. And this judgment would specifically read, my lords, as to how in civil cases, yes, they may be jointly and severally liable. But so far as a partnership firm is concerned, now one act of the partner cannot be equated with all the acts of the partners. That's I understand, my lords, Dilip Hariramani and subsequent judgments, that one judgment goes against me. Fact remains, my lords, all these judgments are passed.
2025-10 goes against.
That is there, my lords. Even today, my lords, I'm given to understand by my clients that the amount in dispute is 9,60,000.
ಅಷ್ಟೇನಾ?
That's all is the amount. I am willing to give the amount and if they are willing to settle it. But they can't keep a sword hanging on my wife and then use that as a pressure tactic to, my lords, push me towards settlement.
If they made a payment.
And my lords, complainant is no more. They are now his legal hairs are.
Now
to come
both
on
of you
record.
sit across, settle, close it.
9,60,000, my lords. Tomorrow I'll make the payment. I have no problems.
Because it is the purchase, the bills are there.
ಆಯ್ತು ಕೊಡ್ತೀನಿ ಅಂತ ಹೇಳ್ತಾ ಇದಾರಲ್ಲ.
I have no, but they can't talk 15 lakh rupees out of court and say, we'll settle it. Whatever is the
You
principle.
sit across and arrive at a figure and settle it.
We will
It's
do
a
it.
settleable issue. Complainant ಇಲ್ಲ ಆಗಿದೆಯಾ, and what's this word you want to project?
My client is present. If they are agreed that, no.
Rajat, you sit and arrive at some figure. All right. I'll take it on 5th. 5th illa, 3rd February 23.
Please.
I'll take it on that day, sit across, settle it.
Please.
It's better to settle.
My lords, this fastening of
Otherwise,
criminal
law
liability-
is difficult.
Please. Understood. Please.
Yes. List on 3rd February.
22.
Petitioner, my lords. Copies will be served, my lords. Copies will be
ಕೊಟ್ಟಿಲ್ಲ.
served, my lords. My senior is not well, my lord. BP fluctuation ಆಗ್ತದೆ. ನಿನ್ನೆ VC ಲಿ appear ಆಗಿದ್ರು.
BP fluctuation. Every minute ಆಗ್ತಾ ಇರುತ್ತೆ ನಮ್ಗೆ. Yes.
1 week time, my lords. We'll serve the copy and.
All right, yes. 22 ಅಲ್ಲ? List the matter on 10th February.
Lords, interim order.
Interim order subsisting will continue. Copy ಕೊಡಿ.
Yes, my lords.
Petitioner to serve set of papers upon the council for the respondent. Next. Yes. ನಿಮ್ಮ ಹೆಸರೇ ಹಾಕಿಲ್ಲ ಇಲ್ಲಿ? ಹಾಕಿದ್ಯಲ್ಲ? Yes.
ಹಾಕಿದೆ ಅದು it's 22 ಅಲ್ಲಿ I have to file ವಕಾಲತ್.
ಹಾಕ್ಬಿಡಿ.
He is not well, he could not come and file.
Next.
23.
23 I pay for petitioners, my lord. But this 490K offense, my lord. My lord, first petition is petition numbers accused number 6 and 7, my lord. My lord, second petition is, my lord, domestic violence petition, my lord, against the in-laws, my lord. Third petition is one more 498A offense, my lord.
More petition now?
Yes, my lord.
In package?
Package ಆಗಿದೆ, my lord. Because.
My lord, my lord's
one by one ಬನ್ನಿ ಈಗ. First petition ಏನು?
My lord, I will go to second petition.
Serial number ಏನಿದೆ?
23, my lord.
23 ಒಂದೇ ಇದೆ.
My lord, it has been connected, my lord.
23 ಒಂದೇ ಒಂದಿದೆ ಇಲ್ಲಿ.
No, my lord, it has been connected, my lord.
It has come in the list, my lord, 23.
Yes, my lord.
ಎಷ್ಟಿದೆಯಾ?
23.1.
ಓ ಸರಿ ಸರಿ ಕೊಡಿ.
My lord, I will go with 7107 of 2022. That is the first petition, my lord.
All right.
In the year 2022.
Now come to ಯಾವುದು 7107
7 of 2022.
All right, yes sir. ಇದು ಏನು offense?
Domestic violence.
DV Act.
DV Act, my lord.
ಆಮೇಲೆ 8453 ಏನು?
Lord, 8720. My lord, 8453 also, 498 and 307, my lord.
498A 307.
Yes, my lord. 8720, my lord, it's 498 and 323.
323. 8239.
My lord, 8239 is other accused in the 498 and 307, my lord.
ಯಾವುದು ಫಸ್ಟ್ ಮಾಡಿ?
7107, my lord.
ಯಾಕೆ ಡೊಮೆಸ್ಟಿಕ್ ವೈಲೆನ್ಸ್?
Yes, my lord. My lord's interim order, my lord.
ಆಯ್ತು ಸರಿ.
My lord, I would show how the complaint has been manipulated.
ನಾವು ಫಸ್ಟ್ ಒಂದ್ ನಿಮಿಷ ಗೋ ಟು ದಿಸ್ ಇದು ಕೊಡಿ ಮೇಡಮ್. 8453 ಕೊಟ್ಟಿದ್ದೀರಾ? 307. 307 ಯಾರ ಮೇಲೆ?
It's husband, my lord. There's a wound certificate, my lord. Also, in the last time, my lord, wound certificate says she herself states against the husband. Subsequently, after 3 days, my lord, a complaint comes to be registered. 27, the incident takes place, my lord. 27, she goes to the
31st is the complaint.
31st, my lord, it's a title complaint, my lord, where she alleged against all sister-in-laws.
Anyway, accused 6 and 7 ಇದರಲ್ಲಿ ಅರ್ಮೇನಿಲ್ಲ. Will quash it.
Please see the complaint, my lord.
Yes sir. ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿದೆಯಾ? ಸರಿ. ಕಂಪ್ಲೇಂಟ್ ಬನ್ನಿ ಸರ್.
Complaint, my lord, second, where the allegation starts.
One moment.
My lord,
Procedural and
Kishore, my lord.
one ನಿಮಿಷ.
There's a sons of sister-in-law.
One moment. ಇವ್ರ ಮೇಲೆ ಎಲ್ಲಿದೆ?
Please, my lord.
One minute. ಬಂದು ನನ್ನ ಗಂಡ ಕೃಷ್ಣರಾಜ ಮಗನಾದ ಪ್ರಜ್ವಲ್ ಏಕಾಗಿ ಒಂದು ಮನೆ ಖಾಲಿ ಮಾಡಿ ಅಷ್ಟು ಬಿಟ್ಟು ಏನಿದೆ?
Second page where he says.
My lord, Prajwal, my lord, he says that he is an advocate. My lord, what he says is when the husband and sister-in-laws, my lord, attempt to assault her, he says, I am an advocate, I'll save you in the court. That is what, my lord, he says, and he also joins the crime. That is what, my lord, is the complaint. Please see, my lord, in the middle portion. ಆ ಸಮಯದಲ್ಲಿ ನನ್ನ ಗಂಡ ಕೃಷ್ಣ ಮತ್ತು ಅವನ ತಮ್ಮ ಶ್ಯಾಮ್ ಸುಂದರ್ ನನ್ನನ್ನು ಕಾಲಿನಿಂದ ಒದ್ದು ಕೆಳಗೆ ಬೀಳಿಸಿದ್ದು. ಆಗ ರಾಜಣ್ಣನವರು ಈ ಸೋನ್ಸೋ ಸಾಯಿಸು ಎಂದು ಕುಮ್ಮಕ್ಕು ಕೊಟ್ಟಾಗ ಪ್ರಜ್ವಲ್ ಎಂಬುವನು
ಕುಮ್ಮಕ್ಕು ಕೊಟ್ಟಿದ್ದಾರೆ.
ಪ್ರಜ್ವಲ್ ಎಂಬುವನು ಕೋರ್ಟಿನಲ್ಲಿ ನಾನು ನೋಡಿಕೊಳ್ಳುತ್ತೇನೆ ಹೊರಗೆ ಹಾಕಿ
ಕಿಶೋರ್
ಅವಳನ್ನು
ಸಿ
ಹೇಳಿತ್ತು. Please.
A6 A7.
They are the, my lord, children of the sister-in-law of the complainant. It is at his instigation, my lord, the incidents has taken place.
ಆಮೇಲೆ
And further, my lord,
this is 498A 307.
please. Further, my lords, may
ನೀವೇ
kindly.
ಹೇಳ್ಬಿಡಿ ಎರಡಕ್ಕೂ ಅಪ್ಲೈ ಆಗುತ್ತೆ. 6 and 7
Yes,
ಆಗುತ್ತೆ.
please. My lords, may kindly.
498 ಆಗುತ್ತೆ, 3 and 7 ಆಗುತ್ತೆ.
ಇನ್ನೊಂದು I just want to point out to my lord. Next para, my lords, may kindly skip the next para. And further, my lord,
ಮನೆಯಿಂದ ಮರದಿಂದ
ಇದಕ್ಕೂ ಮುಂಚೆ ಅಲ್ಲಿಂದ
ಇನ್ನೂ ಇದೆಯಾ?
ಇನ್ನ ಇದೆ. ಇದಕ್ಕೂ ಮುಂಚೆ ಅಂತ ಸ್ಟಾರ್ಟ್ ಆಗುತ್ತೆ.
ನಾನು ಲಾಯರ್ ಇದ್ದೇನೆ, ಏನು ಮಾಡುವುದಿಲ್ಲ, ಬೆದರಿಕೆ ಹಾಕುದು ಎಲ್ಲಾ ಕಾರಣಗಳಿಂದ ನನ್ನ ಮಗಳನ್ನ.
ಆಗ ಆ ಸಮಯದಲ್ಲಿ ನನ್ನ ಗಂಡ ಕೃಷ್ಣನು ಪ್ರಚೋದನೆಗೊಂಡು ಒಂದು ದೊಣ್ಣೆಯನ್ನು ತಂದು ನಿನ್ನನ್ನು ಸಾಯಿಸುತ್ತೇನೆ ಎಂದು ಮನ ಬಂದಂತೆ ದೊಣ್ಣೆಯಿಂದ ಕೈ, ಕಾಲು, ತೊಡೆ, ಬೆನ್ನು ಎಲ್ಲಾ ಕಡೆ ಸಾಯುವ ರೀತಿಯಲ್ಲಿ ಹೊಡೆದು ನಾನು ಕೆಳಗೆ ಬಿದ್ದ ನಂತರ ಮತ್ತೊಮ್ಮೆ ಎಲ್ಲರೂ ನನ್ನನ್ನು ಒಬ್ಬೊಬ್ಬರಾಗಿ ಕಾಲಿನಿಂದ ಮತ್ತು ನನ್ನ ಗಂಡ
ಅದು ಗೊತ್ತಾಯ್ತು ನೋಡಿದೆ.
ಅದಾದ್ಮೇಲೆ ಅದ ನೆಕ್ಸ್ಟ್ ಪ್ಯಾರ ಸ್ಕಿಪ್ ಮಾಡಿ ಫರ್ದರ್ ಮೈ ಲಾರ್ಡ್ಸ್ ಮೈ ಕೈಂಡ್ಲಿ ಸಿ. ಇದಕ್ಕೂ ಮುಂಚೆ ಹಿಂದಿನ ದಿನ ನಾನು ಗೋಧಿಯನ್ನು ಒಣ ಹಾಕಿದ್ದಾಗ ಅದಕ್ಕೆ ನನ್ನ ಗಂಡ ಕೃಷ್ಣ ಮತ್ತು ಶ್ಯಾಮ್ ಸುಂದರ್
ಶಾಲೆಯಲ್ಲಿ ಇಲ್ಲ ಇವ್ರ ಮೇಲೆ ಏನು ಅಂದ್ರೆ ಪ್ರಜ್ವಲ್ ಮೇಲೆ ಪೇಜ್ 23 ಎಲ್ಲದಕ್ಕೂ ಅಷ್ಟೇ ತಂದೇನಿ ಇದಕ್ಕೂ ತರ್ತೀನಿ ಅಂತ
ಅಷ್ಟೇ
ಕೊಟ್ಬಿಟ್ಟಿದೀವಲ್ಲ. 6 and 7. So 6 and 7 children of sister-in-law out.
Yes.
All right. Next in ಉಳಿದಿರೋದು ಯಾರು? Now DV Act we'll see later. 8720. Why second 498A? Yes, Abhinav. Second 498A ಯಾಕೆ? ಒಂದು ಹಾಕಿತ್ತಲ್ಲ ಆಲ್ರೆಡಿ. Why second one? ಅದ್ರಲ್ಲಿ ಯಾರು ಅಕ್ಯೂಸ್ಡ್?
sister-in-law's husband. Now
ಇದರಲ್ಲಿ
ಡಿಫರೆಂಟ್ ಅಕ್ಯೂಸ್ಡ್ ಅಷ್ಟೇ. ಡಿಫರೆಂಟ್ ಅಕ್ಯೂಸ್ಡ್
Husband
ಸೇಮ್ ಕ್ರೈಮ್.
different crime, same accused.
Lord, husband, brother-in-law, sister, two sister-in-laws.
ಯಾವ್ದ್ರಲ್ಲಿ?
8720.
8720 ಕೊಡಿ.
Madam.
8720.
Page number 14 is the rank of the
My lord, in 8720, my lord, Rajanna, my lord, is the husband of the second petitioner. That is, first petitioner is the husband of the second
Order
petitioner.
sheet is bigger than the petition.
The first petitioner, my lord, in the petition is the husband of second petitioner. And second petitioner happens to be the sister-in-law of complainant.
ಈಗ ಇದರಲ್ಲಿ ಹಸ್ಬೆಂಡ್ ಇಸ್ ರಾಜಣ್ಣ.
No, husband is Krishna.
ಅಲ್ಲ ಅಲ್ಲ ಹೂ ಇಸ್ ದಿಸ್ 8720 ಅಲ್ಲಿ
He is the husband of
ಒಂದು ನಿಮಿಷ ಸರ್. ಕಂಪ್ಲೇನೆಂಟ್ ಏನ್ ರಿಲೇಷನ್ ಸರ್?
sister-in-law's husband.
ಸೆಕೆಂಡ್ ಇಸ್ ಸಿಸ್ಟರ್ ಇನ್ ಲಾ, ದಿಸ್ ಇಸ್ ಹಸ್ಬೆಂಡ್.
Yes, madam.
ದಿಸ್ ಪದ್ಮಾವತಿ ಯಾರು?
Sister-in-law, madam. She is no more.
ನೋ ಮೋರ.
But Sam, my lord, had not given the interim order. They have investigated, they filed the charge sheet. He is before trial court.
So that is not there now. This is over. ಇನ್ನು ಉಳಿದಿರೋದು ಸಿಸ್ಟರ್ ಇನ್ ಲಾ ಅಂಡ್ ಹಸ್ಬೆಂಡ್. ರಾಜಣ್ಣ ಅಂಡ್ ಲಕ್ಷ್ಮೀ ದೇವಿ. ಅವ್ರೇನ್ ಮಾಡಿದ್ದಾರೆ ಸ್ವಲ್ಪ ಹೇಳಿ.
And Sham Sundar.
ಶ್ಯಾಮ್ ಸುಂದರ್ ಇಲ್ಲ, he is not pressing.
Yes. Yes. Rajanna. My lord, please take my lord page 21. Page 17, my lord.
Page 19 is the allegation. There are.
Page 18 ಅಲ್ಲಿ in the middle portion, my lord. ಹಣ ತೆಗೆದುಕೊಂಡು ಇಟ್ ಸ್ಟಾರ್ಟ್ಸ್ ಫ್ರಮ್ ದೇರ್. ಹಣ ತೆಗೆದುಕೊಂಡು ಬರಲು ಬೈದು ಹಿಂಸೆ ನೀಡಿ ಸುಮಾರು 3 ಲಕ್ಷ ಹಣ ಮತ್ತು 20 ಗ್ರಾಂ ಬಂಗಾರವನ್ನು ಕೊಡು 2014ರಲ್ಲಿ ನಮಗೆ ವಿಹಾ ಎಂಬ ಹೆಣ್ಣು ಜನಿಸಿತು. ಮನೆಯನ್ನು ನೋಡಿಕೊಳ್ಳದ ಕಾರಣ ಆಗಾಗ್ಗೆ ನನಗೆ ಗಂಡನಿಗೂ ಜಗಳವಾಗುತ್ತಿತ್ತು. 2018ನೇ ಸಾಲಿನಲ್ಲಿ ಒಂದು ದಿನ ಬಂದು ನನ್ನ ಜೊತೆ ಜಗಳ ಮಾಡಿ ಕೈಗಳಿಂದ ನನ್ನನ್ನು ಮನಸ್ಸು ಇಚ್ಛೆ ಹೊಡೆದು ಕಾಲಿನಿಂದ ಒದ್ದು ಸೋಣ್ಸು, ನನಗೆ ನೆಮ್ಮದಿಯೇ ಇಲ್ಲ, ನನಗೆ ಸೋಣ್ಸು ಅಂತ ಹೇಳಿ ನಿನ್ನನ್ನು ಸಾಯಿಸಿ ಬಿಡ್ತೀನಿ ಎಂದು ಬೈದು 2022ನೇ ಏಪ್ರಿಲ್ ತಿಂಗಳಿನಲ್ಲಿ ನನ್ನ ಅತ್ತೆಯವರು ತೀರಿಕೊಂಡ ಮೇಲೆ ನನ್ನ ಗಂಡನಿಂದಲೂ ಜಗಳ ಮಾಡಿ ಸೋಣ್ಸು ಎಂದು ಹೇಳಿ ನಾವು ಪೇಜ್ 19 my lord ಡೈವೋರ್ಸ್ ಕೊಟ್ಟಾಗ ಎಂದು ಬೈಯುತ್ತಿದ್ದರು. ಅಲ್ಲದೆ ನನ್ನ ಮೈದುನನಾದ ಶ್ಯಾಮ್ ಸುಂದರ್ ಕೂಡ ಇತ್ತೀಚೆಗೆ ನನ್ನ ಗಂಡ ಬಯಲು ಪ್ರಾರಂಭಿಸುತ್ತಾರೆ. ಹೀಗೆ ಸುಮಾರು 3 ವಾರದ ಹಿಂದೆ ನಾನು ಮನೆಯಲ್ಲಿರುವಾಗ ನನ್ನ ಗಂಡ ಮನೆಗೆ ಬಂದು ಜಗಳ ತೆಗೆದಿದ್ದು ನನ್ನ ಎಡಗೈಯನ್ನು ಹಿಡಿದುಕೊಂಡು ತಿರುಚಿ ಗಾಯಪಡಿಸಿರುತ್ತಾನೆ. ಅಲ್ಲದೆ ನಾನು ಊಟದಲ್ಲಿ ಏನೋ ಬೆರೆಸಿರುತ್ತೇನೆ.
Husband and that Sham Sundar will face trial.
Yes.
Yes. All others I will quash. One is no more. DV Act ಆಮೇಲೆ ಬರೋಣ.
ಅಲ್ಲ, ಸಿಸ್ಟರ್ ಇನ್ ಲಾ ಮೇಲೂ ಇದೆ my lord.
ಪದ್ಮಾವತಿ.
ಲಕ್ಷ್ಮೀ ದೇವಿ.
ಏನಿದೆ?
ಅದೇ ಅಲ್ಲದೆ ನನ್ನ ನಾದಿನಿ ಲಕ್ಷ್ಮೀ ದೇವಿ ಗಂಡನಾದ ರಾಜಣ್ಣ ಎಂಬಾತನು ನಮ್ಮ ಮನೆಗೆ ಬಂದು ಡೈವರ್ಸ್ ಕೊಟ್ಟು ಹೋಗೋಕೆ ಏನು ರೋಗ ಎಂದು ನನ್ನ ತುಂಬಾ ಹಿಂಸೆ ನೀಡಿರುತ್ತಾರೆ. ಅಲ್ಲದೆ ನನ್ನ ಗಂಡನ ಹೆಸರಿನಲ್ಲಿದ್ದ ಆಸ್ತಿಯನ್ನು ನಾದನೀಯವರಾದ ಪದ್ಮಾವತಿ ಲಕ್ಷ್ಮೀದೇವಿ ರವರು ನನ್ನ ಅರಿವಿಗೆ ಇಲ್ಲದಂತೆ 2018ನೇ ಸಾಲಿನಲ್ಲಿ ತಮ್ಮ ಹೆಸರಿಗೆ ಮಾಡಿಕೊಂಡಿರುತ್ತಾರೆ.
ಅದು 498 ಆಗುತ್ತೆ. 307 ಆಗುತ್ತಾ? 323 ಆಗುತ್ತಾ? ಯಾವುದು ಆಗಲ್ಲ. 1 and 4, yes. 1 and that accused number 2, yes. They have indulged in all the offences. Husband stay ಇಲ್ಲ ಅಲ್ಲ ಇಲ್ಲಿ? Husband ಇಲ್ವಾ ಇಲ್ಲಿ?
Husband.
ಆಯ್ತು, ಒಂದೊಂದು ಆಗ್ತವ. First to take this criminal petition. ಇಲ್ಲ ಬರುದಲ್ಲ. Criminal petition 8720 of 2022. The subject petition, the petitioners accused A2345 are before the court calling in question proceedings, registration of a crime in crime number 130 of 2022 registered for offences punishable under section 506, 34, 498A and 498A, 504, 506 of the IPC. During the subsistence of the petition, the third petitioner, accused number 3, is no more. Therefore, the crime has stood abated qua accused number 3, one late Srimati Padmavati. Who remain in the fray is accused number 5, 2, 4 and 5. Therefore, the petition is answered qua accused 2, 4 and 5. Before entering upon the merit of the matter, I deem it appropriate to notice the relationship between the protagonists of the less. The second respondent is the complainant, wife of one S. Krishna, accused number 1, who is not before the court. The first petitioner, accused number 5, and the second petitioner, accused number 4, are the sister-in-law and her husband of the complainant. The fourth petitioner, accused number 2, is said to be the brother-in-law of the complainant. Marriage between the second respondent complainant and one Krishna, the accused number 1, takes place on
2009, my lord.
In the year 2009. The relationship between the two flounders. On floundering of the relationship, the complainant registers the subject complaint on 6/8/2022 before the jurisdictional police alleging the aforesaid offences. The registration of crime leads the petitioners to this court in the subject petition. This court grants an interim order of stay only insofar as the accused number, only insofar as petitioners 1, 2 and 3, and refuses to grant stay insofar as the petitioner number 4, accused number 2, is concerned. Therefore, the proceedings are now continued against the husband, accused number 1, and the brother-in-law, accused number 2. The learned counsel for the petitioner submits that he would not press the petition qua accused number 2, the petitioner, accused number 2, petitioner number 4. In that petition number 4. The relation, as observed here and above, the relationship between the accused number 1 and the complainant flounders, and floundering of the relationship leads the complainant to register a crime, register a complaint which becomes a crime in crime number 130 of 2022 for the aforesaid offences. Since the issue has now been brought up before the court on registration of the complaint, I deem it appropriate to notice the complaint. The complaint reads as follows. Page 21 to 23. A perusal at the complaint would indicate certain horrendous offences against the accused number 1 husband and offences against the accused number 2, the brother-in-law. It does not find any place, it does not mention any overt act by the other accused which can become the ingredients of the offence punishable under section 498A or 498A, 504 and 506 of the IPC, as is alleged in the case at hand. Therefore, permitting further proceedings against the petitioners 1 and 2, accused number 5 and 4 and 5 would undoubtedly run foul of the judgment of the apex court in the case of 2025 SSC online SC 2890291. In the light of the said circumstance, while permitting further proceedings to be to go on against the accused number 2, Sham Sundar, I deem it appropriate to obliterate the investigation or any further proceedings against accused number 4 and 5, sister-in-law and her husband, finding no allegations against them. For the aforesaid reasons, the following order. Criminal petition insofar as accused number 2 stands dismissed. Criminal petition insofar as accused number 3 stands abated. The proceedings. The criminal petition insofar as accused number 4 and 5 are concerned is accepted. The proceedings against the accused number 4 and 5 are quashed. One light. Next. 8453.
845 823 ಯಾರು ಒಂದಲ್ಲ
ಇಲ್ಲ ಆರ್ಡರ್ ಶೀಟ್
ಸೇಮ್ ಟೈಮ್
ಇದು ಅಷ್ಟೇ ಚಂದನ್. ಚಂದನ್ ಅಲ್ಲ, ವಾಟ್ಸ್ ಯುವರ್ ನೇಮ್?
My name is Chandan.
Sorry.
Vivek.
Abhinav is a senior. The petitioners accused 6 and 7 in crime number 126 of 2023 are before the court seeking its quashment. Heard so and so. The petitioner, the second respondent is the complainant wife of one Krishna, who is accused number 1 in the crime number 126 of 2023. The said accused number 1 and the second respondent get married in the year 2009, and the relationship having floundered between the two, the wife has registered several crimes against all the members of the family or the husband, as the case would be, both under the penal provisions, the IPC and the Domestic Violence Act. The present proceeding forms the crime number 126 of allegation is the one punishable under section 498A, 307, 506, 5 of the crime. Therefore, I deem it appropriate to notice the complaint in its entirety. It reads as follows, page 20 to 23. In the light of the 2023, the petitioners are accused number 6 and 7. Against the petitioners accused number 6 and 7, there are no direct overt acts of any overt acts committed on as would become the offence under to be a practicing advocate who has only threatened that whatever you do, I will get a stay from the hands of the concerned court, and has already taken stay in 2 of the matters. Therefore, the allegation is that he has instigated the behavior of accused number 1 and 2 in a particular manner. The complaint does not accept the aforesaid narration. The complaint does not narrate any circumstance that can become an offence under section 498A and 307 of the IPC. Therefore, permitting further proceedings against these petitioners would undoubtedly run foul of 28902913. In that light, the finding no ingredients that would permit even an investigation to be conducted against these petitioners, the petition deserves to succeed. And obliteration of the crime against accused number 6 and 7. It is made clear the observations made in the case at hand is only for consideration of the case of the petitioners accused number 6 and 7. It would not become binding. It would not influence or bind the investigation qua other accused if it is now continuing, ordered accordingly. Now come to the ಇನ್ನೊಂದು ಯಾವುದು ಅದರ್ ಅಕ್ಯೂಸ್ಡ್ ಇದಾರಲ್ಲ
8239
ಒಂದು ನಿಮಿಷ 8239 ಅಲ್ಲಿ ಯಾವ ಅಕ್ಯೂಸ್ಡ್
ಸೇಮ್ ಮಲೋಡ್ ಅಕ್ಯೂಸ್ ನಂಬರ್ 345 ಮಲೋಡ್ ಸಿಸ್ಟರ್ ಇನ್ ಲಾ ಅಂಡ್ ಹರ್ ಹಸ್ಬೆಂಡ್
ಅದು ಯಾರು ಪದ್ಮಾವತಿ
and ಲಕ್ಷ್ಮೀ ದೇವಿ and ರಾಜಣ್ಣ
ಪದ್ಮಾವತಿ is no more ಅಂದ್ರಲ್ಲ
no more ಮಲೋಡ್
so ಇದರಲ್ಲಿ
ಅಕ್ಯೂಸ್ ನಂಬರ್ 5 is no more
ಅಕ್ಯೂಸ್ ನಂಬರ್ 5 is no more. ಇದು ಸೇಮ್ ಕ್ರೈಮ್ ಎರಡು ಒಟ್ಟಿಗೆ ತಗೊಂಡ್ಬಿಡೋಣ ಹಾಗಾದ್ರೆ We'll pass the same order.
ಇದರಲ್ಲಿ ಕುಮ್ಮಕ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಅಂತ ಒಂದು allegation.
ಕುಮ್ಮಕ್ಕು ಕೊಡೋದು is not a crime, sir. ಕುಮ್ಮಕ್ಕು cannot be a crime. ಇದೆರಡು ಟ್ಯಾಗ್ ಮಾಡ್ಬಿಡಿ. ಸೇಮ್ ಕಂಪ್ಲೇಂಟ್
Same complaint, same complaint, same incident.
ಎಸ್ ವಿನೋದ್ ಅಲ್ಲ
ವಿವೇಕ್ ಮೇಲೆ.
ವಿವೇಕ್ ಇವ್ರ ಮೇಲೆ ಏನಿದೆ ಹೇಳಿ.
My lord,
ಒಬ್ರಿಲ್ಲ, ಪದ್ಮಾವತಿ is not there.
Padmavati
So
is not
sister in law and her husband ಇಬ್ರೆ.
Yes.
Shyam Sundar is a party here.
No, my lord.
Yes.
But there is, my lord, allegation as
Husband and Shyam Sundar will face the trial in all the cases. ಅದೆರಡು ಟ್ಯಾಗ್ ಮಾಡ್ಬಿಡಿ, ಸೇಮ್ ಆರ್ಡರ್ ಮಾಡಿ. ಮೇಲೆ ಒಂದು ಬರೆದ್ಬಿಡಿ. ಅಕ್ಯೂಸ್ ನಂಬರ್ 5 ಪದ್ಮಾವತಿ is no more. Therefore it is to debated.
ಇದರಲ್ಲಿ ರಾಜಣ್ಣ ಅವ್ರ ಮೇಲೂ ಇದೆ.
ಏನಿದೆ?
Please see the complaint, my lord, the first paragraph.
Yes, sir.
ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ನನ್ನ ಗಂಡನಾದ ಎಸ್ ಕೃಷ್ಣ ಮತ್ತು ಅವರ ಅಕ್ಕಂದಿರಾದ ಪದ್ಮಾವತಿ, ಲಕ್ಷ್ಮೀ ದೇವಿ,
ಏಕಾಏಕಿ ಖಾಲಿ
ನಮ್ಮ ಶ್ಯಾಮ್ ಸುಂದರ್ ಹಾಗೂ ರಾಜಣ್ಣ, ಪ್ರಜ್ವಲ್ ಮತ್ತು ಕಿಶೋರ್ ಇವರೆಲ್ಲರೂ ಒಂದುಗೂಡಿ ದಿನಾಂಕ.
Who is the Shyam Sundar?
My lord, brother-in-law.
How can you behave with her like that?
No, my lord.
What no, my lord?
In fact, my lord, she is driven out of the house. She is staying with her, my lord, in her relative's house. She has a minor daughter. Not,
My lord,
totally dependent on the relatives, my
The
lord.
DB Act will see. Wait.
My lord, she is residing in the house. She kicked out everyone from the house. Now she is residing in the
If
house.
Very
that is
good.
the case, my lord, no.
Very good.
ಒಂದುಗೂಡಿ, my lord, it says ರಾಜಣ್ಣ,
ಇದು
ಪ್ರಜ್ವಲ್, ಕಿಶೋರ್.
ಆಮ್ನಿಬಸ್. ಡೈರೆಕ್ಟ್ ಏನಿಲ್ಲ. ಎಸ್ ಸೇಮ್ ಅದನ್ನೇ ಟ್ಯಾಗ್ ಮಾಡ್ಬಿಡಿ. ಅಕ್ಯೂಸ್ ನಂಬರ್ 6 and 7 ಅದ್ರಲ್ಲಿ ಹೇಳಿದ್ನಲ್ಲ, ಅದೇ ರೀಸನ್ ಅಲ್ಲಿ ಅಕ್ಯೂಸ್ ನಂಬರ್ 3 and 4. These petitions are preferred by accused number 3 and 4 I-8239 of 2023 and accused number 6 and 7 ಅವಾಗಲೇ ಹೇಳಿದ್ನಲ್ಲ ಅದು ಗೊತ್ತಾಗ್ಲಿಲ್ಲ. 8453 so on. Yes, ಮಾಡಿ reasons ಎಲ್ಲ ಸೇಮ್. Now come to domestic violence. A5 omitted ಎಲ್ಲದ್ರಲ್ಲಿ. ಪದ್ಮಾವತಿ ಅಂತ ಎಲ್ಲ ಹೆಸರಿದೆ ನೋಡಿ.
This is a first complaint she gives.
DB Act. DB Act. ಕೊಡಿ.
My lord, put please. Who are the parties to the DB Act? But page number 16.
ಅಲ್ಲ DB Act ಅಲ್ಲಿ husband ಮೇಲೆ.
But
Do they have properties, their in-laws?
ಇದೆ.
ಏನಿದೆ?
My lord, I have stated, my lord, in the complaint itself.
but they will insist to say that
Please see, my lord.
what they are contesting. My lord, please.
Para 7, my lord.
ಆಯ್ತು, you, the wife will seek everything against the husband.
Husband shares the care. My lord, who are the parties? Like, this is mother-in-law is a party to the DB Act. My lord, sister-in-law is a party. Sister-in-law is a
No,
party.
this is mother-in-law ಅಂದ್ರೆ she was alive then.
No, my lord, she was not.
ಆದ್ರೂ ಮಾಡಿದಾರ?
Yes, my lord. In April, she deceases. Petition has been preferred to 6th month, 2022.
ಯಾರದು?
My lord, petitioner, sorry, respondent number 2, Jayalakshmamma. She is not a party. My lord.
Correct, she can't be a party, yes.
But they have made it in.
Yes, sir. Only husband.
So, my lord, sister-in-law is the first petitioner, my lord.
ಏನಾದ್ರೂ ಕೇಳಿ, because husband has to maintain you. ಇವರೆಲ್ಲ ಏನು sister-in-law, how will she maintain? Yes.
Brother-in-law.
The petitioners in the case at hand are sisters-in-law, brother-in-law and husband-in-law, brother-in-law. The petitioners 1 and 2 who have approached the concerned court invoking section 12 of the Protection of Women from Domestic Violence Act 2005 are the wife and child of the respondent number, pro forma respondent number 3, 1 S. Krishna. The proceedings are instituted as observed herein above under the provisions of the Domestic Violence Act. Insofar as the present petitioners are concerned, though the complaint alleges several grievances against them of instigation, the ingredients that would become necessary for a Domestic Violence Act to spring are conspicuously absent. For the very reasons rendered in the companion petitions to quash the proceedings against them under section 4, registered under section 498A 307 or otherwise, the same would become applicable to the case at hand as well. For those very reasons, the domestic violence proceedings against against all the petitioners except the husband shall stand obliterated. For the aforesaid reasons, the following order: the allowed quashed criminal miscellaneous 93 of 2022 stands quashed qua the petitioners 1, 2, 3. 1, 2, 3 stroke respondents 2, 3 and 4. It is made clear the court has not interfered qua other respondents. Allu Sham Sundar is there. Yes. Ordered according. Yes.
Obliged.
24.
For the respondent.
Lokayukta sir.
Please.
Ashu Surendranath.
Please.
A.N. Boral. Twenty 26 SSC online SC page 13. Correct?
Please.
ಇದು ಯಾವ ಸ್ಟೇಜ್ ಅಲ್ಲಿ ಇದೆ?
They obtain an entry model.
ಇಲ್ಲಪ್ಪ ಯಾವ ಸ್ಟೇಜ್ ಅಲ್ಲಿ ಇತ್ತು ಎಂಟ್ರಿ ಮಾಡಿ?
HBC.
The learned counsel for the petitioner submits that the arguing counsel is unwell. No submission was made on the last occasion as well. Therefore, as a last chance, list this matter next Tuesday. In the event no submissions are made, the petition would be dismissed for its non-prosecution. Adak matra, yes. Subject to the aforesaid, the entry mod stands extended to the next date of hearing.
Please.
25.
Have challenged before your lordship that the trial court
Joint development agreement.
Joint development.
my submission is that, my lord, the backdrop of the case is
Who is the complainant?
complainant
Respondents
ಇದು
here.
ಗೊತ್ತು ಯಾರು?
They are the
basically
Huh?
they are relatives of petitioner. They are the relatives of the petitioner. The back-
6.
With whom did you have the agreement, sir?
He is the second respondent who is acting as a proprietor. He is independent capacity as a proprietor.
The 138 proceeding.
Yes.
Yes, my lord.
138 proceeding. Yes, sir.
Respondent number 2 and petition number 1 and the accused number 2 is the father of petitioner.
ಚೆಕ್ ಇಶ್ಯೂ ಮಾಡಿದ್ದೀರಾ? ಚೆಕ್ ಇಶ್ಯೂ ಮಾಡಿದ್ದೀರಾ?
Check has been issued, my lord, only for the purpose that they, respondent number 2 along with 5 others have jointly borrowed a loan where I don't want the loan at all. And for that, my lord, they have.
Why did you issue the check?
Yes, my lord, only to that extent, my lord. They have undertaken the loan saying that the loan was standing in the name of 6 persons. Only 4 have availed. The other 2, you don't have to avail, we will discharge you. Based on that, my lord, the check has been issued by the petitioner's father, stating that only after discharging the loan, I will be entitled to present the check. But subsequently, what has happened, my lord, they never discharged the loan. I already paid 89 lakhs 25,000. In addition to that, whatever their loan they have borrowed out with 6 others, it amounts to 2 crore. If it is considered as individual, my lord.
ಚೆಕ್ ಅಮೌಂಟ್ ಏನು ಸರ್?
10 lakhs, my lord, 2 checks.
20 ಲಕ್ಷದ್ದು.
Yes, my lord.
You have signed the check.
In this petitioner has never signed the check.
Then how is it?
Only the petitioner's father has signed the check, my lord.
That's correct, sir.
Yes, my lord.
How are you drawn in the company?
No, my lord, I am an individual.
Then how are you drawn into this?
They are stating
The
that all the people are joint liability.
Hmm.
Yes, they are liable to be prosecuted under section 138 of.
Signatory yaru, sir?
Signatory is
Father.
his father, that her father, Zaja.
Yes, ashte.
And my lord,
It was a registered document, the GPA holder. And its specific information instruction was given to draw the check.
my lord, there is additional ground I just wanted to bring to your attention.
This is, you are the daughter, is it?
Yes.
Daughter of accused. My lord, I'm just submitting my objection.
You are not, are you a signatory to the joint development agreement?
Yes.
Signatory to the joint development agreement as an attorney holder by my father. But nevertheless, my lord, the payee is not in the name of.
Page number 21 is the
What
general
is that?
power of
My
attorney.
lord, objection.
For what?
For the taking of state.
Copy kodi avarge.
It's received now. Now
Let me
received.
Here, my lord, I have produced one judgment, my lord.
Wait, list on 3rd February. Along with the application seeking vacation of the interim order. Next. Interim order will continue to the next date of hearing.
26.
Hmm. Offense.
420, 468,
ಅದೇ
470.
ಬಿಹಾರ್ಲಿ ಒಂದು ಆಯ್ತಲ್ಲ ಅದು.
ಫಿಟ್ನೆಸ್ ಮೆಡಿಕಲ್ ಸರ್ಟಿಫಿಕೇಟ್ ನ ಹೋಲ್ಡ್ ಮಾಡಿದ್ದಾರೆ.
What became of the forgery? What advantage did you take? No, ಈ offense in the end, fabrication or forgery in the. Where?
In Bihar itself, then he was posted in Bangalore.
Hmm.
Cantonment. Another FIR was registered. In the memo, can be seen that the charge sheet is also filed against him in Bihar, and the matter is pending there.
What certificate did you forge? Disability certificate.
ಮೆಡಿಕಲ್ ಫಿಟ್ನೆಸ್ ಸರ್ಟಿಫಿಕೇಟ್.
Fitness certificate.
ಅನ್ಫಿಟ್ ಅಂತಿತ್ತು. ಅದನ್ನ
Joined the army, is it?
He joined the army.
ನೀವೇ ಫೋರ್ಜರಿನ. ಹ್ಮ್. ಬಟ್ ಅಲ್ಲೊಂದು ಕ್ರೈಮ್ ಇದೆಯಲ್ಲ. ಇದೇ ನಡೀಲಿ, ಅಲ್ಲಿ ಕ್ವಾಶ್ ಮಾಡಿಸ್ಕೊಂಬಿಡಿ. ಇಲ್ಲಿ ನಡೀತಾ ಇದೆ. ಅದೇ ಬೆಟರ್. ಪರವಾಗಿಲ್ಲ. We'll observe that first FIR should be closed. Same FIR ಇಲ್ಲಿ. ಅಲ್ಲಿ 20 ವರ್ಷ ಆದ್ರೂ ಮುಗಿಯಲ್ಲ. ಎಲ್ಲಿದ್ದೀರಾ ಈಗ? ಅಲ್ಲೇ ಇದ್ದೀರಾ? ಇಲ್ಲಿ ಎಂಟ್ರಿ ಮಾಡಿದ್ಯಾ? But any observation here will affect there. Same crime. ಈಗ they have dismissed you? You are not in the army. ಅಲ್ಲಿಗೆ ನೀವು ಫೋರ್ಜರಿ ಮಾಡಿಕೊಟ್ಬಿಟ್ರೆ. You have a knock knee, is it? Knock knee. What is your problem? ಏನ್ ಡಿಸಬಿಲಿಟಿ ಇದೆ? ಇಲ್ಲಿದೆ knock knee ಅಂತ. Yes. You would not be selected if you had the disability. Is the petition is challenging a crime registered against the petitioner second in time. For the same offense, the petitioner is facing proceedings in case number 303 of 2014 for offenses under section 420, 467, 468 and 471 in before the jurisdictional court at Muzaffarpur, Bihar. The petitioner, when he was posted to Karnataka, Bangalore, second complaint on the same offense, on the same allegation for the same offense, comes to be registered in crime number 520 of 2024. In the light of the pendency of the crime or proceedings before the concerned court at Muzaffarpur, Bihar. The second proceeding which is now challenged in the subject petition needs to be interdicted. Therefore, there shall be an interim order of stay of further proceedings in CC 53493 of 2017 for till the next date of hearing. List the matter March end al kodi. Yes.
Respondent number 2 and notice.
Emergent, second, 2 year army.
Please, Army.
Emergent notice to the second respondent. Yes, next.
27.
What offense, madam? Domestic violence. Prayer? To use the mic, why?
With respect to this petition, orders have been passed by the trial court minutes. I'm pressing only on prayer A minutes for early disposal.
On prayer A.
Please.
Is a appeal hakbakaguttಲ್ಲಿ. Prayer A I will grant. The petitioner is before the court seeking the following prayer. The petitioners are your complainant, is it? Or the petitioner has instituted proceedings invoking the provisions of the Domestic Violence Act in Criminal Miscellaneous 244 of 2019. The said petition is said to be pending without any orders being passed for the last 7 years. Therefore, the petitioner is now restricting the prayer to prayer A and would not press B and C. In the light of the said submission,
That's may make a submission. Prayer B and C orders have been passed.
Orders. They would not, the learned counsel submits that prayers B and C, orders have already been passed and therefore those prayers would not, those prayers have been rendered infructuous today. In the light of the said submission of the counsel for the petitioner, the concerned court which has now kept the petition under Criminal Miscellaneous 244 of 2019 for the last 6 years shall endeavor to conclude the proceedings with an outer limit of 4 months from the date of receipt of the copy of this order, if not earlier, in accordance with law. Yes, next.
28.
Order record.
Okay.
Number 28 and 58 are connected matter.
Yavdu, Girish?
58.
58.
28 to 58?
Same.
58 ಗೆ ತಗೊಳ್ಳೋಣ ಹಂಗಾರೆ. Yes.
29.
Accused number 2 is before your lordships. The allegation is that the respondent number 2 had paid my lords 30 lakhs to the petitioner and my lords it was returned. Subsequently, my lord, he gets in touch with one Abhishek Chaudhary, my lords, A1, and he transfers 15 lakhs. Pardon? No, my lord, there is no transaction between us. Even according to complaint governments, my lord would kindly take page 11, annexure B. My lord, I have returned the money.
Railway board member ಮಾಡಿಸ್ತೀರಾ?
But the whole purpose was illegal. Whole purpose, my lords, I never induced him to pay the money. In fact, he transacts with A1, my lords, they can proceed against him.
A2ನೇ ಕರ್ಕೊಂಡು ಹೋಗಿದ್ದಾರೆ ಸರ್, ಡೆಲ್ಲಿ ಕರ್ಕೊಂಡೋಗಿ ಅವರ ಅಮೌಂಟ್ ಕೊಡಿಸ್ಬಿಟ್ಟು ಮತ್ತೆ
ಅದಕ್ಕೆ ಯಾರು ದುಡ್ಡು ಕೊಟ್ರು? ಟ್ರಾವೆಲ್ ಎಕ್ಸ್ಪೆನ್ಸಸ್ ಎಲ್ಲ ನೀವೇ ಕೊಟ್ರಾ?
15 lakhs cash, but all those things, my lords, they have been, just to my lords, as a local person, he has implicated because I knew this complainant. Earlier, he was working with us.
Who are you?
My lord, I am a company owner, my lord, software engineer, having an established.
Railway board membership ಎಲ್ಲ ಕೊಡ್ಸೋದು.
Because of this, my lords, even matrimonial issues have started between.
ಅದಕ್ಕೂ ಇದಕ್ಕೂ ಏನ್ ಸಂಬಂಧ?
Husband now.
Husband is accused number 1.
No, no.
Friends, accused number 1 and 2 are friends. Friends.
They can proceed against A1, my lord.
Proceed against A1. Yes. The petitioner is before this court calling in question proceedings in crime number 93 of 2023 registered for
Conspiracy ಇದೆ 120B ಇದೆ
120.
meeting of minds. ಎಲ್ಲಿ ನಿಮ್ಮ ಮೈಂಡ್ ಮೀಟ್ ಆಗಿಲ್ವಾ? ಡೆಲ್ಲಿ ಕರ್ಕೊಂಡು ಹೋಗಿದ್ದೀರಾ ಮತ್ತೆ?
All payments are made. He calls the complainant, takes the money, my lords. I am no way concerned. If I had to involve, I had no intention of returning the money. My lord, the complainant himself would not have stated so. Just my lords, as a local person, he tries to implicate.
ಅವರೆಲ್ಲಿ ಅವರು?
Uttar Pradesh. Account ಅಲ್ಲಿ ದುಡ್ಡು ಕೊಟ್ಟಿದ್ದಾರಂತೆ. My lord, who believes that bribe is paid in the account and all, my lord? Some third transaction he tries to implicate.
ಫಸ್ಟ್ ಆಫ್ ಆಲ್ ರೈಲ್ವೆ ಬೋರ್ಡ್ ಆಗ್ಬೇಕು ಮೆಂಬರ್ ಆಗ್ಬೇಕು ಅಂತ ಹೇಳ್ತಾರೆ. Huh? The petitioner, accused number 2, is before the court calling in question registration of a crime in crime number 93 of 2023, heard so and so, for offences punishable under so and so, heard so and so. The petitioner and the second respondent are said to be acquaintances with the accused number 1, who is not before the court. The accused number 1 is said to have induced the complainant in parting with ಎಷ್ಟು amount?
31 lakhs.
31 lakh,
Parting with
40,000.
31 lakhs,
40,000.
40,000 rupees, which is paid by the complainant by bank transfer to the account of accused number 1.
15 lakhs cash ante.
15 lakhs cash and
Balance.
16 lakhs 40,000 by bank transfer. It is now projected that the accused number 1 and accused number 2 together assured the complainant that he would be made a railway member, railway board member.
Railway board member.
ಹಿಂಗಾಗೋಗ್ಬಿಟ್ಟಿದ್ರೆ ಏನ್ ಬೇಕಾಗಿರೋದು. Railway board member, and therefore the transaction had taken place. Insofar as the transaction has taken place, registration of the crime has driven the petitioner to this court in the subject petition. The learned counsel Venkatesh Dalwai, appearing for the petitioner, submits in the entire complaint there is no allegation against the petitioner that can become offences punishable under section 406 or 420 of the 506, 120B or 420 of the IPC. All the transaction conversation have happened between accused number 1, who is not before the court, and the complainant, which is an admitted fact. Therefore, the learned counsel submits that if further proceedings are permitted to continue, it would become an abuse of the process of the law. The learned counsel for the complainant would vehemently refute the submission that the petitioner is the one who introduced the complainant to accused number 1, but accepts the fact that all transactions and conversations have happened between accused number 1 and the complainant, and the petitioner was not even in the loop except introduction being made at the outset.
Received the amount and returned back the amount.
ನಿಮಗೆ ಬಂದಿತ್ತಾ?
My lord, he says that I had taken and returned it. My lord, there is no proof, nothing. Cash ವಾಪಸ್ ತಗೊಂಡ್ರ.
ಕ್ಯಾಶ್ ಕೊಟ್ಟಿದ್ವಿ, ವಾಪಸ್ ಕೊಟ್ಟಿದೀವಿ ಅಂತ.
ಹೆಂಗ್ ಕೊಟ್ರಿ? ಯಾವಾಗ ಕೊಟ್ರಿ ಕ್ಯಾಶ್?
ಅವ್ರು ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ 30 ಲಕ್ಷ ನಗದು ರೂಪದಲ್ಲಿ ಸರಿತಾ
ವಾಪಸ್ ಕೊಟ್ಬಿಡಿ. ಎಲ್ಲ ಕೊಟ್ಟಿದ್ದು ಗಾಳಿ, ತಗೊಂಡಿದ್ದು ಗಾಳಿ. Yes. So and so. The learned counsel submits that the petitioner also had received the amount but promptly returned the amount. These are all admitted facts. In the light of I have given my source. In the light of the issue getting triggered for the purpose of triggered on the complaint so registered, I deem it appropriate to notice the complaint. The complaint reads as follows. In the entire complaint, there are two factors. One, the petitioner and the complainant being introduced to accused number 1 by the petitioner, and a stray line that the petitioner also received 30 lakhs but returned the 30 lakhs, but has promptly returned the 30 lakhs. But the transaction that the petitioner alleges, which is now become a crime, is for the transaction between accused number 1 and the complainant, who is said to have received 15 lakhs in cash and 16 lakh 40,000 by way of bank transfer. Therefore, having found nothing against the present petitioner, if further proceedings are permitted to continue, it would run foul of the plethora of judgments, and particularly of the judgment of the apex court in the case of state of so and so's Bhajan Lal. Page para 102 quote ಮಾಡಿದ್ರು. Yes. For the aforesaid reasons, allowed quashed qua accused number 2. Next.
30.
May please, my lord. The first petitioner is the mother-in-law of the second respondent. Second and the third petitioners are the maternal aunt and uncle of the second respondent. Yes, stay this one. The offences under 498A and section 31RS of the SC/ST.
Atrocities Act yake?
ಏನಾಗಿದೆ ಅಂದ್ರೆ
complaint
ಅಲ್ಲಲ್ಲ, ಇಲ್ಲಿ ಸೆಕೆಂಡ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಬಿಲಾಂಗ್ಸ್ ಟು SC community. The first petitioner also belongs to SC community.
So ಅದು ಬರೋದೇ ಇಲ್ಲ.
But insofar as accused number 3 and 4 are concerned, they are the maternal aunt of the complainant, please, my lord. And that, my lord, they belongs to non-scheduled caste category, please, my lord. And that, my lord, they stay in Channapatna. The incident took place 1 year prior to the date of filing of the complaint, please, my lord.
ಅವರಿದ್ರೆ ಮುಗಿಸ್ತೀನಿ, ಇಲ್ವಲ್ಲ?
2-3 times, my lord, it was notified.
ಇಲ್ಲ.
Last occasion also, please, my lord was
Registered to print the name of, show the complainant as serve ಆಗಿದೆ.
serve ಆಗಿದೆ ಸ್ವಾಮಿ.
Third unrepresented.
Yes, please, my lord.
ವಕಾಲತ್ ಹಾಕಿದ್ದಾರೆ. ವಕಾಲತ್ ಹಾಕಿದ್ದಾರೆ.
Date may kindly be fixed, please, my lord.
ಶ್ರೀನಿಧಿ ಆರ್ ಅಂತ ಯಾರು ಹಾಕಿದ್ದಾರೆ?
Srinidhi is the second respondent complainant, please, my lord.
ಇನ್ಯಾರು ಬೇಕು ನಿಮ್ಗೆ? ಕಂಪ್ಲೇನೆಂಟ್ ಅವರ?
ಹೌದೌದು. She is the de facto complainant.
ಫಾರ್ R2 ಅಂತಿದೆ. ಯಾವತ್ತು ಸರ್ವ್ ಆಗಿದೆ ನೋಡಿ ಮೇಡಮ್?
29/2/24.
The petitioner is before the petitioners accused 2, 3 and 4 in special case 209 of 2023 are at the doors of this court calling in question proceedings in, calling in question the entire proceedings. Heard so and so. Heard the learned counsel K.B. Swami appearing for the petitioner. The second respondent complainant, though served on 29/2/2024, has remained unrepresented even today. Therefore, the petitioner and the learned HCGP appearing for the state are heard in the matter. The accused number 1 and the complainant get married. The marriage happens on 31/8/2020. The relationship between the accused number 1 and the complainant is said to have floundered. On the floundering of the relationship, several proceedings are instituted against each other. The impugned proceedings come about on a complaint being registered by the second respondent wife on 16/6/2023 for 16/6/2023. The said complaint becomes a crime number 62 of 2023 for these following offences. The police charge sheet ಆಗಿದೆಯಾ?
Yes, charge sheet.
The police, after investigation, have filed a charge sheet against these petitioners for the aforequoted offences. Filing of the charge sheet has driven these petitioners to this court in the subject petition. The learned counsel The learned counsel appearing for the petitioner submits that the allegation of the provisions of the Atrocities Act would not get attracted qua the first petitioner, as the first petitioner also belongs to scheduled caste. Insofar as the second and third petitioners are concerned, the allegation of hurling of abuses has taken place 1 year prior to the registration of the complaint. Therefore, the said allegation also would not hold any water in the light of several judgments of the apex court. Insofar as the offense under section 498A is concerned, the petitioners being brother-in-law and sister-in-law,
ಅಲ್ಲಲ್ಲ, maternal aunt and the maternal uncle.
complainant ಗೆ ಯಾರು ಹೇಳಿ?
Complainant ಗೆ maternal aunt.
Being the maternal aunt and uncle of the complainant cannot be dragged into the web of crime for offences punishable under section 498A of the IPC. Therefore, the learned counsel would submit that the proceedings be quashed against these petitioners, as the husband accused number 1 is facing trial. Per contra, the learned counsel, learned HCGP appearing for the respondent would seek to submit that the petitioners, the allegations are found against these petitioners insofar as the offense under section 498A or the Atrocities Act is concerned. In that light, the charge sheet having been filed, it is for the petitioners to come out clean in a full-blown trial. The learned counsel would, the learned HCGP would just seek dismissal of the petition. I have given my source. The afore narrated facts are a matter of record. The relationship between the petitioners and the complainant is explained herein above. The wife registers a complaint against the husband and several members of the family by a complaint so made on 16/6/2023. Since the entire issue is now triggered from the complaint, I deem it appropriate to notice the complaint. The complaint reads as follows, page 17 to 19. Insofar as the present petitioners are concerned, even in the complaint, there was nothing found. Insofar as the offence under section 498A is concerned, as the ingredients were completely absent. So far as the provisions of the Atrocities Act are concerned, as observed here and above and admitted, the first petitioner also belongs to a scheduled caste, and therefore the offence under the Atrocities Act could not spring against the first petitioner. Insofar as the other petitioners are concerned, insofar as other offences and the offence under the Atrocities Act, the other petitioners are concerned, the hurling of abuses has admittedly taken place in the year 2022, i.e. on 29/12/2022, and the complainant has taken more than 7 months to register the complaint for an offence that has taken place in the year 2022. Therefore, the delay would undoubtedly lead to a prima facie, lead to an inference that the complaint is full of embellishments that has taken place, embellishments of the events that not having taken place. The police, after investigation, file a charge sheet. The summary of the charge sheet as obtaining in column number 17 reads as follows. If the complaint and the summary of the charge sheet are read in tandem, what would unmistakably emerge is the crime being registered, the charge sheet being filed, all on omnibus statements made against these petitioners accused 2, 3, and 4. Insofar as the offences under the Atrocities Act is concerned, as observed, it is an incident that has taken place 7 months ago. The incident does not, the complaint also does not indicate whether the abuses are hurled in a public view or in a public place or a place of public view. Ostensibly so, as the abuses are hurled within the four corners of a house as the dispute runs in the family. In that light, the permitting further proceedings the Atrocities Act even would run foul of the judgment of the apex court in the case of Hitesh Verma versus State of Uttarakhand 2020, 10 SCC page 710 and para 14 to 19. In that light, the petition deserves to succeed. Allowed, quashed.
Grateful. Only the date of complaint is to be 30 March 2023, please, my lord. 33, please, my lord. Grateful.
7 months beda. Incident yavagindu?
First incident 1 year ago at Ramnagar.
Time, date, sir.
29 December. That is correct date.
ಮತ್ತೆ ಕಂಪ್ಲೇಂಟ್ 33
4 ತಿಂಗಳಾಯ್ತು.
ಮತ್ತೆ 7 ಬರಲಿಲ್ವಾ?
ಅಲ್ಲಲ್ಲ, first incident 1 year ago. They did not register any complaint. In December, that is on 29/12/2022, incident takes place. Then they approached the police on 30 March 2023. So again, there is a delay of about 3 to 4 months, please, my lord.
ಅದು 4 months ಮಾಡಿ ಮೇಡಮ್, 7 months.
Grateful.
31.
For the petition. The case, my lord, where election
31,
offense.
I'm appearing for response to Lordship. Can you grant me 10 days time, my lord? There's some allegations regarding.
Election offense, my lord, even before MC.
ಕೊಟ್ಟಿದ್ದೀನಲ್ಲ ಸರ್,
Please.
10 days ಟೈಮ್ ಕೇಳ್ತಾರೆ ಸರ್. ಕಾನ್ಸಲ್ ಶರದ್ ಅವರು ಬಂದು ಹೇಳ್ತಾರೆ, ಆಮೇಲೆ ಏನು ತೊಂದರೆ ಇಲ್ಲ. ಬಟ್ 10 days ಟೈಮ್ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ ತಗೊಂಡ್ಬಿಡಿ. Place the matter on 3rd February at the request of Sharath Dodwad. Interim order subsisting will continue to its covered, Sharath.
Please.
Interim order subsisting will continue to the next date. Yes, next.
32, my lord. Offense 420, 467, 468, 471.
420.
Respondent number 2, my lord.
2009 lordships, they execute sale agreement and they receive the amount in check, and also they execute a registered general power of attorney, 2009. Thereafter, my lord, the land is, sale permission is obtained, conversion happens, and sale deed is executed in favor
Granted
of.
land.
Yes, my lordship, granted land.
Granted land.
Non-alienation period in?
That is long back, my lord.
The long back, how long back?
My lord, even
Date
that
of
is.
grant?
My lord, date of grant, I'm not aware, but
ಹೇಳಿ sir.
1964, my lord.
64.
Non-alienation 15 ವರ್ಷ ಅಷ್ಟೇ ಅಲ್ಲ?
SC/ST land, my lordship.
So?
My lordship, here is.
ಅಲ್ಲ, ಅದೇ non-alienation permanent ಆ?
Without permission, my lordship, they purchase the property.
ಯಾಕೆ ಸೇಲ್ ಡೀಡ್ ಎಲ್ಲ ಆಗೋಗಿದೆ?
No, my lordship.
Sale permission is
Submit
also
some
obtained.
documents and I will convince the court, my lordship.
See, there are two things in law. ನಾನ್-ಎಲಿನೇಷನ್ ಕ್ಲಾಸ್ 15 years ಇದ್ರೆ 14ನೇ ವರ್ಷಕ್ಕೆ ನೀವೆಲ್ಲ ಮಾರ್ಬಿಟ್ರೆ ವಿತೌಟ್ ಪರ್ಮಿಷನ್ ಎಲ್ಲ ವಾಪಸ್ ಕೊಟ್ಬಿಡೋಣ ಗ್ರಾಂಟೆಡ್ ಲ್ಯಾಂಡ್. ಬಟ್
ಲಿಮಿಟೇಷನ್ ಏನಿಲ್ಲ 15 years
ಮತ್ತೆ
ಲಿಮಿಟೇಷನ್
ಬಿಡಿ. This land is not permanently non-alienable. Be it SC/ST land. Permanently non-alienable ಇದ್ದಿದ್ದು only for the period between 1938 to 1953. ಆವಾಗ ಗ್ರಾಂಟ್ ಆಗಿದ್ದ ಲ್ಯಾಂಡ್ಸ್ even after 100 years was resumable to the granted people, but not after that. Mysore Land Revenue Code ನೋಡಿ.
my submission
Civil suit is also filed, my lord.
ಗೊತ್ತಾಯ್ತು.
my lordship, my submission is, my lordship, at the time of the sale permission, my lordship, they created the number of documents.
ಯಾರು? ನೀವು
Petitioner
ಸೇಲ್
here.
ಮಾಡಿಲ್ವಾ?
No, my lordship.
ಮಾಡೇ ಇಲ್ವಾ?
My lordship, we execute the GPA, registered GPA in the year of 2009. Based on the GPA, they approached the DC for sale permission. At that time, they created all the documents and submit the documents and obtain the sale permission. my lord.
ಒಂದ್ ನಿಮಿಷ. ಟ್ರಾನ್ಸಾಕ್ಷನ್ ಏನು? ಎಷ್ಟು ಕನ್ಸಿಡರೇಷನ್ ಎಷ್ಟಿದೆ?
There is no consideration. As on today, we are not.
35,000.
My lordship, my lordship,
ಒಂದ್ ನಿಮಿಷ. ಇದು ಕನ್ಸಿಡರೇಷನ್ ಏನು ಅಂದ್ರೆ?
13,35,000.
ಹೆಂಗ್ ಕೊಟ್ರಿ?
We paid half by way of cash.
No.
6 lakhs is by way of check, my lord.
ಎಷ್ಟು ಎಕರೆ?
1 acre 30 gunters.
ಎಲ್ಲಿ?
Nelmangla, my lord.
Nelamangala, my lord.
6 ಲಕ್ಷ.
No, it is in 2009, my lord.
My lordship, my submission is sale agreement,
ಇರಲಿ, ಇದು
sale
crime.
agreement,
And that too, there is
sale
no
agreement
road to it.
13.
ಈಗ OS ಹಾಕಿದಿರಲ್ಲ.
ಹಾಕಿದ್ದು.
My lordship, my submission is, in sale agreement ಅಲ್ಲಿ 13 lakhs ಅಂತ ತೋರಿಸ್ತಾರೆ. ಸೇಲ್ ಡೀಡ್ ಅಲ್ಲಿ 37 lakhs ಅಂತಾರೆ ಬೈ ಕ್ಯಾಶ್ ಅಂತಾರೆ. ಅದ್ರಲ್ಲಿ ವರ್ಡಿಂಗ್ ಬಳಸೋದು ಏನ್ ಬಳಸ್ತಾರೆ ಅಂತ ಪರ್ಮಿಟ್ ಮೀ ಟು ರೀಡ್, ಮೈ ಲಾರ್ಡ್ಶಿಪ್. ಫಾರ್ ಸೇಲ್ ಡೀಡ್,
Who is in possession?
as of my instruction,
doubt ಬರ್ತಾ
we are in
ಇದೆ.
position.
ಅದೇನ್ ಡೌಟ್ ಅಲ್ಲಿ ಹೇಳ್ತಾ ಇದ್ದೀರಾ? ಅಂದ್ರೆ ನೀವಿಲ್ಲ ಪೊಸಿಷನ್ ಅಲ್ಲಿ.
My lordship, kindly see in page number 22, my lordship. What are the documents submit today? ಅದರಲ್ಲಿ ಅವಶ್ಯಕತೆ ಇದ್ದಿದ್ದರೆ ಇದರಡಿ ನಮೂದಿಸಿರುವ ಪೂರಾ ಶೆಡ್ಯೂಲ್ ಸೊತ್ತನ್ನು ನಿಮಗೆ ಗವರ್ನಮೆಂಟ್ ರು 33,75,000 ರೂಗಳಿಗೆ ಶುದ್ಧ ಕ್ರಯಕ್ಕೆ ಕೊಡಲು ಒಪ್ಪಿ ಕ್ರಯದ ಮೊಬಲಗನ್ನು ಪೂರಾ ನನಗೆ GPA ಕೊಟ್ಟವರೇ
ಆಯ್ತು. ಈ ಡಾಕ್ಯುಮೆಂಟ್
ಈಗಾಗಲೇ ಪಡೆದುಕೊಂಡಿರ್ತಾರೆ ಅಂತ ಹೇಳ್ತಾರೆ.
ಕೊಟ್ಟಿಲ್ವಾ ಡಾಕ್ಯುಮೆಂಟ್ಸ್?
ಕೊಡ್ತೇವೆ.
ಮತ್ತೆ ಅವರು
ಕೊಟ್ಟಿದ್ದೀವಿ.
ಈಗ ಕೊಟ್ರ ನೋಡ್ಬಿಡಿ.
ಅದ್ರಲ್ಲಿ ಏನಂತಾರೆ GPA ಹೋಲ್ಡರ್ ಅವರೇ ಅವರೇ ಪರ್ಚೇಸರ್. ಇಲ್ಲಿ ವರ್ಡಿಂಗ್ ಏನಂತ GPA ಹೋಲ್ಡರ್ ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ ಅಂತ ಬರೀತಾರೆ. ವಿ ಆರ್ ನಾಟ್ ರಿಸೀವ್ಡ್ ಎನಿ ಮನಿ.
ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್ ಅಂದ್ರೆ
ಇಲ್ಲೇ ಪದನೇ ಅವರೇ ಬಳಸಿರೋದು ವರ್ಡ್. GPA ಈಗಾಗಲೇ ಪಡೆದುಕೊಂಡಿರುತ್ತಾರೆ, GPA ಹೋಲ್ಡರ್ ಪಡೆದುಕೊಂಡಿರ್ತಾರೆ ಅಂತಾರೆ. ಅವರೇ ಸೆಲ್ಲರ್, ಅವರೇ ಪರ್ಚೇಸರ್.
That is permissible, my lord. TP Act, that is
ಅಲ್ಲ, ಕರೆಕ್ಟ್. ಬಟ್ ವಾಟ್ ಅಬೌಟ್ ಕನ್ಸಿಡರೇಷನ್, ಮೈ ಲಾರ್ಡ್ಶಿಪ್? ಅಂಡ್ ಆಲ್ ದಿ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಇಸ್ ಕ್ರಿಯೇಟೆಡ್. ನನ್ನ ಸಿಗ್ನೇಚರ್ ಅವ್ರು ಮಾಡ್ತಾರೆ DC ಮುಂದೆ. ಅದ್ರ ಡಾಕ್ಯುಮೆಂಟ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದೀನಿ.
That is not the.
ಅದ್ರ ಜೊತೆಗೆ ನನ್ನ ಹೆಸರಲ್ಲಿ ಪಾರವೇ 150 ಕಿಲೋಮೀಟರ್ ದೂರದಲ್ಲಿ 6 ಗುಂಟೆ ಜಮೀನನ್ನು ಮಾಡ್ಕೊಳ್ತಾರೆ. ನಾನು ಅಲ್ಲಿ ಪರ್ಚೇಸರೇ ಅಲ್ಲ, ನಾನು ಯಾರಿಗೂ GPA ಕೊಟ್ಟಿಲ್ಲ. ಆ GPA ಕ್ರಿಯೇಟೆಡ್, ಅದನ್ನು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದೀನಿ ಡಾಕ್ಯುಮೆಂಟ್ ನಾನು.
That is not even the complaint raised, my lord.
ಅಲ್ಲ, ಇದೆ
Complaint raised is.
ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿದೆಯಾ?
No, FIR, my lord, it is stayed.
ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಆಗ್ಲಿ.
Allah, it is stayed. What has happened is.
We'll vacate this day.
Allah, my lord, here what has happened is 2009 is the sale agreement, my lord, not by just single person.
Section 3
by
is
all the
very clear.
family, by all the family members, lordships. And there are two agreements. One agreement, my lord, 6 lakhs is given. Another agreement, 13 lakhs.
What is shocking is even 2009 or 2017.
Please.
1.5 ಎಕರೆ 6 ಲಕ್ಷಕ್ಕೆ ನೆಲಮಂಗಲಲ್ಲಿ ಸಿಕ್ತು.
No, my lord, 13,50,000 and 6 lakhs. Then 2009, my lord. Thereafter, my lord, it is 2001, 2021 itself, my lord, sale deed is done.
We'll see. Look into this document.
Please, lord.
List the matter on 3rd February. We'll close it on that day.
Interim order.
Interim order will continue to the next day. Yes.
33. My lord, for respondent number 2, kindly pray time as
Respondent number 2, come this side.
Sorry. Respondent number 2, my lord, kindly pray time as senior is out of station on a
Raise
different
time.
case. Yes,
No grants time. Yes.
Previous order, my
I'm a
lords.
proxy counsel, my lord.
In the event the petitioner does not make his submissions, the petition would be.
Petition.
ಅದೇ ಬರ್ದಿರೋದು.
My lords, one before. Anyway, my lords, this is a case where the petitioners.
Last time ನೀವಿರ್ಲಿಲ್ಲ.
ಇಲ್ಲ, ನಾನು.
ಅಲ್ಲ ನೀವಲ್ಲ, petitioner ಯಾರು ಇರ್ಲಿಲ್ಲ ಇಲ್ಲಿ.
My lords, the petitioner, husband and wife, they were working under respondent number 2, which is a proprietrix concern. Now, my lords, they would leave the employment, and after leaving the employment, the husband would enter into an agreement, my lords, with one other company on the very next day. Thereafter, my lords, that company with which the petitioner has this agreement would then, my lords, cut ties with the proprietrix concern. They cut ties. After which, my lords, the complaints that come to be filed, a complaint which he gives in the first instance is that petitioner number 1 had stolen 5 lakh rupees. Now that
ಅವ್ರಿಗೇನು ಗೊತ್ತಾಗ್ತಾ ಇಲ್ಲ proxy counsel. Yes.
in that NCR takes place, my lords. Once an NCR.
One opportunity, third. ನನಗೂ ಈ interview ಮುಗಿದ್ಬಿಟ್ರೆ third in the will take whole hog. All memos of all councils I'll take. Till then, ಅಷ್ಟೇ. Yes.
Interim order.
Interim will continue. Learned counsel representing the counsel for the complainant seeks a week's time. Finally, list the matter on 3rd February. At the same stage, in the event no submissions are made, petitions would be answered. Petition would be answered hearing the counsel for the petitioner.
Obliged.
Heard, learned senior counsel anta ಮಾಡಿ ಆಮೇಲೆ ಅದ್ ಮಾಡಿ. Next, yes.
34.
I'm appearing for the petitioner, my lords, seeking a short date, my lords. We have to produce few more documents in this matter.
ಅಯ್ಯೋ 3 years ಇಂದ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿಲ್ಲ.
My lords,
Last time, as a last chance, I posted it today. No representation.
my lords, I was held up in another court, my lords.
That's not the ground, madam. Interim order will vacate otherwise.
No, my lords. My lords, it's a civil matter, my lords. They have, we have already given a complaint even before their FIR stating that they might falsely give
They might.
case. No, there is, I've already annexed it. There are few more documents where I have to submit before.
ಏನು
it's on the
abuse
paper.
ಮಾಡಿದ್ರ?
Abuse also destroy the household equipments and destroy the wall and sheet of the house, my lord.
Civil suit ಹಾಕಿದ್ದೀರಾ?
Civil suit ಇಲ್ಲ ಇದರಲ್ಲಿ.
My lords, there are pending check bounce cases as well, where we have filed it against them. So as a count.
You get ready. Third.
My lord.
Third is to. Third is, yes, 3rd February.
Grateful. My lords, interim order mechanic.
Interim order will continue to the next.
Great.
The last chance, next.
Date maybe.
Third,
please.
35.
My lord, on last date, on 6/1, there was an order passed, my lord. Thereafter, now they have come forward for settlement, my lord.
They are ready for settlement.
Yes, sir.
They pass on.
Settlement ಆಗ್ತಾ ಇದೆಯಾ?
Our party is also ready, they are also.
ಇವತ್ತೇ ಮಾಡ್ತೀರಾ? The counsel for the parties would submit the matter has been settled and would report settlement. Pass over ಏನು ಆರ್ಡರ್ ಬೇಡ. Pass. ಇಲ್ಲ ನಾಳೆ ತಗೊಳ್ಳ.
Please.
ಆಗತ್ತೆ ಇವತ್ತೇ ಆಗತ್ತಾ ನಾಳೆ?
15 people came from Kolar, my lord, kindly.
ಆಯ್ತು ಬಂದ್ ಮಾಡ್ಬಿಡಿ. I am sitting only up to 3:30.
Before at
Yes,
before
next.
2:30 will.
ಏನು ಗೌತಮ್?
By 1:30 will.
ಆಯ್ತು.
36, I appear for the petitioner's counsel.
Yes, sir.
Emanates from a joint development agreement. FIR is registered, my lord, in 2025. After permission was granted by the panchayat to release the sites, all the 100% sites. The petitioners, my lord, are owners of the land. The
Yes, my lord.
injunction.
But I'm not on the
ex parte
point of it
temporary
being a
injunction.
civil dispute. I completely understand that fact, my lords. I'm only on the aspect of creation of documents. My lords,
For what? Okay, joint development agreement.
Lords, ಇದ್ರಲ್ಲಿ ಏನಾಗುತ್ತೆ, I am given the power to go and seek necessary sanctions. My lord, I seek for these necessary sanctions.
ಇದು granted land.
ಇಲ್ಲ. My lord, I seek for these necessary sanctions for development.
Development.
My lord, after I seek these necessary sanctions, they remove my name from the layout plan and they sell it. My lords, I have paid 25 lakhs as per the joint development agreement. My lord, through
ಅಷ್ಟು ಬಂದ್ರೆ ಸಾಕಾ?
ಅಲ್ಲ ಸ್ವಾಮಿ, ಇದ್ರಲ್ಲಿ ಏನಾಗಿದೆ, they've sold my share also as per the sharing agreement.
The
30,
approach to
50%
civil court.
was granted to me, 50% was theirs.
Ex parte
50% ಮಾರ್ಬಿಟ್ಟಿದ್ದಾರೆ.
ex parte TI is rejected, then my lord.
Right away covered by Mithilesh Garg.
My lord, if I may just convince you
Mithilesh Verma.
about one point, my lords, just one point. My
Lords, in 2021, by which time my TI was already vacated, that is when they start selling my land. My Lords, the joint development agreement to this day is not cancelled. The sharing agreement to this day is not cancelled. My Lords,
Anyway, that's the same thing that is projected in the civil suit.
illa. The
Same,
civil
same.
suit al ಕೇಳೋದು ಇಷ್ಟೇ ಸ್ವಾಮಿ. They are butting into my development project. Kindly restrain them.
No, they are restrained, their
I have produced the
TI
plaint,
has
my lord, the
been,
plaint
my
may
lord,
be
set
looked into.
aside by the appellate court. Senior civil judge, there is a finding, my lord. Clear finding. Page 82. The order commences at page 72.
Right, we'll take it on 3rd.
3rd February. The interim order,
Interim, okay,
we
continue.
may be permitted to file
From 3rd, we'll
rejoinder.
take it
We
complete.
will be permitted to file rejoinder.
Grateful.
Lord,
First,
we will be
30th ಗೆ
permitted to
ಮುಗ್ದೋಗುತ್ತೆ
file
ಇದು.
rejoinder and with
Whatever you
additional
want.
documents.
Yes. Heard the learned senior counsel Murthy Dinayak appearing for the petitioner and Mayur Dibano representing the respondents. List the matter on 3rd. The learned senior counsel is at liberty to file a rejoinder. To rejoinder, criminal case ಅಲ್ಲಿ.
They have filed a voluminous, my lord,
ಪರವಾಗಿಲ್ಲ ಅದಕ್ಕೇನು ರಿಪ್ಲೈ ಹಾಕ್ಬೇಕು. Will let us not term it as rejoinder and create another.
additional documents
Yes,
permitted to file. additional.
Whatever you want. Yes, next.
The interim order may be extended.
Excellent.
Grateful.
Yes.
Pleasure.
37. One day accommodation for furnishing the PF and process.
PF ಆ?
ಅದೇ PF ಅಂದ್ರೆ
Copy, petition of
copy
the
ಕೊಡ್ಬೇಕಾಗಿತ್ತು.
ಕಾಪಿ ಕೊಡಿ ಮೇಡಮ್.
Please,
ನೋಟಿಸ್ ಆಗಿಲ್ಲ ಫಸ್ಟ್ ಟೈಮ್
notice ಆಗಿದೆ. First time, this 1 and 2 ಗೆ notice ಆಗಿಲ್ಲ.
ಆಗಿದೆಯಾ? List on 3rd, needful be done by then. Interim order subsisting will continue to the next date of hearing. Next.
Much obliged.
38.
Offense is 302, my lord, sole accused.
302
Oh, yeah,
grounds
he
of
po-
arrest ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಹೇಳಿ. Only have a day after tomorrow, my lords, 22nd. Senior.
ಆಯ್ತು ಬರ್ಲಿ. We'll take it on again. 24th ಇದು. List on 4th.
Much obliged.
25 ಇದು. 5th, yes.
39.
But the respondent number showing 39.1 months.
An offense.
I have not received any papers.
Not received the papers, sir.
Already. I'll, offense are put,
420, 447, anyway, yes. Petitioner to serve set of papers upon the counsel representing the respondent, HP Leeladhar. First all ನಿಮ್ಮ ಹೆಸರು ತೋರಿಸಿಲ್ಲ?
ಅದು ನಮ್ದಲ್ಲ ಸರ್.
ನಿಮ್ದಲ್ಲ.
ಬೇರೆ ಯಾವ್ದು?
In 39.1, list the matter on 25, 24 and 25. So we'll take it on. List the matter on 11th February.
Yes.
Yes, interim order in any of these cases shall continue to the next date of
this
hearing.
case, interim order, one case was granted and another case it was not granted.
Same thing will continue. Yes, next.
40.
498 in-laws.
Time ಕೇಳಿದ್ರಿ ಮತ್ತೆ last time.
Lord, I was not well on day. I was ಹುಷಾರಿರ್ಲಿಲ್ಲ ಅವತ್ತು.
Accused number 1 is their husband.
I'm a in-laws.
The petitioners are accused 1, 2 and 3 in CC 541 of 2024 registered for offense punishable under section 490, 354 ಯಾರ ಮೇಲೆ?
Lord, it's against,
Where is the summary?
Lord, complaint is in page number 74.
Complaint ಅಲ್ಲ. Charge sheet.
Lord,
Come to
number-
page 72.
Lord, the against,
Yes. The petitioners are accused 1, 2 and 3. The summary of the charge sheet in CC so and so. The summary of the charge sheet reads as follows. Page 72, marked portion. Insofar as accused number 1, the allegations are horrendous of cruelty, assault, torture. He is the husband. Therefore, there is no question of grant of any interim order, qua the husband. Insofar as accused number 3 is concerned, he is said to have tortured the complainant wife by pulling the clothes and pulling the clothes. Therefore, the offense under section 354 has sprung against him. Therefore, there can be no stay of against accused number 3 as
Lord,
well.
he's suffering
Insofar
from-
as accused number 2 is concerned, there is no allegation of any ingredient of any offense. In that light, there shall be an interim order of stay only against accused
may I make
number
one
2.
One submission. My lord,
Discharge
he's-
reject agile.
ಅಲ್ಲ, he's my lord suffering from varicose. He even cannot my lord stand for 5 minutes.
ಆ 5 minutes ಅಲ್ಲೇ ಇದೆಲ್ಲ
My
ಮಾಡಿದ್ದೀರಾ?
lord, kindly my lord, I have enclosed the medical certificate also my lord against accused number 3.
All right, so and so. Finding no allegations that can permit for framing of charge or trial against accused number 2 and 3, the proceeding shall remain stayed qua accused number 2 and 3. However, it is made clear that the trial shall continue against accused number 1.
Great.
41.
ಇದು ಮಾಡಿದೆಯಾ? ಇಲ್ಲ. No representation, list after 2 weeks.
42.
For the petitioner, my lord.
For withdrawal ಅಂತ ಮೂವ್ ಮಾಡಿದ್ದೀರಾ?
ಇಲ್ಲ, for yesterday, my lord, so lordship directed them whether charge sheet has been filed or not.
Yesterday.
Charge sheet ಆಗಿದೆಯಾ?
It is filed, my lord.
Huh?
Charge sheet is filed.
ಮತ್ತೆ ಹಾಕಿದಾರಲ್ಲ.
Yesterday they have stated that not filed.
ಯಾವತ್ತು ಹಾಕಿರೋದು?
That's yes.
Yesterday also we were.
Yesterday ಹಾಕಿದ್ರೆ I will quash it.
I verified it was already filed.
ಚಾಲೆಂಜ್ ಮಾಡಿ ಅದಕ್ಕೇನಂತೆ?
Because I verified before the trial court.
ಚಾಲೆಂಜ್ ಮಾಡಿ.
Please.
Yes, charge sheet format, ಚಾಲೆಂಜ್ ಮಾಡಿ. Yes, next.
43.
Petitioner is a practicing advocate before Shumaga court.
Hmm.
The FIR has been registered punishable under section 352, 351 class 2, 115 class 2, 3 class 5 of the BNS Act.
ಇದಕ್ಕೆ ಇಲ್ಲಿ ಬಂದ್ಬಿಟ್ಟಿದೆ ಮೇಡಮ್.
Act of the cases.
ಬೇಲ್ ತಗೊಂಡಿದ್ದೀರಲ್ಲ?
Bail town.
We'll take it on Monday, fresh matters. List on Monday ಅಲ್ಲ, Tuesday ಅನ್ನೋದು. 27th, fresh matters list. Yes.
44.
Lord, the petitioner has filed an appeal before the Sessions Court challenging the order of acquittal, my lord.
20%
Allah, the IPC offense.
IPC offense.
I filed an application, 2 applications, my lord. One to summon a document which is before this honorable court, a record, trial court record which is before this court in RFA, and to refer the admitted and disputed signature for handwriting expert.
Before the appellate court.
Yes, my lord. My lord, that application, the pleadings are complete.
391 application.
Yes, my lord. My lord, on that ground itself, there was an acquittal by the trial court, my lord, because they have not produced the document. Your lordship may kindly peruse the observation of the trial court.
You are the complainant.
Yes, my lord.
You serve on the respondent.
No, I am only seeking a mandamus, my lord, because they.
For disposal.
Yes, my lord. The Sessions Court has not disposed of 1.5 years has elapsed.
The petitioner is before this court. What is the offense?
Lord's, its offense is 420.
We can't bind the courts like that, sir. 138 proceeding, adara summary adu kalisbodu.
My lord, 1.5 years, my lord. Before that, I had not moved.
The petitioner is before this court seeking the application matrana.
How the application?
The petitioner is before this court seeking the following prayer. The petitioner is the complainant, has filed, the accused have filed an appeal against the order of conviction.
My appeal is filed by the complainant. It's an order of
Acquittal.
Yes, ma'am.
The respondents are accused who gets acquitted of the offense in CC 10004 of 2017 in terms of an order of the concerned court dated 21/9/2023. Against the said order of acquittal, the petitioner complainant prefers an appeal in criminal appeal 1508 of 2023. The issue in the list does not pertain to the merit of the matter. The petitioner files an application under section 391 of the CRPC seeking certain documents and reference of certain documents for the handwriting expert. This application is kept pending despite about 10 adjournments being granted. Therefore, the petitioner is before this court seeking the aforesaid direction. In the light of the prayer being innocuous, and is only to disposal of an application which is kept pending for the last 18 months, I deem it appropriate to direct the concerned appellate court to dispose the application filed under section 391 of the CRPC in IA1 with an outer limit of 6 weeks from the date of receipt of the copy of this order in accordance with law, if not earlier.
I number 1 and 2, my lord.
One,
Section 91.
2 and 77, IA 1 and 2. Yes.
Deeply obliged, my lords.
45.
Offences under section 419 and 506 and 66, my lord. Civil suit filed in
List on
page number
27th in the fresh matters list.
46.
Vacation bench date idella.
My lord.
Adike 27th.
This also, my lord, it's a
Same,
declaration suit.
27th.
partition suit is pending.
Yen 27th or yen agbidalla bidi.
47.
Same. Oh, the 47 ಇವರು ರವಿಶಂಕರ್ದ
47.
ಯಾವ ಜಗದೀಶ್ ಸರ್? ಆಯ್ತು. List on 5th February. Current additional SPP is directed to accept notice for the respondent. Next.
48.
ಕೊಡಿ ಸರ್.
One is your lordship judgment, another is Justice Amaran.
ಯಾವ್ದು ಫಾಲೋ ಮಾಡ್ಲಿ ಈಗ?
But this Justice Amaran's judgment, your lordship may kindly see me. Paragraph number, page 16.
ಈಗ ಅಮರಣ್ಣ ಅವರವ್ರದ್ದು 138.
138.
ನಂದು 500.
And Justice Vishwajit Shetty's judgment is on 138. Yesterday I have produced. Where your lordship's judgments have been referred, even for 138 million, 223 at least, that is judgment.
Supreme Court does not say that you should be examined.
But Supreme Court in
O'Shea.
Justice Oka's judgment, it says earlier 200, now 223 has to be followed.
ಅಲ್ಲಿ ಕಂಪ್ಲೇಂಟ್ ಎಕ್ಸಾಮಿನ್ ಮಾಡಿರಲಿಲ್ಲ.
And
ಅಷ್ಟೇ, ಅದರಲ್ಲಿ ಏನು ಅಕ್ಯೂಸ್ ನೋಟಿಸ್ ಕೊಡಬೇಕು ಅಂತಿಲ್ಲ ಅದರಲ್ಲಿ.
Section 4(1) of the BNS Act is not been considered by Justice Amaran. Kindly have a look at section 4(1).
Special provision.
Special provision.
ಏನು special
4(1).
provision?
Let all offences under any other law
ಹೌದು.
shall be investigated, inquired into, tried, or otherwise dealt with according to the same provision, but subject to any enactment for the time being in force, regulating the manner or place of investigating, inquiring into, trying, or otherwise dealing with such offences. Therefore, section 4(1) says, Milord, it should be tried accordingly under section 223. And with reference to section 8 of the General Clauses Act. But General Clauses Act, kindly have a look at Milord, section 8. Any act which has been reenacted or modified with modification.
Section 5 ಓದಿ ಸರ್.
Yes, yes. Section 5 also. Nothing contained in this Sanhita shall, in the absence of a specific provision to the contrary, affect any special or local law for the time being in force, or any special jurisdiction or a power conferred, or any special form of procedure prescribed by any other law for the time being in force.
NI Act is the other law.
Correct. NI Act, Milord, only one second, one submission.
Anything else?
Only one second.
Yes.
NI Act does not, Milord, take a power to the court to, Milord, take cognizance. There is no independent provision. Under section 143 of the NI Act, Milord, it says, in so far as it has to be followed under section 143. 143 says, Milord, it should be tried summarily.
142.
Notwithstanding anything contained under 143 is the procedure. 143 says, Milord, judicial magistrate of the first class or a metropolitan magistrate, and the provisions to section 262 to 265, both inclusive of the said code, shall, in so far as may be applied to such trials. Therefore, notwithstanding, Milord, under section 223, it is only a power given to the magistrate to take cognizance under the BNS Act or the CRPC. Independently, Milord, the 138 does not give a power. Once the Milord, the BNS is made applicable, then the giving of notice is mandatory according to me.
ಅಷ್ಟೇ ಮುಗ್ದೋಯ್ತು. ಗಿವಿಂಗ್ ಆಫ್ ನೋಟಿಸ್ ಅದ್ರ ಮೇಲೆ ಒಂದು ರಿಟ್. ಮೊದಲೇ ಚೆಕ್ ಬೌನ್ಸ್ ಕೇಸ್ಗಳು ಅಷ್ಟೊಂದಿದ್ದಾವೆ, ಮತ್ತೊಂದು ಜೂರಿಸ್ಟಿಕ್ಷನ್ ಕ್ರಿಯೇಟ್ ಮಾಡ್ತೀವಿ ಸಮರಿ ಟ್ರಯಲ್ ಅಲ್ಲಿ.
And section 531, my lord, repealing of
531 repeal and savings does not protect you in any
under
manner.
section 8 of the General Clauses Act, my lord. ಅದರಲ್ಲಿ ಯಾವುದು ರೀಎನಾಕ್ಟ್ಮೆಂಟ್ ಮಾಡಿದ್ರೆ ಯಾವ್ದಿದೆ ಅದೇ ಆಕ್ಟ್ ಅನ್ನು ಫಾಲೋ ಮಾಡಬೇಕು ಅಂತ ಜನರಲ್
Yes,
ಕ್ಲಾಸಸ್
what I have
ಆಕ್ಟ್.
rendered is IPC offense.
Correct, your lordship, sir.
It is to be dealt with only under CRPC then or BNSS now. Now this is NI Act, it is a separate enactment. If there is no procedure prescribed, yes, but this is summary trial.
Procedure for taking cognizance, there is no procedure adopted
Anyway,
under the NI Act.
we'll answer it. This requires an answer, illare sumar bartave iಲ್ಲಿಗೆ.
Yes.
But reserved.
Till then, let the trial court.
ನಾಳೆ ನಡೆದಲ್ಲಿ ಕೊಟ್ಬಿಡ್ತೀನಿ. Yes.
49.
ನಾಳೆ ನಡೆಯಲ್ಲ, ಸೋಮವಾರ.
ಆಯ್ತು.
Yes.
Petitioner is accused number 1, my lords. Plus on 28/7/2022, I had yesterday's matter, my lords, I had issued notice to the complainant regarding the defamatory statement made by the complainant before the media. Then subsequently, my lords, after lapse of 6 days, he registers the complaint against this petitioner and others, my lords. During the course of investigation, the IO has registered. Now accused number 1, my lords, I was not there. Initially in FIR, they have mentioned that section 109 of IPC, my lords. I have instigated the other.
307.
109 of IPC, my lords, instigation. IPC 109. Then, my lords, in the complaint, he says that ಇವರ ಕಡೆ ನಂಜುಂಡ ಸ್ವಾಮಿಯವರ ಕಡೆಯವರಾದ ಇವರು ಬಂದು ನನಗೆ ಹೊಡೆದ್ರು ಅಂತ. That is the allegation, my lords. Then in the charge sheet, my lords, the IO has dropped the section 109 of the IPC.
What remains now?
Now, my lords, 448/323 and section 34 of IPC. I was not present at the place, my lords.
That's a pleading, we'll see. Learned additional SP, ಇದು vacation bench date ಕೊಟ್ರದ?
No, my lords, yesterday's matter I am.
The learned HCGP is directed to accept notice for the respondent. Emergent notice to the second respondent complainant returnable by the 19th of February, list on 19th of February. There shall be an interim order of stay of further proceedings by the petitioners till the next date. Petitioner till the next date of hearing. Next.
Please, my lord. Lord, limited grievance. But the condition imposed to deposit money in suspension of sentence, my lord, page 15.
20%.
ಅಲ್ಲ ಅದು NI Act ಅಲ್ಲ.
ಮತ್ತೆ ಇನ್ಯಾವುದು?
APMC ಇದು.
ಹಾ.
Lord, it was alleged that I purchased maize from traders and not paid the cess. Cess was supposed to be paid by the traders. I am the end user, I am the
ಈಗ ಎಷ್ಟು
consumer.
ಡೆಪಾಸಿಟ್ ಮಾಡಬೇಕು ಅಂತ ಹೇಳಿದ್ರೆ?
25%, Lord, of the fine amount. Fine amount is 50 lakhs.
All right, ಕುಡಿಯೋದು. The emergent notice, Swaroop ಅಲ್ಲ madam?
Swaroop.
Swaroop T is directed to accept notice for the respondent. Register to print the name of so and so as appearing for the respondent. This the matter on again 12th February. There shall be an interim order of stay for the stay as prayed for till the next date.
Great.
51.
ಇದು ಅದರೊಳಗೆ ಇಟ್ಟಿದೆ.
Let's say, number 138 permitted to deposit 20%. DD is also ready.
Learned counsel for the petitioner. The petition is preferred on the score that the concerned court has not permitted deposit of the 20% amount as it is deposited, it is being deposited after a long delay. The petitioner is the accused who gets convicted of the offense under section 138 of the Negotiable Instruments Act, files an appeal before the first appellate court and seeks suspension of sentence. The suspension of sentence is conditioned upon deposit of 20% amount. The said deposit is not made within the time. The petitioner is now ready with the demand draft of the deposit to be made before the concerned court. The order of the concerned court does not reflect total application of fine for directing deposit as is observed by the apex court in the case of Jambu Bandari versus so and so 2024 10 SCC page 483. In that light, the order is rendered unsustainable. Even otherwise, the petitioner is now ready to deposit the same within 1 week from today. The petitioner shall deposit before the concerned court within 1 week from today. In the light of the said submission that he would deposit, the order of the concerned court, though unsustainable, is not interfered with. Once the deposit is received, the concerned court shall regulate its procedure, ordered accordingly. Next.
52.
Lordships have directed this matter to be tagged along with another matter. Now that matter has been listed before quota 11 today.
Quota 11?
Yes.
GM matter?
Yes.
ಇದು ಅಲ್ಲೇ ಹೋಗ್ಲಿ.
No, my lords, that, in fact, this is the correct roster, my lords, but it's been displaced before that bench.
ಆಯ್ತು, I will take it on third.
Lord, kindly fourth, my lords. Possible.
Third, 23 mat, 23 ತಾನೇ ಇದು?
Yes, my lords.
Then don't disturb that. Yes.
May be directed for that matter to be placed before your lordships, my lords, kindly.
But ಇದು ಅಲ್ಲಿಗೆ ಹೋಗುತ್ತೆ ಅವಾಗ.
My lords, in fact, the order was passed by your lordships. Based on this order, my lords, the file has gone there. I don't understand why, my lords. It had to be tagged along with this matter.
ಅಲ್ಲಿಗೆ ಹೋಗುತ್ತೆ.
My lords?
ಅಲ್ಲ, ಇದನ್ನ ಟ್ಯಾಗ್ ಮಾಡಿದ್ರೆ ಅಲ್ಲಿಗೆ ಹೋಗುತ್ತೆ.
No, that's a 482 matter, my lords.
ಅದು 482?
Yes, my lords. It's been misplaced before that court, my lords.
The registry is there, the earlier petition in?
My lords, WP number 31287/24.
WP 31287 of 2024 was a successive writ petition that was filed, which ought to have been placed before the bench that had disposed the earlier petition. Learned counsel submits that the registry has erroneously placed it before the other. ಪಾಠಾಗಿದೆಯಾ?
ಇಲ್ಲ, ಏನೂ ಆಗಿಲ್ಲ.
Erroneously placed before before another bench. Therefore, the registry is directed to take appropriate steps in terms of the circular and tag this petition along with so on. Yes.
Grateful.
Next.
Preliminary hearing, 53.
I'm for the petitioner in this matter, my lord. For expeditious trial, my lord. The petitioner was cross-examined a record 13 times by the accused, my lord. Even then, cross-examination not completed.
Petitioner is before this court seeking expeditious disposal or conclusion of the trial in CC 845 of 2017. The petitioner is the complainant.
Yes, the de facto complainant.
Petitioner is the de facto complainant and the respondents are accused. The crime comes to be registered in the year 2013 and the charge sheet is filed in the year in 2017 in CC 845 of 2017. The petitioner is now before the court on the score that about 17 adjournments are already granted for the purpose of cross-examination of the accused. And therefore, there has been a gross delay in conclusion of the trial. In offense,
406.
And the offense being the ones punishable under 406 and 420 of the IPC. The dates are also indicated in the petition. If the dates are noticed, it is the concerned court has shown too much of lenience in granting time after time without rhyme or reason. In that light, I deem it appropriate to direct the concerned court to conclude the trial with an outer limit of 6 months from the date of receipt of the copy of the order, if not earlier.
Much
ordered accordingly. Next. Next, fifth aki.
55.
Same fifth aki. Intermodal idea?
No, my lords, it's not
ಏನಿದು?
That's offense under Copyrights Act and IT Act, my lords, and accused number 4, it's been quashed, my lords. And the court
Page-
is same, my lords, page, Annexure F, page 131. I'm only a manager, my lords.
ನೀವು accused number?
Accused number 2, my lords. Accused number 4 is a managing director and I'm only a manager. I was assigned with the role of looking after the.
ವಿನಯ್
archives.
ಮಹಾದೇವಯ್ಯ ಅಪೇರ್ ಆಗಿರೋದು. ವಿನಯ್, ನೀವೇ ಅಪೇರ್ ಆಗಿರೋದು. ನೋಡ್ಬಿಟ್ಟು ಹೇಳಿ.
Yesterday, my lords.
Yesterday's matter.
Yesterday's.
Covered on page 130. ನೋಡಿ, yes. List on fifth. Yes, next. ಟೈಮ್ ಬರ್ತಾರದ ಇರ್ಬೋದಾ? ಅಂತವರೆಗೂ ಆಗ್ಬೋದಾ ರವಿಶಂಕರ್?
Lords, 56, I am appearing for the petitioner.
Urgency ಇದೆ.
Lord says suit is filed, page number 61, where there is an order of.
We'll take it on Monday, ಆಗ್ಬೋದಾ ಅಂತ.
Lords, if your lords, the police are constantly harassing, I have stated so in the petition. They are calling upon the petitioner to be present in the police station to ensure that there is a settlement in the matter. This is the problem.
ಅದನ್ನ ಮಾಡಬೇಡಿ. Yes. The learned additional SPP is directed to accept notice for the respondent. The allegation is, despite grant of bail, the police are repeatedly summoning the petitioners and Bail ತಗೊಂಡಿಲ್ವಾ?
Lords, bail is not obtained in this matter yet. my lords.
Then you take bail, sir. Yes.
Lords, it's not about the bail, my lords. If your lords were to see, I have the benefit of an order of injunction against the complainant. Complainant goes and files a complaint saying that he was trying to put up compound wall and that I have disturbed. And
Then
police
we'll-
registers an FIR against me.
We'll take it on 27th. Now you don't strain. We'll take it on 27th. Yes. Yes.
Lords, the whole difficulty is I have to now subject myself to this police harassment, my lords. Even till such time I obtain the bail, it is not
Anyway.
going to be easy. Real estate matters, my lords.
The
police
additional
intelligence-
SPP will instruct. Don't worry. Monday will take. Yes.
Lords,
Monday, 27 Tuesday. Yes.
lords.
Fresh matters list. Yes.
Orders 57.
A week's time is granted to do the needful. Learned counsel submits needful has been done, office to verify. Next.
Interim order is correct.
Interim order continues.
58.
Non-compliance of office objection, IA1. A week's time is granted to comply with the office objections to the respondent number 2. Interim order continues.
59.
Memo for retirement. Office of same order, madam. 58 ಅಲ್ಲಿ ಏನ್ ಹೇಳಿದೆ? Same order 59 ಅಲ್ಲಿ. Next. Interim order continues. Next.
Interim order.
That will continue.
Much obliged.
Yes.
60.
Office objections. A week's time is granted to comply with the office objections. Quay the statement of objections. Interim order continues. Next.
61.
Petitioner.
Same order. Interim order
The
continues.
respondent has to comply.
Interim order, same order. Interim order continues.
Some
Next.
date, my lords. Absence of sanction for BMRCL engineers.
Quickly come, sir. 23 dates good.
I'm
Yes.
appealing for the petitioner in this case, my lord. After 17 years, this 498A complaint has been registered, my lord.
Interim order ಇದೆಯಲ್ಲ?
Mother of.
Interim order ಇದೆಯಾ ಇಲ್ವಾ?
Interim order ಇದೆ, my lord.
Office objection, quay the statement of objection.
To comply, my lord.
A week's time is granted to comply with the office objections.
My lord, date may be fixed, my lord.
last time
Since, my
objections
lord,
are
they have-
2 weeks time is granted to
Date-
comply with the office objections. Quay the statement of objections. Interim order continues. Next.
My date may be fixed,
No.
my lord.
Matter is settled, my lord.
Memo for withdrawal
Yes, my lord.
in terms of the memo. Next.
64.
64. A week's time is granted to do the needful. Interim order continues.
65.
Post immediately after service of notice upon the
Petitioners, my lord.
respondent. Interim order
My lord,
continues.
there is no interim order on 65, my lord.
No, that also will continue. Yes, next.
66, my lord.
Requesting.
The coordinate-
66.
the coordinate bench has permitted investigation.
ಯಾವ್ದ್ರಲ್ಲಿ sir?
66.
ಇದು
In fact,
ಇರಿ
your lordship-
2:30 ತಗೊಂತೀನಿ. I'll
67.
take this at 2:30. Yes, next.
Fresh matter, my lords.
67.
67,
That's for an offense under 3.
27th fresh matters list. Yes.
68.
May I request for interim order.
27th is a date, right?
Yes.
Yes. 68, 2 weeks time.
ಇದರಲ್ಲಿ settlement
67 complied.
Comply ಮಾಡಿ.
In the event office objections are complied with 67.
ಮಾಡಿದೀನಿ ಸ್ವಾಮಿ.
67 ಅಲ್ಲಿ, Brijesh,
Order sheet they are insisting, my lord.
whatever,
Till now,
yes.
Plus the translation of the
68, translation, office objections,
Typed
any
copy.
translation stands
Typed copy of the
rejected. Typed copy haki, yes. 68, 68, non-compliance of 1 to 3, 1 and 3.
ಅಲ್ಲ ಅದರಲ್ಲಿ ಏನು
Till office objections ಕೇಳಕ್ಕಾಗಲ್ಲ. 2 weeks time is granted to comply with the office
one
objections.
week, please, 1 week.
Yes, sir.
69.
ಅದೇನು ಸ್ಲೋ ಮೋಷನ್ ಇದ್ರೆ ಹೇಳಿ.
ಅಲ್ಲ ಅದರಲ್ಲಿ ಏನು ಅಬ್ಜೆಕ್ಷನ್ ಇದೆ ಅದು ಆಧಾರ್ ಕಾರ್ಡ್ ಅಲ್ಲಿ ಏನಿದೆ ಅದನ್ನೇ ಕೊಟ್ಟಿದ್ದೀನಿ ಸ್ವಾಮಿ.
ಕೌನ್ಸಿಲ್ ಸಬ್ಮಿಷನ್ ಬರ್ಕೊಡಿ. ಎಸ್.
ಅಲ್ಲ 2 weeks
69,
ಬೇಡ, 1 week ಕೊಡಿ ಅಂತ.
1 week.
Yes, much.
Yes.
69, my lord, I'm appearing.
69 ಏನು?
69 and 70, my lord, they're connected matters. This is against the.
First time ಬರ್ತಾ ಇರೋದಾ?
First time, my lord.
List on 27th in the fresh matters
Lord,
list.
there is an urgency in this case, my lords. The petitions will be rendered infructuous, my lords.
Why?
My lords, my colleague, my lords.
The matter is
Procedural
before
under
application
70.
authority.
Oh, this is a-
Immediately will appear in this matter.
We have silenced the search. We have silenced the search. There is a closure report in the predicate offense. And there the closure report is, the predicate offense is only of rupees 30,000. Where there is a closure report.
Let's see, we'll pass it over then.
My lord, ASG is appearing in this matter.
ಆಯ್ತು, ಬರಕ್ಕೆ ಹೇಳಿ.
He's not, he, 2:30 ಸ್ವಲ್ಪ inconvenience ಇದೆ ಅವ್ರಿಗೆ.
Tomorrow, my lord.
ಆಯ್ತು, ನಾಳೆ ತಗೊಂತೀವಿ. Yes.
71.
77, 69, 70 ಎರಡು ನಾಳೆ. Next.
71, my lord.
Hmm.
The peculiar order passed by the London Session Judge directing us to provide home cooked food. To the
Home
petition-
cooked food.
Home cooked food. on
ಅದೇ
oral
ದರ್ಶನ್
request.
ಕೇಸ್ ದಾ?
Yes, my lord. Though Supreme Court has directed no special treatment. If any special treatment is given, suspension of superintendent is what Supreme Court said.
Where is that order?
I'll place it.
ಯಾರಿಗೆ ಹೋಮ್ ಫುಡ್ ಕೊಟ್ಟಿದ್ದೀರಾ ಈಗ? ಯಾರು ಕೊಡಕ್ ಡೈರೆಕ್ಟ್ ಮಾಡಿದ್ದಾರೆ? ದರ್ಶನ್.
Accused number 1, Pavitra Gowda. Lordship is the last page, my lord. After para 27, Justice Padiwala's.
Five-star treatment.
Yes.
Five-star food ಕೇಳಿದ್ರಾ?
Now, ನಮ್ಮ food, it has been certified. All the foods are certified to the extent the 4-star ratings have been given to us.
ಇದು ಜೈಲ್ ಫುಡ್ 4-star.
In fact, my lord,
ಸಿರಾಜುದ್ದೀನ್ ಹೇಳ್ತಾರೆ ರಾಗಿ ಬಾಲ್ ಹಾಕಿದ್ರೆ ವಾಪಸ್ ಬರುತ್ತೆ ಅಂತ.
ಒಬ್ರಿಗೆ ಮಾತ್ರ ಹಂಗ ಅನ್ಸುತ್ತೆ ಅಷ್ಟೇ, ಇನ್ಯಾವುದು ಅನ್ಸಲ್ಲ.
If you throw a ragi ball, it will rebound back to you ಅಂತ. 4-star ಅಂತಿದ್ದೀರಾ ನೀವು?
4-star rating, my lord. Your lordship may see that order passed by the London magistrate, the substantive judge on page 38. Simply on oral instruction.
Where is the order?
Page 38, my lord. Page 38.
ಈಗ ಕೊಡಕ್ ಶುರು ಮಾಡಿದ್ದೀರಾ?
ಇಲ್ಲ ಕೊಟ್ಟಿಲ್ಲ. Now they issued a contempt, I've been told, my lord, that
Contempt notice.
show cause notice for not providing food.
Where is the order?
Order, my lord, page 38. London Council, accused number 1 and 11. Your lordship, see in the middle, my lord. Submitted that the jail authorities are not providing food to them.
Proper food to them and praise for allow them food from their respective home.
Then we move for clarification. We provided the details of the manner in which food has been cooked. My clarification, my lord, request for clarification is page number 41.
ಆಮೇಲೆ ಏನ್ ಬರ್ದ್ರ ಅದಕ್ಕೆ?
ಆಮೇಲೆ then he passed a detail order directing that detail order, my lord, lordship will see final order 35. Now, not only provide to them, provide to everybody in this case.
Everybody?
Your lordship may see the order, my lord, page 35. Clarification. It is clarified that the jail authorities, Central Prison Bengaluru, is hereby
strictly allow accused 1, 11 and 12 to get home food.
Once in a week. And when
Once in a week,
correct. And doctor advice include other accused persons in this case who are in JC.
Without any clarification.
Yes.
In case lapse is found, then Supreme Court contrary ಬರದೆ.
Now Supreme Court says I will be suspended if provide something. And there are prison manuals contemplates, my lord, that to file a complaint if there is any issue.
There are 11 and 12 euro.
Yes, ma'am.
The petitioner the state is the petitioner, calls in question an order of the concerned court dated 29
The two orders, my lord.
30/12/2025. 4 or 5? 2025 in SC 1319 of 2024.
And
The
clarification
application.
and clarification order.
And clarification and order on clarification dated
12th January.
12th January 2026. The issue is whether accused number 1, 11 and 12 are to be granted home food while serving sentence for offence punishable under section 302 of the IPC inter alia.
Under trial.
It could be granted to the detainees or under trial prisoners who are facing trial for offence punishable under section 302 inter alia. The petitioners, an application, learned counsel, the concerned court files an application, the accused number 1, 11 and 12 submitted before the concerned court at the time of trial that they are not being provided proper food and therefore they should be given home food. This is allowed straight away by an order on 29/12/2025. The state immediately files an application seeking clarification 25. FACCI has given 4-star rating to the food that is given in the jail for it to be for it being nutritious. The clarification is answered by the following order, page 35. Not only the accused 1, 11 and 12, all the persons who are accused in the said crime must be granted home food without any clarification or even without a doctor or as and when the doctor advises to the other accused. Therefore, the apex court in this very case had observed as follows. The apex court observes, however high the person may be, the law would be above him, and obedience to law is demanded as a right, not asked as a favor. The accused persons are being provided some special or 5-star treatment within the jail authorities. If it is found, the apex court observes, the day we come to know that the accused persons are provided with some special or 5-star treatment in jail premises, the first step in the process will be to place the jail superintendent under suspension, including all other officials involved in such misconduct. The apex court observes that providing special food to certain prisoners, albeit they are under trial prisoners, would be a misconduct. The concerned court, in complete or blatant ignorance of what the apex court has observed in this very case concerning, in the very case of Darshan and other accused who are facing trial as afore observed, has now issued a show cause notice even to the state as to why the food is not granted as is directed by the court. While it is true that food can be granted from the house under special circumstances, for which elaborate procedure is prescribed under the prison rules, all the procedure is given a go by, and an order is passed which runs completely counter to the order passed by the apex court. Therefore, the order passed by the apex court, as the apex court has held, a prisoner is a prisoner, the under trial prisoner or otherwise, special treatment to some and normal treatment to some would be in violation of law. This is what the concerned court has now directed. In that light, I deem it appropriate to stay the order dated, orders dated?
Orders 29/12 and 12
Stay
January.
the order dated
9/12.
29/12/2026 and 12/1/2026 till the next date of hearing. Emergent notice to the respondents. Ing serve ಮಾಡ್ತೀರಾ ಅಲ್ಲೇ?
Still service.
Respondents be served through the jail superintendent. Yes. Enter ಮಾಡಿದ್ಯಾ? क्या ಯಾವ ಲಿಸ್ಟ್ ಅದು? ಯಾವ 23 ಇದೆ? List number 2 will repeat according to the years from 3rd February. Entry models LLA continue.
Serial number 35. The lordships have directed the office to place a file before the lordships along with that serial number 72. 2 orders have already been passed, my lords. To this day, they're not placing the file before.
Which one? ಈಗ ಹೇಳಿದ್ನಲ್ಲ.
Serial number 72, my lords.
72 ಈಗ ಯಾವ ಇದ್ರಲ್ಲ?
Yes, my lords. List 1.
Modification ಅಂತ ಏನೋ ಇದೆ ಅಲ್ಲಿ?
Yes, my lords. ಇದ್ರಲ್ಲಿ ಏನಾಗುತ್ತೆ ಸ್ವಾಮಿ, ತಮ್ಮ ಮುಂದೆ ಸ್ಟೇ ಆಗುತ್ತೆ. In the meantime, they go before the current roster bench and they seek an order for speedy disposal. And your lordships had stayed the matter at that point in time.
ಅದು registry to tag the petition along with
WP number 18915/20.
72 ಅಲ್ಲಿ ಮೇಡಮ್.
Orders already passed. Order pass ಆಗಿದ್ರು ಅವ್ರು ಫೈಲ್ ತರ್ತಾ ಇಲ್ಲ.
Registry to show cause as to why the orders passed not once but twice is being dodged. The file shall be placed before the Tarsi madam. File, tagging the petition is being dodged deliberately, yes.
Serial number 35, my lord. 30,
It's number
35, my
two.
lord. My lord,
So, ಎಲ್ಲ
compromise.
ಊಟ ಮಾಡಿದ್ದೀರಾ?
My lord, once
ಮಾಡಿದ್ದೀರಲ್ಲ?
more. My lord.
Reporting.
Lordship's kind leave, my lord.
ಎಲ್ಲರೂ ಊಟ ಮಾಡಿದ್ದಾರೆ.
Madam.
Ma'am, whether we are audible? Courtmaster, ma'am.
ಸೀನಿಯಾರಿಟಿ ಮ್ಯಾಮ್ ಅಲ್ಲಿ ಮೇಲ್ ಬರ್ದಿರೋದು ನೋಡ್ಬೇಕು ನೀವೆಲ್ಲ ಕೇಳ್ಬೇಡಿ. ಮಧ್ಯಾಹ್ನ ಹೇಳ್ತೀನಿ. ಫ್ರೆಶ್ ಮಾಡ್ರಿ ತಾನೇ. ಸೆವೆಂಟಿ ಒನ್ ಆಗಿದೆ, 72 ಆಗಿದೆ, 72 ಥರ್ಡ್ಗೆ ಡೇಟ್ ಅಲ್ವಾ? ಥರ್ಡ್ಗೆ, ಥರ್ಡ್ ಅಲ್ಲ ಫೋರ್ತ್ಗೆ, ಸಾರಿ. ಅವ್ರ ಹೆಚ್ ಡಿ ನಮ್ಗೆ ಹೇಳ್ಬೇಕು. ಹತ್ತು ಗಂಟೆ ಕುತ್ಕೋತೀವಿ ನಾವು. ನಾಳೆ ಎಲ್ಲ ಒಂದೇ, ಯಾವ ಕೊಟ್ಟರು ಒಂದೇ ನಾವು ಕೊಟ್ಟರು. ಏನದು? ಒನ್ ವೀಕ್ ಕೊಟ್ಟರೆ ಎಂಟ್ರಿ ಮಾಡಿ ಎಕ್ಸ್ಟೆಂಡ್. ಇಲ್ಲಿದೆ ಅಲ್ಲ ಫುಲ್ ಕಂಪ್ಲೀಟ್ ಆಗಬೇಕು. ನಿನ್ನೆ ಬಂದಿಲ್ಲ ಕೇಳಿ, ನಿನ್ನೆನೂ ಮಿಸ್ ಆಯ್ತದು.
No, my lords, it's a
Then
Supreme-
no, my lords.
my lords, my lords, that order was passed on the submission of the accused person themselves, my lords. And even, my lords, the submission, no objection of the SPP, my lords, as
Who's
per
the
the
Univen?
SPP, my lords, their
Prasanna Kumar was
application was
SPP.
filed by the
Your Lordship has
SPP.
seen the order.
Clarification
There
was
is
filed by
nothing
the
in the order to
SPP.
say that you
Order
haven't
ಏನ್ ಬರ್ದಿಲ್ವಲ್ಲ?
heard.
My lords,
ಆರ್ಡರ್ ಅವ್ರು ಹೇಳಿದಾರೆ ಅಂತ ಏನ್ ಬರ್ದಿಲ್ವಲ್ಲ?
my lords, that application was filed on behalf of SPP and the clarification was also filed on behalf of SPP, my lords. And the submission was also made by the SPP Prasanna Kumar, sir, my lords.
That is on the
Then, my
clarification,
lords, when
not
we
on the
filed
order.
the, my lords, my submission that, my lords, that order may be set aside today itself, my lords. But, my lords, there should not be any unfair to the all the, my lords. My lords, the very same order, the very same facility given to the another accused, my lords, in
Which
another
accused?
case.
Which accused?
In another case, another accused, I'll place it, my lords,
Kodi,
have it
kodi.
till tomorrow, my lords. That order has not been challenged by the jail authorities, my lords. And when we filed the contempt petition before the trial court, they approached this honorable court by suppressing all those things, my lords. My lords, that order was passed on 29th, my lords. Till filing of petition before this honorable court or till today, my lords, when the trial court issues the show cause notice, till then, my lords, they have not given till then they have not completed the orders of the judiciary, my lords. That's why we brought to the notice of the trial court. Trial court has took serious
No,
note on
my
that.
only concern is trial court could not have passed orders contrary to the Supreme Court's order, which said no special treatment shall be given to these
No
people.
special, only, my lords, home food weekly once, my lords. We made the submission weekly once because, my lords, A1 suffering from heart disease, my lords. That another accused suffering from, he is aged about 56 years, my lords. We are seeking only, my lords, per day, my lords, the jail authority is spending 85 rupees to all the prisoners. Only 85 rupees for breakfast, lunch and dinner, my lords. There is no quality foods, my lords. Even we have a CCTV
4-star
footage.
ಬಂದಿದೆ ಅಂತಾರೆ?
No, I'll place it the data, my
No
lords.
star?
No, sir, nothing, my lords. There is a national issue. Some person obtained some. No, my lords, we are not seeking biryani. Just, my lords, my lords, Honorable Supreme Court says that, my lords, there is no special treatment. My lords, we are requesting for at least minimum basic treatment to all the
Let them
prisoners.
show one complaint
No,
filing.
This prisoner, that prisoner illa. If nutritious
Everyone,
food has to be given, every prisoner, every human
My lords,
being
my
is the
submission
same.
that, my lords, I visited the jail, my lords. There is a CCTV footages. My lords, ಅಲ್ಲಿ shoes ಮತ್ತೆ ಚಪ್ಪಲಿನೂ ಅದೇ ಇದರಲ್ಲಿ ಚೆಕ್ ಸ್ಕ್ಯಾನ್ ಮಾಡ್ತಾರೆ, my lords. Even food also same. There, this honorable court may call for CCTV footages.
There
The
is
quality 85
pursuant to
rupees game, my
Supreme
lords.
Court order, there is
Though,
a
my lords,
committee.
How much do you spend on a?
85 rupees. I'll place it the
I'll
data.
secure the
On a
record.
particular under trial prisoner?
I'll secure the record.
85 rupees, my lords. I have RTI data also. Someone has obtained the RTI details. And, my lords, we are seeking for minimum food per person, my lords. One day,
It is not Darshan or somebody involved. in it.
anyone, my lords.
Any human being, the prisoners are also human beings. They should get
Well,
food, what you get, everybody should get.
Yes, literally, my lords, the honorable court order for shifting of the prisoners. Absolutely, we are no objection, my lord. They are till today, they are kept in quarantine. As per the jail manual, my lord, there is a provision of only keeping the prisoner 15 days. Now, after even lapse of 5 months, my lord, they are keeping in quarantine. Absolutely, we are not quarantined. We are ready to stay there only. Now, my lord, they are treating literally, my lord, inhuman. I visited the jail, my lord, as a counsel on the record to all the accused persons. And, my lord, the food, shoes, chappli, advocates, police officers, ಎಲ್ಲರದು ಅಲ್ಲೇನೆ. Even their CCTV footages, cameras also. Otherly food, my lord, dinner, they will give dinner at 5 o'clock, my lord.
That's very healthy, actually.
Now, your lordship can summon the records from the CMM who supposed to visit the prison on a surprise visit. Your lordship can summon those records from the authority.
I endeavor this, my
And
lord.
let's see what
Till
the-
today, my lord, the attitude of the jail authorities. Let them, my lord, this order may be set aside. Absolutely, I am not quarrel with. Why they have not completed the orders of the judiciary, my lord? Till today,
No,
till
we
today.
moved
My lord,
clarification immediately.
The wife of the accused number 11 suffering from cancer, my lord. 3 o'clock correspondent, my lord, daily. 3 to 6 o'clock, and they have taken my Aadhaar card, they have taken my permission, everything. ಎಲ್ಲಾನು ತಗೊಂಡು, and even one of the official MLA MP who is in jail, my lords, ಅವರಿಗೆ separate ಒಂದು ಕುಕ್ ಕೊಟ್ಟಿದ್ದಾರೆ. That order has been passed by the judiciary. That order has not been challenged by the very state itself.
Let them show.
I'll produce it, my lords. This,
ಕೊಡಿ, ಎಲ್ಲ
sir, is
ಕೊಡಿ.
SPP, additional SPP appearing as SPP.
Give,
in that
give
matter,
everything, give everything.
I'll give, my lords,
Clear,
kindly have it
produce
tomorrow, my lords,
everything.
I'll take notice.
I'll take it day after tomorrow, you give everything.
Yes, my lords. I'll place all those materials, my
Friday.
lords. Till then, my lords, the interim order, even till today, they are not giving any
ನೀವು
food.
ಕೊಟ್ಟಿಲ್ಲಲ್ಲ, ಇನ್ನು 2 ದಿನ ಸುಮ್ಮನೆ ಇರಿ.
But, my lords, the conduct and attitude of the
That
jail
we
authorities,
will answer all
that
that.
kind may
We
be
will
noted.
answer all that. You produce every detail here.
Yes, my
Let
lord.
them file the details, my lord.
Let you file every detail.
Let, my lords, the direction to the appear SPP also, my lords, because that was submission was made by the SPP.
Get
He is
Prasanna Kumar.
representing.
Get Prasanna Kumar.
Yes, my lord.
So lordship,
Yes,
kind
day after
permission,
tomorrow,
my
get
lord.
Prasanna Kumar.
Yes, my lord.
Serial number 15 in the list number 2, my lord. Some urgency is this, my lord. It has been settled before the Lok Adalat. Subsequently, R2 took it to the session judge, stating that one of the matter is non-compoundable, and it was taken. for rupees 13 lakhs, we have paid 29 lakhs.
ಆಯ್ತು ಒಂದ್ ನಿಮಿಷ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಕರೀತೀನಿ.
Now list number 15, my lord.
Wait.
Sorry, my lord.
One
Yes.
request, Lords, that stay may be, my lords, shall not come in the way of, because my lords, we have moved in contempt petition. The trial,
ತಪ್ಪಾಗುತ್ತೆ ಅದಕ್ಕೋಸ್ಕರ ಮೂವ್ ಮಾಡುತ್ತೆ. 2 ದಿನ ವೇಟ್ ಮಾಡಿ, we will decide the issue.
because my lords, the trial court has
there is-
all for the explanation.
there is
That's it. Let them
elaborate-
give explanation, my
No,
lords.
there is elaborate procedure to draw special treatment to be given to anybody. ಅದು ಯಾರ್ಯಾರು ಕೊಟ್ಟಿದ್ದಾರೆ ಸ್ವಲ್ಪ ಕೊಡಿ.
I'll give, my lords, I'll give everything, and
Give
even I'll
every
give
detail, give it.
Yes, present FIRs
The
and
state
also
is,
the.
if the state is partisan that way,
Yes, my lord.
you show me the person, I'll tell you the law ಅಂತ ಇದ್ರೆ,
Yes,
we will treat them.
Even I'll file application before this honorable court, my lords, for calling of the details to how many prisoners they are giving the special treatment.
ಈಗ ಸ್ವಲ್ಪ ಏನಾರು ಅಮಾಯಕಸ್ ಬೇಕು ಅಂದ್ರೆ ಸಿರಾಜುದ್ದೀನ್ ಕರ್ಕೊಂಡ್ ಬನ್ನಿ.
Madam,
ಜೈಲ್ ಪೂರ್ತಿ ಗೊತ್ತು ಅವ್ರಿಗೆ.
Lordship.
let him, my lords, because if he is appearing for some, let him appear, my lords, absolutely we don't have
We'll
any
see.
objection.
Yes.
Because there must be a truth, my lord, that's it, my
ನೀವು
lord.
ಸುನಿಲ್ ತಾನೇ? ಸುನಿಲ್ ಎಲ್ಲ ತಗೊಂಡ್ ಬನ್ನಿ.
Yes, my lord.
Friday, my lord, not Thursday.
Till then, my lords, my one humble request is, my lords, the trial court
ಈಗ
has called
food
for
ಇಲ್ಲಿವರೆಗೂ
explanation.
ಕೊಟ್ಟಿಲ್ಲ.
ಕೊಟ್ಟಿಲ್ಲ,
Day
my
after on Friday I will decide.
But then, my lord, let them give explanation, my lords, because
They will give it here, don't worry.
They-
Clarification ಹಾಕಿದ್ರು ತಾನೆ. Clarification reject ಆಗಿರೋ 12th ತಾನೆ.
No, clarification was not rejected, my lords.
Is rejected,
No,
sir.
my lords, it is not rejected, it is modified, because earlier order.
Modified, give everybody ಅಂತ modification ಇರೋದು.
No, my lords, not everybody, with particularly that accused persons, ಅವ್ರಿಗೆ with the opinion of the doctor. ಅಷ್ಟೇ, my lords, ಮಾಡಿರೋದು. Earlier order ಅಲ್ಲಿ all dates ಅಂತ ಮಾಡಿದ್ರು, then we made the submission before the honorable court.
Friday ವರೆಗೂ.
Lord.
Friday.
You are interested in food or their explanation?
Mostly looks
Both,
like
my lords,
explanation.
because they are not obeying the orders of the constitutional
see.
courts, also the
Yes.
courts, both, my lords, on both.
Lordship. serial-
I've been
serial-
told ಇನ್ನು ಜಾಸ್ತಿ ಕೇಳಿದ್ರಂತೆ, ಪ್ರಸನ್ನ ಕುಮಾರ್ ಹೇಳ್ತಾ ಇದ್ರು ನನಗೆ.
ಆಯ್ತು, ಬರ್ಲಿ
Prasanna Kumar,
ready?
come on.
This,
Prasanna Kumar sir is also there, my lords.
Get Prasanna Kumar
Yes, sir.
on Friday.
Yes.
ಅದೇ jail food for Darshan and others.
Please.
Not Darshan, the
Other
other accused. ಅದೇನೋ ನೀವು ಒಪ್ಕೊಂಡಿದ್ದೀರಂತಲ್ಲಿ?
Plus they made the submission that
It
as per
is-
the
You
manual.
made the submission ante?
The submission which we made is that as per jail manual, please provide them. That is all we made.
All right, we'll see. Yes.
No.
I'll take notice,
Respond to
respond
the
number 2 and 3.
Learned Counsel Sunil Kumar accepts notice for all the respondents.
2 and 3 only.
2 and 3. And CBI,
Him
your
may be-
SPP ಇದರ ಪಾರ್ಟಿ ಇದರಲ್ಲಿ?
He is not party, I'll ask him to come.
Ask him to come.
Name may be reflected.
Registered to print the name of P. Prasanna Kumar, Special Public Prosecutor in the case, as directed to appear before by the court.
Lordship, serial number 35, my lord. The compromise matter, my lord. They told, in morning it was for preliminary hearing, my lord. They informed me that it will be settled. Now they are telling it will not be settled, my lord. It may be taken for preliminary hearing
We'll take
because
it.
on another date, my lord.
ಆಯ್ತು, ತೊಂದ್ರೆ ಇಲ್ಲ. ಇಲ್ಲದೆ ನೋಡಿ time. ನಾವು ರಿಪೀಟಿಂಗ್ ಸೆಟಲ್ಮೆಂಟ್ ನೆಕ್ಸ್ಟ್ ಫಸ್ಟ್ ಮೇಲೆ ಹಾಕ್ಬಿಡ್ಬೇಕು. ಇವತ್ತಿನ ಕರೆದು ಬಿಡಿ, ಏನ್ ಮಾಡಕ್ಕಾಗಲ್ಲ.
Serial number 15 ಮೇಲೆ
Wait sir, we'll take it on. ಯಾವ ವರ್ಷದ್ದು?
23 ದಿವಸ.
23 ಮಂಗಳವಾರ ಬರುತ್ತೆ.
Urgency is this matter. That's my kindly see. Matter has been settled before the Loga by the complainant, who have paid for 13 lakhs, 29 lakhs were paid.
ನೀವು ಅಕ್ಯೂಸ್ಡ್ ಕಂಪ್ಲೇನೆಂಟ್?
Accused.
ಹಾ.
Accused.
ಏನ್
Now
ಹೇಳಿ?
the matter is posted for charge. ಅದಕ್ಕೆ
ಸೆಟ್ಲ್ ಆಗಿದೆಯಾ?
settle ಆಗಿದೆ ಸ್ವಾಮಿ. I will produce the document.
Posted for charge in what proceeding?
420 and other offenses.
138 ಅಲ್ಲಿ ಸೆಟ್ಲ್ ಆಗಿದೆ.
138 ಅಲ್ಲ ಸ್ವಾಮಿ.
ಇದರಲ್ಲೇ ಸೆಟ್ಲ್ ಆಗಿದೆಯಾ?
ಅಲ್ಲ, ಇದು ಏನಂದ್ರೆ it is a question of allotment of sites. We failed to allot the sites.
ಕಂಪ್ಲೇನೆಂಟ್ ಯಾರು?
Complaint R2 ಸ್ವಾಮಿ.
ಅಲ್ಲ ಇದಾರ ಅವರು?
ಅವ್ರು ಬಂದಿಲ್ಲ ಸ್ವಾಮಿ.
ನಾಳೆ ಬರ್ತಾರೆ ಬಿಡಿ, ಹಾಕೋಣ. 15 ಇದೊಂದು ನಾಳೆಗೆ ಹಾಕೋಣ.
My lord, 35 also.
In fresh list ಮೇಲೆ.
ಇರೋದೇ ಒಂದ್ ಲಿಸ್ಟ್. 3:30ಗೆ ಎದ್ದೇಳ್ತಾ ಇದೀನಿ, ಅದಕ್ಕೋಸ್ಕರನೇ ಪ್ರಾಬ್ಲಮ್. ಇಲ್ಲದ್ರೆ ಎಲ್ಲರ ಮೆಮೊನು ತಗೊಂತೀನಿ. ಒಂದ್ಸರಿ ಇಂಟರ್ವ್ಯೂಸ್ ಮುಗಿದು February 2nd ಇಂದ ವಿಲ್ ರೆಗ್ಯುಲೇಟ್.
Date may be given, my lord. Shortest date, my lord. We are.
ಯಾವ ವರ್ಷದ?
ಮಕ್ಕಳು ಅವರು minors ಎಲ್ಲ.
ಯಾವ ವರ್ಷ?
25, my lord.
23 ಆದ್ರೆ ಟ್ಯೂಸ್ಡೇ.
23, my lord.
24 ಆದ್ರೆ ವೆಡ್ನೆಸ್ಡೇ, 25 ಆದ್ರೆ ಥರ್ಸ್ಡೇ. ನೆಕ್ಸ್ಟ್ ಪಾಸ್ಓವರ್ ಆಗಿದೆ. ನೆಕ್ಸ್ಟ್ ಥರ್ಸ್ಡೇ. Yes.
Our matter they compromise, my lord.
Whatever. Yes.
Reporting settlement 83.
ಮೇಡಮ್ ಆಮೇಲೆ 83 ಸೆಟಲ್ಮೆಂಟ್ ಆದ ತಕ್ಷಣ 84 ಇದು ತಗೊಳ್ಳಿ. ಅದೊಂದು connected matters ಇದೆ ನೋಡಿ. Third list, take that.
83, reporting settlement.
I'm filing the
Offense.
application along with the affidavit.
Offense.
376.
376, Lordship.
Come on, merits. 23, list the matter on 3rd February. No settlement in 37. Promise to marry?
No, no.
Yes, Lordship.
Huh?
Promise to marry.
Promise
but
to
my
marry,
lords,
Lordship.
she also wants to, my lords, to get married
Correct, sir. You get married to whom?
to other person.
To other person. We'll close it on merits. 376, I will not settle it.
Both parties are
All
agreed,
right.
Lordship. by intervention of
Maybe
the
all the parties idru parvailla. 3rd February, I'll post it. We'll close it on merits.
marriage, Lordship. She is also planning to get
ಈ
married.
ಥರ್ಡ್ ಒಳಗ್ ಮದುವೆ ಆಗ್ಬೇಕಾಗಿದ್ಯಾ?
Please,
ಇಲ್ಲ ತಾನೆ?
No.
Wait, 3rd February.
Yes, Lord.
3rd February, I'll close it on merits because it's
Please,
23 ಮೇಲೆ ಬರುತ್ತೆ.
Please.
ಮೇಡಮ್ ಇದು ಸೀನಿಯಾರಿಟಿ ಪ್ರಕಾರ ಹಾಕ್ತಾ ಇದ್ದೀರಾ ತಾನೆ ಎಲ್ಲ?
84,
The fresh matter is.
Offense.
323, 324, JJ.
Appearing to the
Lordship, in
JJ Act ಯಾಕೆ?
Lordship, in RFA, matter is settled. Kindly see the paragraph
ಕೊಡಿ
7,
ಕೊಡಿ ಅದು ಕೊಡಿ.
page 7, paragraph 4, your Lordship.
ಹೌದು ಅದೊಂದು ಫ್ಲಾಗ್ ಹಾಕ್ಬಿಡಿ ಮೇಡಮ್ ಕೊಡಿ.
May I just make a submission, Lords? The position is.
ಒಂದು ನಿಮಿಷ ಅದು ನೋಡ್ಬಿಟ್ರೆ ತಾವು page 7, paragraph.
Is it settled or not settled, Mithun?
It has been settled, but an undertaking was given that they will complete the entire compromise as per the undertaking given, Lords. The compromise
that's
also
not
has
done
been
today?
recorded. They have not,
That's not
they have
done.
not completed.
List
Lordship,
on-
we have done, Lordship, we have handed over
I
the
was just
question.
requesting Mr. Anil,
Settlement always on equal terms, whatever it is.
Lordship, we have handed over the question, your Lordship.
ಇಲ್ಲ ಅಂತ
undertaking will.
ಅಲ್ಲ ಕೊಟ್ಟಿದ್ದೀವಿ.
I'll just hand over.
Question
if there
ಕೊಟ್ಟಿದ್ದೀವಿ.
is any ambiguity, settlemental argument ಮಾಡಬೇಡಿ. Argument ಮಾಡಿ settlement ಆಗಿರೋದು ಮತ್ತೆ argument
ಅಲ್ಲ,
ಮಾಡಬೇಕು.
question
I
ಕೊಟ್ಬಿಟ್ಟಿದ್ದೀವಿ.
requested Mr. Naveen now because he requested that in the position totally undertaking ಕೊಡ್ತೀನಿ ಅಂತ. I told my client, please take, don't dispute anymore. In fact, I sent my
Now you
colleague.
want me to close the proceeding?
No, no, I'm
or
only
not?
saying, I request Naveen, at least by next date, let them complete the
Next date,
process.
yes, list the matter on 2nd February at 4:30 PM to report settlement. Yes.
Please.
Second, Rajana? Monday ಬೇಡ, 3rd, yes. Madam, ಅವತ್ತು ಇಂಟರ್ವ್ಯೂ ಇಲ್ಲ. ಕೊಡ್ತೇನೆ. Second yearly, yes.
85,
Offense.
My lord, the petitioner is present with the DD and gold, my lords.
DD, oh, ಅದು.
Also to recall yesterday, I got a call from a learned friend saying that all the items are in Hoskote. Please ask your client to go to Hoskote to go down and come.
My lords, will see that it is delivered to their
Sorry,
home, my
my
lords.
ಈಗ
But they
ನಾನೇ
are not-
bailable warrant issue ಮಾಡ್ಲಾ?
My lords, we are.
ಈಗ
ready-
ಕೊಡ್ತೀರಾ ಇಲ್ಲ issue ಮಾಡ್ಲಾ?
My lords, we are ready to give it to them.
Give it, sir.
And the excuse is that the go down person is saying, no, you cannot take it
So
today.
now,
I don't understand, my lord.
if you are giving it, fine. I'll take this tomorrow as the first case. If it is not given, bailable warrant issue.
My lords, the items are.
ಇಲ್ಲ NBWA issue ಮಾಡ್ತಾರೆ.
My lords, items are kept in go down.
Wherever.
They are not allowing today and tomorrow because
Why?
there is no staff for them to deliver the items to their residents, my lords. That is the problem.
ಯಾರು?
They have sent-
Who is the packer?
Safe storage. Safe storage.
Safe storage.
Please, my
ಒಂದು
lord.
notice issue ಮಾಡಿ.
They have sent
We'll
a ma-
send the police.
They have sent a mail.
We'll send the police today to that place. Staff ಎಷ್ಟಿದ್ದಾರೆ ಎಲ್ಲ ಗೊತ್ತಾಗುತ್ತೆ. Husband is dodging this ಅಂದ್ರೆ I am not going to keep quiet. Don't behave,
My lords.
don't act too smart or behave too
My
much.
lords, on the last date of hearing.
ಎಲ್ಲ ಬೇಡ. Yes.
My lords, one submission.
ಅಡಿಷನಲ್ SPP ಅವರೇ, ಆ ಸೇಫ್ ಸ್ಟೋರೇಜ್ ನ ಸ್ವಲ್ಪ ಸಾಯಂಕಾಲ ಇನ್ಸ್ಪೆಕ್ಟ್ ಮಾಡಿಸಿ. ಆರ್ಡರ್ ಮಾಡ್ಲಾ? The petitioner is before the court. Though after a settlement is dodging the items to be delivered to the wife. The wife has been roaming pillar to post to get her articles from the hands of the
My
husband.
lords, sorry.
The husband,
One submission, my lord.
the husband has received 22,000 rupees for the purpose of transport of materials of the wife. Even then, it is not delivered. It is said to be placed in a safe storage, and it is said that these officers of the safe storage are not giving the items as there are no staff to give the items. Therefore, the state shall cause an inspection from the hands of the jurisdictional police and see to that it is delivered. This order is passed solely on the default of the husband, notwithstanding the settlement and the amount being received to deliver the items of the petitioner, of the wife to his hands.
My lord.
I'll release this order, let the jurisdictional police inspect. Safe storage will become unsafe. Yes.
My lords, one submission.
Yes,
my lords.
sir.
On the last date of hearing.
ಅದೆಲ್ಲ
all
ಗೊತ್ತಿಲ್ಲ.
the items were-
ಇವತ್ತು ಕೊಡ್ಬೇಕಾಗಿತ್ತು, ಕೊಟ್ಟಿಲ್ಲ, ಪೊಲೀಸ್ ತಗೊಂತಾರೆ ಬಿಡಿ. Let not the husbands play in this court. Yes. All right.
Wait, my lord.
Tomorrow. Yes.
Please, Oblesh.
Address ಕೊಡಿ. Address.
ಸೇಫ್ ಸ್ಟೋರೇಜ್ ಅಡ್ರೆಸ್ ಕೊಡಿ. ಹಾ ಸರಿ. Tomorrow.
86.
Petitioners, parties are present.
Offense.
490.
ಆಯ್ತು 323 ಟ್ರಯಬಲ್ ಅಫೆನ್ಸ್ ಕಾಂಪೌಂಡ್ ಮಾಡಕ್ ಆಗದೇ ಇಲ್ಲ. ಎಸ್ ತಗೊಳ್ಳಿ ಮೇಡಮ್. ನೀವು 320 302 ಹೇಳ್ದಂಗೆ ಹೇಳ್ತಾ ಇದ್ದೀರಾ. ಎಸ್
Order sheet signatures.
Yes.
87.
ಸೆಕೆಂಡ್. ಎಸ್
88.
Both the parties are present.
Offense.
Offense is 418, 380, 504 finance.
All right, ತಗೊಳ್ಳಿ.
Compound. ಅಲ್ಲ ಮ್ಯಾಟರ್ ಸೆಟ್ಲ್ ಆಗಿದೆ. ಸಿವಿಲ್
ಆಯ್ತು, ಎಲ್ಲಿದೆ ಸೆಟಲ್ಮೆಂಟ್?
ಸೆಟಲ್ಮೆಂಟ್ ಐ ಪ್ರೊಡ್ಯೂಸ್ ದಿ
ಹಾಕಿದ್ದಾರೆ.
ಐ ನಮ್ಮ
89.
ಎಲ್ಲದೂ ಫ್ಲಾಗ್ ಹಾಕೊಂತೀರಾ?
Respondent to.
Offense.
354 minus case and counter case.
Other parties. Case and counter case. Why?
Manish, the petitioner has filed the complaint against the respondent. The respondent has filed the complaint against the petitioner.
Both
the
settled,
offenses are 354 Manish.
All are present?
Yes, Manish.
Yes.
But your date ಕೊಟ್ಟಿರೋ ಸಮಯ connected matter ಅದು ಮಧ್ಯಾಹ್ನ ಮೂವ್ ಮಾಡಿದ್ರು 2:30.
1706.
ಬರುತ್ತೆ ಅದು. ಬಂದಿದೆ. ಎಸ್ ಕೊಡಿ ಅದು. ಸೆಟಲ್ಮೆಂಟ್ ಕೊಡಿ.
17063.
ಅದು ಬಂದಿಲ್ಲ ಅಲ್ಲ.
ಬಂದಿಲ್ಲ ಅಂದ್ರೆ ಅದು ಲಿಸ್ಟ್ ಮಾಡಿಸ್ಬಿಡಿ. ಲಿಸ್ಟ್ ಮಾಡಿಸ್ಬಿಡಿ. ಎಸ್.
Order sheet signature.
89.
89 ಆಗಿದೆ.
ಆಗ ಮುಗಿತಲ್ಲ.
Number 3, number 2, one call. List number 3, seal number 1.
Serial number 2. Serial number 1. Today senior has some inconvenience.
As I appear in serial number 1.1.
1.1, my lord.
I am a paternal father to the disease. In no way, this section doesn't attract me.
ಆಯ್ತು, ಸ್ಟೇ ಇದೆಯಲ್ಲ? ಇದೆ. ಎಸ್. 3rd.
Have it at 2:30.
List on 3rd February. A further hearing at 2:30. Yes. 2:30 on 3rd.
Grateful.
Number 2.
But in this case, my lord, I appeal for the Ministry of Home Affairs. Lord, this matter is with regard to, my lord, the freezing of the bank accounts by the law enforcement agencies. Lord,
It's not pertaining to non-submission of KYC.
This one? No.
Serial number 2.
ಇಲ್ಲ, ಇದ್ಯಾವ್ದು ಬೇರೆ ಇರಬೇಕು. 2.1.
2.1, my lord, time for the series of matters.
28.
Series of correct. What he says is correct. Freezing of bank account.
Yes, 28/446. It is related to non-submission of the KYC documents. KYC documents.
ಅಕ್ಷತಾ ಮೇಡಮ್. ನಿಮ್ದೆ ಅಕ್ಷತಾ ಶೆಟ್ಟಿ ಯಾರು?
2. ಅದೇ ಸರ್.
2ನೇ.
Serial number 2.
Not for non-submission of KYC, my lord.
ಮತ್ತೆ freezing of account ತಾನೆ?
Freezing of account. There was a complaint filed against the.
Correct. Who said KYC document?
My lord, we wrote a mail. I got instruction from the bank. They have not submitted the KYC documents. My lord, the account went to dormant.
Freezing of account gido, not by law enforcement agency, not by you.
No, my lord, as far as
Is it not freezing?
It's not freezing, my lord.
It is 15123.
Debit freezing, my lord, for lodging of complaint. There was no crime registered.
Francis.
Yes, my lord, I have taken the instruction.
Prayer nodi page 11
As far as
alli.
Yes Bank is concerned, my lord. As far as Yes Bank is concerned.
No. Look at this. Page 11 ಅಲ್ಲಿ prayer ಇದೆ ಹೇಳಿ.
Freezing and defreezing, sir.
Correct. That is good.
Freezing ಮತ್ತೆ.
Yeah. My learned friend is saying that this freeze because of non-submission of the KYC.
KYC, not otherwise in this matter. As far as Yes Bank is concerned.
Law enforcement agencies ಅಂತಾರೆ ಕಂಪ್ಲೇಂಟ್ ಇದೆ ಅಂತ.
ಅದು RBL bank, SBI ಇದು Yes Bank ಏನೋ ಹಾಕಿಲ್ಲ ಅವರು.
ನೀವು earlier bank ಎಲ್ಲ. Yes.
Please,
very
please,
all of them are freezing, right?
For indefinite period. For indefinite.
ಅದೇ indefinite period freezing. ಕಾರಣ ಅದನ್ನ ಕೇಳೋಣ. Yes.
Please, my lord. In this case, my lord, there is a standard operating procedure when it comes to freezing and defreezing, which is the SOP is by the Ministry of Home Affairs. My lord, to demonstrate it, my lord, the ACP I4C is online, my lord. He would demonstrate it, my lord, how it works, my lord. He just wanted to appraise the court.
Let him, yes.
Sir Singh, sir, Jitendra Singh, sir, you can continue.
Yeah, good afternoon, sir. Shall I share the PPT, sir?
Oh, through the PPT, is it?
Please.
All
Sir,
right.
the presentation also and the SOP copy also, sir. Both, sir, we have, sir.
You will also be benefited by this. Yes. Yes.
So we need the access to share it, sir.
Madam, accept.
Accept kodi, submit alla.
ಇಲ್ಲ ಆಗುತ್ತೆ.
Yes, confirm.
Yes.
Sir. It's not coming complete. Entire screen. Screen को बना दीजिए.
Yes, sir.
Sir, just a second, sir. It's taking some time to share, sir. It's coming, sir. This is the process, sir.
No, Shanti Bhushan, please. It is better it is on paper.
Sir, this is the 4 mechanisms through which we can file the complaint on the NCRP portal, sir. The one is the portal website which can be accessed online by any citizen and file their complaints related to financial fraud and any cyber crime in the country, sir. Another mechanism, the person who is not able to file online complaints, he can directly call from his number on 1930. All states UT have 24/7 call centers to accept these calls for the victims. They file the complaint and which is updated on NCRP portal, sir. Another mechanism is a mobile application which can be installed on the mobile phone and the complaint can be filed, sir. One is if the nearest bank is there, he can go to his bank and file the complaint. Cyber help desk is established in all the banks to file the complaints from there, sir. Nearest cyber police station he can visit and file the complaint. So these are the mechanisms and the methods how he can file the complaints on related to cyber crime in the country, sir. So this is first mechanism which is filed through NCRP portal, sir. On the top we can see once he filed a complaint on the NCRP portal, he visits and creates his own account. After creating the account, he fills the entire detail related to his transactions or any cybercrime details, his personal details, his ID, and the suspect data ID, sir. Whatever is required in the forms to be filled, then it is acknowledged by the portal and a 14-digit acknowledgement number which starts from 2 is generated, sir, and an SMS is received to the concerned victim.
Yes.
Sir. And this, once it is submitted, it is directly visible to the SHO and the state and the district officers, which is appointed to a concerned investigation officer. And stage by stage, SMS has been delivered to the victim that this is the stage of his complaint and he has to contact this person, sir. And after reaching to a concerned investigation officer, the process is started. If it is in a financial fraud complaint on a portal, the concerned SHO or district officer push the complaint to the bank bucket. This is called CF RMS, sir. There's a module behind NCRP portal wherein 1,000 banks are integrated and financial intermediaries are integrated with this portal, sir. Once it's reached to the portal, its mechanism starts, sir. The victim bank updates the records, and once the records are updated, he pushes to the beneficiary bank. The beneficiary bank receives the concerned request. He looks after his details in the bank, particular bank account. If the amount is available in that bank account, which is the beneficiary bank account, he put holds on that amount and updates the record. If the amount is further layered into further beneficiary bank accounts, then the ticket request is further pushed to the concerned bank. In this manner, the layer keeps on going. Wherever the money is available, it is put in hold, sir. If the money has exited from the system, till the check or e-commerce or any mod is adopted by the suspect, if the money is out of the system, then the records are updated on and he is intimated the victim is intimated that the money has been exited or the amount of money which is hold is sent to the victim through SMS message and email, sir. Both mechanism is there, sir. This is the mechanism which is running through portal, sir. Next is, sir, the mechanism, sir, through banks also. The same process, he can reaches to any bank, and the cyber help desk available in the bank can also file a complaint related to a victim, sir. Third mechanism is, sir, 1930 call center, sir. Any person who is a victim of a cybercrime can call 1930. The call center in the respective state will attend the call, file the complaint. After finalization of the complaint, a SMS will be sent to the concerned person, which starts from 3. This means that the complaint is already filed into the banking bucket. Call center is directly connected to the banking bucket. The ticket is immediately pushed to the beneficiary, the victim's bank. Victim's bank updates the records where the money has been gone. That ticket is then immediately pushed to the concerned bank. The bank put in holds if the amount is lying there. Otherwise, the details are uploaded, and similar fashion, the layering goes on, and till the money is exited from the system, it is updated the records, sir. This is the mechanism how it works, sir. And this is the entire mechanism how it works.
Now, one moment.
Yes, sir.
Now, DSJ,
Please.
now the Ministry of Home Affairs has drawn this.
Please, my lord.
Now are the banks not following this? Because there's an elaborate procedure from the beginning till the debit freeze happens.
Please.
Where is the procedure followed in all these cases?
Lord, this
Now
SOP
1930 call bharat.
Please.
1930 call is recorded, and the banking bucket will, the bucket of banks that are there,
Please.
communication will be sent straight away of a cyber crime.
Please.
Now, when communication is sent of a cyber crime, then when will it get, when the debit freeze will happen? That's the end thing. Now, debit freeze first time ಮಾಡ್ಬಿಡ್ತಾ ಇದ್ರು.
It's not that, my lord. Once, my lord, the law enforcement agencies, my lord.
No, I understood what he told.
Please,
it's quite graphical also. It's not the thing. But without following procedure, if you straight away debit freeze,
then they'll have to follow it.
they'll have to follow the procedure. If an SOP is there for debit freezing,
Please,
and that SOP is not followed by this, who appears with the state here? Is Jagdish Ali? No, I.
Initially, my lord, SOP was not there. This SOP came into force, my lord.
12/20/25. So henceforth you will follow this.
Please, my lord. They'll have
SOP
to. My
will
lord,
direct
this
the
SOP
state.
is formed after, my lord, consultation.
Indefinite period, how? Anybody will not be able to operate the account.
No, my lord, it's not indefinite period.
No,
my lord. Now, in this
Jagdish,
case.
This
Sir, may I
SOP
assist
is there.
May I assist the honorable court, sir, related to this matter?
Yes, yes.
Sir, we have elaborated. If the SOP copy is available in the front of the honorable court, sir, I can assist you.
Yes, no, it is here. I have a copy itself.
Yes, sir. We can go to, sir, on page number. We can see, sir.
No, I just want the state also to come into the loop here.
Yes, sir.
You have debit frozen all these accounts. There is a standard operating procedure by the Ministry of Home Affairs. You adopt it and issue a circular. It's already done or what? You issue a circular so that this procedure is followed and no loopholes are left of procedural aberrations.
So one order has already been passed by the Honorable Karnataka High Court in one court, sir, wherein the DG has been directed to adopt this mechanism and issue the circulars to hold Karnataka, sir. One of the case has already been done.
All right, we'll amplify this.
Yes, sir.
Whatever order is passed there, we'll amplify and hold the state responsible if you don't follow this procedure. Everybody will be safe. ಸುಮ್ಮನೆ ಯಾರೋ ಕಂಪ್ಲೇಂಟ್ ಹೋಗೋದು, ಇನ್ವೆಸ್ಟಿಗೇಟಿಂಗ್ ಆಫೀಸರ್ ಗೊತ್ತು ಅವ್ರಿಗೆ ಚೆನ್ನಾಗಿ ಫ್ರೀಸ್ ಮಾಡಿಸೋದು, ಇದೇ ಆಗ್ತಿರೋದು.
Amount involved in the commission offense that could be freeze. That is not an issue. But the entire account has been frozen. My lordship cannot be.
See, marking, ನೀವೇ ಒಂದು ಸರ್ಕ್ಯುಲರ್ ಇಶ್ಯೂ ಮಾಡಿದ್ದೀರಾ ಸ್ಟೇಟ್ ಜಗದೀಶ್ ಅವರ, ಏನಂದ್ರೆ ಫ್ರೀಸ್ ಮಾಡಬಾರ್ದು, ಲೀನ್ ಮಾತ್ರ ಮಾರ್ಕ್ ಮಾಡಬೇಕು ಅಂತ. ಹೌದಾ? ಸಿ, ಲೀನ್ ಮಾತ್ರ ಮಾರ್ಕ್ ಮಾಡಬೇಕು ಅಂದ್ರೆ ವಾಟ್ ಇಸ್ ದ ಡಿಸ್ಪ್ಯೂಟೆಡ್ ಅಮೌಂಟ್, ಅದಕ್ಕೆ ಲೀನ್ ಮಾರ್ಕ್ ಮಾಡಿ. Now is the entire amount debit frozen, entire account debit frozen.
If I could.
ನಿಮ್ದು ಅಕ್ಷತಾ ಮೇಡಮ್ ಯಾವಾಗ ಆಯ್ತು?
2022.
3 ವರ್ಷ ಸರ್ಕ್ಯುಲರ್ ಬಂದಿರೋದು ಈಗ 24 ಅಲ್ಲಿ.
My case is different, my lord. That is pertaining to cyber crime, whatever the process they have shown. Idu police station ge hogi ಒಂದು complaint file ಮಾಡಿದ್ರು. They called me. I'm a company rendering financial services. 2-3 customer ಬಂದು ತೊಂದ್ರೆ ಅಂತ ಹೇಳಿದ್ರು. They called me. Then and there I settled it. Further ಏನಾದ್ರು claims ಇದ್ರು I'll settle it ಅಂತ ಹೇಳಿದ್ದೇನೆ. They have sent the intimation to the bank. All my bank accounts have been freezed from 2022. ಅಲ್ಲಿಂದ further investigation ಇಲ್ಲ. Crime has not been registered. Magistrate ಗೂ report ಮಾಡೋದಿಲ್ಲ. This is my case.
Wait, we'll answer all the ನಿಮ್ದೇನು?
My lords, if I could seek, my lords.
One moment, sir.
Multiple liens are being marked with respect to the single offense. Because the police, there have been single complaint would be filed before the multiple police stations. So each police station, they comes up and they mark a lien. Here, according to this particular thing, the disputed amount in my case, this is writ petition 35/2020.
How much is it?
1,50,000. But here the lien has been marked for 3 lakhs in my case.
I will see.
Multiple.
My lords, if I could seek my lord's indulgence, my lords.
In which matter, sir?
My lords, 2.1, my lords.
I have some time constraint today. I'll take all these matters again.
May I make one submission, my lords, and there is minus answer.
Yes, sir.
My lords, in my matter, my lords, 2.1, there is a memo, my lords, that I have filed on 7/7, my lords, 7/7/2025, where, my lords, the cybercrime police station clearly says that I am one of the victim, my lords. In my case, my lords, is a bit different. They portray to me, my lords, that they are one of Angel One brokers, my lords. This is called Angel Book. I have, my lords, paid 5 lakhs. I have got my 5 lakhs back.
Your angel broking.
I am a citizen, my lords. I am a individual. They portrayed to me, my lords, that they are part of Angel One group and they wanted to seek an investment from me. I, my lords, first paid 5 lakhs. Then I got an email from Angel One saying that we have no other subsidiaries. So, my lords, what I did was, when they told me to invest more, I said, you first give me back my money, then I will invest, which they gave back. It is only 5 lakhs, but they've lien marked it to 82 lakhs, my lords. And they say that I am the victim. Therefore, my lords, insofar as mine 2.1 is concerned, my lords may consider.
Insofar as
all right, Yella Vatke, I'll take it on.
Insofar as defreezing.
We'll answer separately 2.1. Yes. List on third interim orders and idea. Ella third will dispose it.
My lords, could mine, my lords, alone be on the second, my lords, 2.1? Third,
no, not
some small
second.
inconvenience.
No, let it be on third. I'll if you want any other date, I'll give it to you on that day. Yes.
Very well, my lords. My lords, I would only seek, my lords, if I could appear on VC on that day, my lords. I'll appear on VC on that day.
Whatever you want, sir.
Lord, in this SOP, my lord, insofar as
no, I'll also
50,000
see the
and
SOP,
less than 50,000, my lord, the pass are given to the concerned LEA only, my lord. The half of the.
Let me see them. Yes.
In my case, it's below 30,000 only, my lordship, but they are not considered the concerned IO. Have represented even the IR official of the concerned police station.
Yes, third. 230 more matter.
230 more matters. Fresh matters. Seal number 1, GM Sharad Kumar.
Great.
Harassment petition. Filing joint memo.
Settle. ಯಾವತ್ತು ಆಗ್ತೀರಾ?
ಇವತ್ತು parties are present.
ನಾನು 3:30ಗೆ ಎದ್ದೇಳಬೇಕು. ಪ್ಲೀಸ್ ಇದ್ರು ಆಗಲ್ಲ. ಇಂಟರ್ವ್ಯೂಸ್ ಇದೆ. ಆ ಫೈಲ್ ಜೊತೆ ಒಂದು ಚೇಂಬರ್ ಕಳಿಸ್ಬಿಡಿ ಬೇಡ. ಸೆಟ್ಲ್ ಆಗಿದ್ರೆ ಕೊಡಿ, ಇಲ್ಲಾಂದ್ರೆ ನಾಳೆಗೆ
ಸೆಟ್ಲ್ ಆಗಿದೆ.
ಕೊಡಿ. ಎಸ್. ಒಫೆನ್ಸ್ ಏನು?
326, 504 and
326
352, 196, 118 surplus to pub ಅಲ್ಲಿ.
ಎಲ್ಲಿ ಹೊಡೆದ್ರಿ?
ಇವ್ರು ಹೊಡೆದಿಲ್ಲ ಸ್ವಾಮಿ. A1 ಹೊಡೆದ್ರು. ಇದು A2 ಮೇಲೆ.
ನೀವು ಯಾರು?
A2.
A2 ಸೆಟಲ್ಮೆಂಟ್ A2 ಮಾತ್ರನಾ?
A2 ಮಾತ್ರ.
ಯಾವ ಪಬ್ ಇದು?
ಚಿಂಗ್ಲಾಂಗ್.
ಚಿಂಗ್ಲಾಂಗ್. ಎಸ್. ಆಲ್ ರೈಟ್. ಎಸ್. A2 ಕೊಡಿ. A2 ತಾನೆ A1 ಮೇಲೆ ಇರೋದೆಲ್ಲ. ಅಲ್ಲಿ ಫೈಂಡಿಂಗ್ ಆಲ್ ದಿ ಅಲಿಗೇಷನ್ಸ್ ಅಗೇನ್ಸ್ಟ್ ಅಕ್ಯೂಸ್ ನಂಬರ್ 1, though the offense is punishable under 326 of the IPC, I deem it appropriate to accept the aforesaid compounding application and the joint memo and obliterate the proceedings against the accused number 2. Yes.
All sheets. Bill number 2, Rohan Kotar.
Petitioner. Your Lordship, for the petitioner, I apologize for not being in court physically.
Yes, tell me.
Your Lordship, the two aspects of the matter, Your Lordship. One, the magistrate passes an order to.
Why did you move it at 2:30? You said some emergency. What is that?
The urgency, Your Lordship, is the magistrate has passed the order for defreezing and releasing the amount in the name of the complaint in
releasing
favor of
the
the
amount.
complainant
Without
without
hearing the
notice.
account holder, how can the magistrate do it? The petitioner is the account holder. On certain allegation, the amount in the account of the petitioner is now ordered to be paid to the complainant without hearing the petitioner, the account holder. This court in plethora of cases has directed the magistrate not to do so while answering an application under 450 and 457 of the CRPC. Notwithstanding the same, it is being repeated. Therefore, the order shall remain state, order dated 10/8/2025 shall remain, order dated 18/12/25 and 23/12/25 shall remain state till the next date. Yes. Emergent notice, relevant additional SPP for the state, emergent notice to the second respondent. Who second respondent?
Private complainant, one Meghna.
The emergent notice to second respondent. Petitioner is also at liberty to serve on the counsel who represents the complainant before the concerned court. Yes, next.
I'm obliged.
Admission seal number 3. Shri Nishant SK.
Appearing for the petitioner, my lord. 420 and 468, my lord.
Move ಮಾಡಿದ್ಯಾ 230 ಗೆ?
My lord, the reason was
Settlement.
summons was issued. No, my lord.
Then?
Summons was issued, my lord, and the petitioner, my lord, recently gave birth.
Oh, gave birth to. The petitioner accused number 1. The learned counsel of the petitioner submits that the petitioner is delivered and is unable to attend the court proceedings. Therefore, till the next date of hearing, the petitioner is accused number 1 is exempted from appearance before the concerned court.
Request for my interim order.
Interim order, appearance ಅಷ್ಟೇ ತಾನೆ?
Challenge the entire proceedings.
ಅದಾಮೇಲೆ, yes. Stay ಕೊಟ್ಟಿಲ್ವಾ?
No, my lord, my lord.
23 ಇದೆ ಇದು.
25, my lord.
25.
It's a civil dispute, my lord.
List the matter on Tuesday in the fresh matters list. Yes, next.
Seal number 4. Shri Vasant Kumar, withdraw.
Petition is moved seeking withdrawal of the petition. Petition is disposed as withdrawn. Yes, Ravi Shankar. ಏನ್ judgment ಹಾಕಿದ್ದಾರೆ ಅಂದ್ರಲ್ಲ ಯಾವುದು?
38 have been initiated against directors of a company without arraying the company as a party. The urgency is this matter is more posted before the trial court.
ಇಲ್ಲಿವರೆಗೆ ಏನ್ ಮಾಡ್ತಾ ಇರ್ತೀರಾ ನೀವು? ಅಲ್ಲ ಅದಾಯ್ತು ಸರ್, ಇಲ್ಲಿವರೆಗೆ ಏನ್ ಮಾಡ್ತಿರ್ತೀರಾ?
Hello, I moved this matter on Wednesday minutes. It was directed to.
ಸರ್ 2025 ಏನ್ ಮಾಡ್ತಾ ಇದ್ರಿ ಅದೇಳಿ?
Hello, I moved it in the vacation minutes. I filed it in the vacation minutes.
ಅಲ್ಲ, what did your client do for ages? The problem is they sleep ಆರಾಮ್ಸೆ. ಇಲ್ಲಿ ಯಾವಾಗ ಅರ್ಜೆಂಟ್ ನಿಮ್ಮ ಹತ್ರ ಬಂದಾಗ ಅರ್ಜೆನ್ಸಿ ನಮಗೆ.
I apologize.
What you apologize?
Well, it's the complaint lordships of.
Petitioner to serve on the counsel who represents the respondent in the trial proceedings. List the matter on 19th February. There shall be an interim order of stay of further proceedings before the concerned court. Next.
Can request for handle brief.
Kodi. Satnarayan.
I'm grateful.
Ungrateful. I am grateful.
Bring the petition. Now permitted to withdraw the petition.
Thank you, sir.
Anybody to challenge charge.
Yes. Next.
Reporting settlement seal number 7. Siddharth Suman.
The connected matters not all negotiable in fact all settled.
ಯಾವುದು ಅದು ಲಾರಿ ಇದಾ?
ಇಲ್ಲ ಇದಾಯ್ತು.
So the matter has been settled. I appear for the borrower, Miluj. So Miluj, they are permitted to be filing a joint memo for withdrawal.
File, when do you file? Yes, sir, yes. Offense ಏನು?
Not negotiable instruments act.
138.
138 ECS mandate also.
Anyway, yes. That will be found. All three, yes.
Please, grateful.
Parties? Ilva?
Parties they are appearing online. Parties appearing online.
Identified. Anyway, you said 138. Yes.
Please.
10. Venkatesh Somare.
Appearing for petitioner, my lord. Joint memo has been already placed on record. Joint memo has been already placed.
Offense.
On 318 and 316, 318 and 336.
406, 420.
Outside.
ಎಲ್ಲಿದೆ ಕೊಡಿ?
Parties are present.
ಆಯ್ತು, ಇದು ಕೊಡಿ ಮೇಡಮ್, ಫ್ಲಾಗ್ ಹಾಕೊಡಿ. ಎಸ್ ಫಾಸ್ಟ್ ಓವರ್ ಯಾವ್ದು ಕೊಡಿ? ನಂಜರೆಡ್ಡಿ ಅವ್ರು ತಗೊಳ್ಳಿ, ನಂಜರೆಡ್ಡಿ ಅವ್ರು ತಗೊಳ್ಳಿ. ಎಸ್ ವೆಯ್ಟ್.
$66.
Yes, sir.
Three properties were purchased by the complainant. In respect of that, my lords, when Radha filed a civil suit, that my lords would get at page 81. In that suit, my lord, the prayer is
Anjali, sir.
for a declaration that the sale deeds executed in my favor are bad, and also for mandatory injunction. Therefore, the plaintiff admits that I am in possession of the property. Then not there, this was in April 2025. The suit is in progress. Then thereafter, after 6 months, the FIR is filed at page 19, where at page 21, I am accused as accused number 8. Then at page 22, 24, my lords, the complaint starts at page 23, narration, and page 24, fifth line from the top. ಇದಲ್ಲದೆ ಎರಡನೇ ಗುಂಪಿನ ಶ್ರೀಮತಿ ರಾಧಾ ವೆಂಕಟರಾಮ ನಾಯ್ಡು ಕೋಲಾ, petitioner is Venkatram Naidu Kola.
Yes.
About that, at the end, till the end of that paragraph is the allegation. There is no criminality or no element of any offense is indicated in that. Then, my lords, on that the investigation commences, and which my lord stayed. Now, my lords, the application for vacating stay has been filed, saying that in respect of one accused in team 1, this court had said, let the investigation go on.
That is what Justice M.I.
Yes, if my lords look at FIR, the set of allegations against team 1 is totally different from set of allegations against me.
So your team 2.
I am named in team 2. I am not part of any team. Why should I be having a team?
Yes, sir.
And then the allegation is that there is a forgery of the sale deeds. That is the exact issue in civil suit. It is for the plaintiff there to prove that the sale deeds are forged. Now, by filing a complaint, what she wants to do is burden which is on her in the civil suit. She would, by invoking the criminal motions, they would like to shift the burden onto me. These are identical circumstances. Supreme Court has said.
I have many.
Burden, particularly allegation of fraud, where it is in the civil court, then you cannot shift the burden by just filing a FIR. Para 20 of that judgment.
Rajesh Bhai.
Yes. Para 20 of that judgment squarely covers my issue.
Yes.
The distinguishing feature, see the nature of allegations between the two teams. ಒಟ್ಟು 3 team ಮಾಡಿದ್ದಾರೆ. I did not even read what is team 3 because since team 1 allegations are held against me, I read it.
Yes, sir. Yes.
There are 4.
ಅಲ್ಲೂ forgery ತಾನೆ ಕೇಳಿರೋದು.
Just
4 teams.
There are 4 Radha.
4 Radha.
4 jana Radha claiming to be the owners of the property. Now, my lord, so far as the petitioner is concerned, one lady impersonates in conspiracy with the present petitioner, sells the property. One lady claimed on a will by name Radha, my lord, so she gets a portion of the compensation. My lord, one Radha, my lord, so impersonate the present complainant and sells away the very same property. My lord, considering all these facts, coordinate bench has said it is a case involving impersonation and forgery, therefore permitted investigation to be continued. Now, my lord, the investigation, I am told, even FSL report has come now, indicating that there is a forgery of documents.
There is no Radha?
My lord, I am the original person.
You are Radha?
Yes. There are 3 more Radhas are there who claim to be the property owner. The properties has been dealt.
So this is team Radha.
Team of Radhas.
There can be 16,000 Radhas also, my lord. The question is,
we have
when you have initiated a civil suit against me,
on the same ground.
On the same grounds.
Just because civil suit is, latest Supreme Court says that, my lord, just because suit is pending, criminal proceedings need not be obliterated.
So
that is a
judgments are there both ways.
So, my lord, this is a case where 4 persons are claiming to be property, including myself. My specific allegations are original documents with me, title deeds I have submitted to the FSL. They have been examined by the concerned IO.
IO papers, investing papers,
very interesting.
Otherwise, it is purely a civil matter.
No, this has to be investigated. Therefore, noting the claims, my lord, the coordinate bench has said, don't take coercive steps. Please go on with the investigation.
The coercive steps ತಗೊಂಡಿಲ್ವಲ್ಲ?
ಅಲ್ಲ ಇದರಲ್ಲಿ
ಸ್ಟೇನೇ ಇದೆ.
So,
Introductory ಇದೆ.
Malad,
Lord,
in the
in the
connected
judgment
matter.
that my learned friend is citing, at paragraph 23, Supreme Court arrives at a specific finding. By reading the FIR, the contents of the FIR, prima facie case is made out. Here I am on FIR. What is the allegation?
Malad, contents of the complaint would show, Malad, FIR cannot be an encyclopedia. Contents of the complaint
All
would
right,
show.
there should be some semblance of an offense.
Definitely.
When you have yourself registered a civil case
Malad, civil case is for
on the
recovery of
same ground for the same relief.
Malad, your lordship may kindly consider. Civil case is for recovery of the property. But so far as the offences are concerned, the logical hand has to be seen. Now, Malad, I can understand it is.
See, in the civil suit, if in case the court finds, yes, there is forgery, there is fraud.
Then I will be liable for criminal action.
The point is, Malad, so one cannot be replacement of other proceedings. What my humble submission is, there are 3 persons other than me claiming to be Radha have dealt with the property.
You do
My
not even know
allegation is,
whether-
my allegation
It
is that they are
true
in.
to say that whether he is real rather.
Malad, that's what I'm saying. Yes, my learned senior is correct, Malad. That has to be investigated. That's what I'm trying to say. He is claiming through XYZ. Incidentally, Malad, the father's name, husband's name, all the documents are same for all the Radhas. So, Malad, there cannot be.
ನೀವು real rather ಅನ್ನೋದು.
ಗೊತ್ತಿಲ್ಲ ಅದಕ್ಕೆ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಆಗಲಿ ಅಂತ ಹೇಳ್ತಾರೆ. ಅದಕ್ಕೆ there are allegations, Malad. So I think
The family trees produced are different things. And one of the Radha, my lord, who executes a will in December, 10 days later she dies mysteriously.
Mysterious.
ಎಲ್ಲ ಇನ್ವೆಸ್ಟಿಗೇಟ್ ಮಾಡಿ ಮರ್ಡರ್ ಎಲ್ಲ ನೀವು ಮರ್ಡರ್ ಚಾರ್ಜ್
please see the order passed by the coordinate bench along with the vacating step.
That I have seen.
Same thing, Malad, we are requesting. Let the investigation, let
No,
him not be.
there was no interim order. Here there is an
No,
interim
Malad.
order.
Lordships have said this crime needs to be investigated. Therefore, not to take coercive steps.
That's a different accused. Huh?
Different accused. Malad,
Different
these are all-
accused and this is different.
It is team one accused.
Oh, team
But
one.
This is all part of same conspiracy, collecting bits and pieces by projecting somebody as Radha, by impersonation.
The property belongs to Radha. We'll see. That result.
Great.
Other documents.
I'll place it.
Heard the learned senior counsel P.S. Rajagopal appearing for the petitioner and the learned counsel Venkatesh Dalwai. The heard judgment reserved. Interim order subsisting will continue till the disposal of the petition. The state is directed to place on record the entire investigation papers.
My lords,
Yes, madam.
mentioned, my lords, serial number 73. The matter is passed over in the trial course. The urgency is the offence is under section
Yes,
5
Kodi.
read with
Kodi.
73, my lord.
Why is it passed over in the trial court?
My lords, for framing of charges, my lords.
Framing of
offences
charges. CBI.
Offences has already been decriminalized, my lords. Under section 5 read with section 16 of cable television network.
PV9, why?
My lords, the complaint has been detailedly heard, my lords, at Annexure C. The Honorable High Court has passed an order. But however,
Page.
at page 42, my lords. However, liberty was granted for filing of a fresh complaint on the lawful requirements. Page 42, Annexure C.
Liberty is reserved to proceed against the petitioners on the same cause of action.
Please, my lords.
Oh, legal requirements.
The absence of sanction.
Sanction idea. I will
My
see.
lords, that offences has been decriminalized.
We'll
That
hear
has been
it. We'll ask the court, to defer framing of charges. That's all the order now can be passed. Ready, next time be ready.
Milords, actually, in fact, Milords, on the interim prayer, it was heard before coordinate bench.
So what? Yes. Parted ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ.
Defer, Milords, I may not say anything.
Defer ಅಷ್ಟೇ. I am not saying stay of proceedings.
I may not say much.
My lords, but as far as the
All
offence is
right.
concerned,
For today, charge is not framed. It is fine. We'll hear it. He will hear you on the 5th and close this. All right.
stay may be granted in the proceedings.
Not proceeding stay ಮಾಡಿದ್ರೆ then it gets worse. I'll say the court will not frame charges till the next date.
Please, my lords.
Heard the learned counsel appearing for the petitioner. The learned counsel submits that the court has adjourned the matter to the end of the day to frame charges against the petitioner. The learned counsel submits that there are various submissions to be made which would touch upon the frivolousness or malefides in registering the crime. Therefore, the concerned court shall defer framing of charges till the next date. List the matter on 5th for admission.
He is for exemption of the personal appearance before the court also.
ಡೆಫರ್ ಮಾಡಿದ್ದೀನಿ ಮತ್ತೇನು ಡೆಫರ್ ಮಾಡಿದ್ಮೇಲೆ ಯಾಕೆ ಕರೀತಾರೆ?
Please.
Yes.
A date may be fixed, my lord.
5th is a date, right?
Much obliged.
Serial number 78, same respondent, same request. Tomorrow matter is posted for framing of charge, my lord. I'm
70?
accused 78, my lord.
Offense?
IMA, my lord. After the IMA.
No, sir.
My lord, it's an
That I
matter
will
it
not.
has been heard. My lord, may I just make, tomorrow is the framing of charge, my lord. NBWs are being
ಒಂದು ಯಾವ್ದೋ
issued.
ಡಿಸ್ಚಾರ್ಜ್ ಮಾಡಿದೆ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಇಂದ ವಾಪಸ್ ಬಂತಲ್ಲ ಅದು ವಾಟ್ ಇಸ್ ದಟ್?
ಇಲ್ಲ ಅದೆಲ್ಲ ಕನೆಕ್ಟ್ ಆಗಿ ಎಲ್ಲದು ಕನೆಕ್ಟ್ ಮಾಡಿಸಿ ಇಟ್ಟಿದ್ದಾರೆ ಅಷ್ಟೇ. ನಥಿಂಗ್ ಎಲ್ಸ್ ಹ್ಯಾಸ್ ಹ್ಯಾಪೆಂಡ್. My lord, accused number 1 in this, my lord, has been.
ಎಂಟ್ರಿ ಮಾಡಿದೆ?
ಇಲ್ಲ. My lord, I have the order sheet, my lord. I'll produce it, my lord. Exemption ಅಂತ it's posted for framing.
Exemption.
My lord, it's posted. NBW is issued
IMA
against.
ಅಷ್ಟೇ ಮಾಡಲ್ಲ.
My lord,
ಅದೇನೋ
I'm not seeking for stay, my lord. Only tomorrow if they don't frame the charge, I have the order sheet. NBW is issued against me, my lord, for non-appearance.
Why did you not appear?
My lord, I was exempted. I filed an application.
Here it is exempted ಅಲ್ಲ?
Yes, my lord.
This court, the coordinate bench of this court had exempted the petitioner from appearance before the concerned court. Therefore, the concerned court, the petitioner has not appeared, notwithstanding the same. It transpires that a non-bailable warrant is issued against the petitioner. Therefore, the said warrant shall remain stayed.
That matter is posted for, I have sought for recalling.
see, you
Tomorrow
see-
is the charge.
I'll take it on 23rd ಅಲ್ವಾ? I'll take it on 3rd February.
Very well.
Yes.
In
ಅಲ್ಲಿ
order.
ಏನ್ ರಿಕ್ವೆಸ್ಟ್ ಮಾಡ್ಕೋಬೇಕು ಮಾಡಿ. Yes, correct.
Fresh matters.
2:30 ಆಯ್ತಲ್ಲ ಎಲ್ಲ? ಇನ್ಯಾವ್ದಿದೆ? ಯಾವ್ದು? ನೈಜೀರಿಯಾನ?
My lord, serial 80, the interim order was extended, but the order shows it was vacated, my lord, on the previous, please.
Kalburgi matter is there.
Serial
number 74, my lord. 230 Kalburgi.
Madam, date ಕೊಡ್ತೀರಾ?
ಧಾರವಾಡ ಕಲಬುರ್ಗಿ ಮ್ಯಾಟರ್ 30th ಸರ್.
ಯಾವತ್ತು ಮೇಡಮ್?
30th.
ಮೇಡಮ್ ಲಿಸ್ಟ್ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಏನಾಯ್ತದೆ?
ಧಾರವಾಡ ಕಲಬುರ್ಗಿ ಮ್ಯಾಟರ್ಸ್ 30th.
ಮೇಡಮ್ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್.
Second list after 2 weeks.
ಮೇಡಮ್ ಡೇಟ್ ಕೊಡ್ಬೋದು ಸೆಕೆಂಡ್